All after vacation. Move the vacation bench. 2:30, no matter. Move the vacation bench. Friday vacation bench ಇದೆ. ಡಾರ್ಕ್ ಸೆಲ್ ಮ್ಯಾಟ್ರ್ ಏನು ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ? ನೆನ್ನೆದ ಕೊಟ್ಟಿದ್ದೀವ? ಡೇಟ್ ಇದೆಯಂತಲ್ಲ ಬಿಡಿ. ಯು ವಾಂಟ್ ಇಟ್ ಆನ್ 15th. ಹಾ ಸರಿ ಅಷ್ಟೇ. ಡಾರ್ಕ್ ಸೆಲ್ ಇಲ್ವೇ ಇಲ್ಲ, ಬರೀ ಸುಳ್ಳದು. ಅದೆಲ್ಲ ಹೇಳ್ಬೇಕಾದ್ರೆ ನೀವ್ ಇರ್ಬೇಕಿಲ್ಲಿ. ಆಯ್ತು, ಅದೊಂದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಒಂದ್ ನಿಮಿಷ, ಬೇರೆ ಏನೇ 2:30ಗೆ ಯಾವುದು ಬೇಡ. ಅದು ಕೊಡಿ, ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್ ಕೊಡಿ, ಇದು ಕೊಡಿ. ಬಿತ್ ಬೇರೆ ಸಾಗರ್, ಮೋದಿ ವೆಕೇಶನ್ ಬೆಂಚ್. ಮೋದಿ ವೆಕೇಶನ್ ಬೆಂಚ್ ಯಾವ್ದು? ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್. Move the vacation bench. When was it rejected, sir? When was the application rejected? When was the application rejected? Leave it. Yes. Move the vacation bench. Move the vacation bench, sir. No. No, sir. It's all right. No problem, sir. Move the vacation bench. Move the vacation bench. 2:30 I'm not taking, sir. Settlement you give. 2:30 I'm not taking any matter. I am not even sitting at 2:30, please. Yes. No. 2:30 ಯಾವುದು ಕೇಳಬೇಡಿ. ಎಲ್ಲ ಆಫ್ಟರ್ move the vacation bench. Except those grounds of arrest ಇತ್ತಲ್ಲ ನೆನ್ನೆದು ಅದು ಮಾತ್ರ. Move the vacation bench, sir. Move the vacation bench. No, crime register agilla urgency and one. Attavole, Prabir Tavole. No, no, no. Other, move the vacation bench. No, sir, I am not. Move the vacation bench. Then arrest ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಹಾ. ಯಾರು which police sir? Why sir? ಹಾ. ಹಾ. ಅದು ಬಿಡಿ ಆಮೇಲೆ. ಹಾ. Who are you?
239.
I am not going to interfere, sir. You want, you seek bail. There is no crime registered. There is nothing. What 482 are you filing here? Yes. I cannot believe whatever you say straight away, unless there is something on record. Not the petition. There should be something on record. It's a could you not? Give it. See, this is the problem. I'll have to take every case then. Anticipated visit. Move on the 14th. Move on the 14th. Today for 14th, please don't move memos. Move on the 14th. Yes. No problem. Move the vacation bench. Move the vacation bench. Yes.
Serial
Move the
number.
vacation bench, sir. Avinash, memo ತಗೊಳ್ಳೋದಿಲ್ಲ. Move the vacation bench. Yes. ಏನು urgency ಇರಲ್ಲ. ಎಷ್ಟು ವರ್ಷದಿಂದ not able to practice, sir? ಎಷ್ಟು ವರ್ಷದಿಂದ? Last 3 days. ಬರಲ್ಲ. Move the vacation bench.
Serial number
Move
1.
the vacation bench, sir. Friday is the vacation bench. Yes. ನೀವು ಅಷ್ಟೇ. Move the vacation bench. ಅದು ತಗೊಳ್ಳಿ. ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್ ಅದು ತಗೊಳ್ಳಿ. ನೆನ್ನೆ ಇತ್ತದು ಮ್ಯಾಟ್ರ್. ನೆನ್ನೆ ಇತ್ತಲ್ವಾ ಅದು? ನೆನ್ನೆ ಇತ್ತು, ಹಾಕ್ಸಿ ಅದು.
Serial number
ನೆನ್ನೆ
1.
ಇದ್ದಿದ್ದು ಪಾಸ್ ಓವರ್ ಆಗಿದ್ದು ತಗೊಂಡಿಲ್ವಲ್ಲ ಅದಕ್ಕೆ.
Serial number 130, my lord.
Adjournment only when it is called.
Filing memo for withdrawal, my
Where
lord.
is the memo?
It has already been given.
All right, leave it.
Much.
Serial number 117, your lordship. 230 matter, lordship.
No, come after vacation.
My lord, may I make small submission, my lord?
Yes.
Serial number 110, my lords. Permit to withdraw, my lords.
ಆಯ್ತು. 130 and 110. 132 ನಾ ಯಾವ್ದು ಹೇಳಿದ್ ಮೇಡಮ್ ಅವರು? ಆಯ್ತು, ಹಾಕಿದ್ರೆ ಹಾಕಿ.
Serial number 117, your lordship.
Obliged, my lords.
Withdrawn.
Serial number
117 withdraw ಅಲ್ಲ?
Please, withdrawal, my lord. I'm the petitioner.
Call the cases.
After they had compromised, but in view of the fact that 376 is there, your lordship hesitated, I mean rather held that it can't be done. Now, what we are
ಎಷ್ಟು
doing,
ವರ್ಷ ರಿಲೇಶನ್ಶಿಪ್?
your lordship will see the complaint is on page 15. And as per the allegations, the so-called relationship took place sometime in 2023, and the complaint is tendered in the year
ನೀವು
24.
ಇಂಟರ್ ಮಾಡರ್ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ?
Yeah, only it was arrest, but the parties have since.
No. List on ಒಂದೇ ವರ್ಷದ ರಿಲೇಶನ್ಶಿಪ್ ಇದು. List on 15th.
3 years.
15th in the fresh matters list, inter matter subsisting shall continue to the next date of hearing.
17th or 18th.
17th, Raja sir. We'll
18th.
take it on 22nd then.
Please.
22nd in the fresh matters list. Next. Yes, Sirajuddin, what is this?
This, my lords, abuse in process of the investigation.
Abuse in process of investigation.
The investigation officer
Yes.
has falsely implicated me when I have cooperated with the investigation, my lords.
Okay, Michael.
The person who's collected the credit card and debit card details of various people, handed over to accused number 1. And accused number 1 obtaining a swiping machine from the bank has siphoned off this money. Transaction is in about 1 plus crores. And he's obtained bail, my lord. After that, we have issued various notices to him. He's not cooperated with any even single notice so far. In fact,
Appear
now we are
before the
My lords,
investigating
my lords,
officers.
for a cancellation
My lords,
of
what has
bail.
happened, my lords, at the time of investigation,
I'm not going to stay this.
my lords, kindly listen, my lords.
Hmm.
Place this
When-
notice issued to my.
I cooperated with the investigation. The investigation officer asked me to give the whereabouts of the accused number 6, my lords. I have been arraigned as accused number 5. They took me to identify accused number 6 to Goa. Then I booked my tickets in flight and everything. I booked the rooms for them also. And thereafter, from 17 to 20, I was in with them, cooperating with the investigation. Just that they asked me to identify, my lords.
Minute.
Thereafter, my lords,
Where
my
are
lords,
the investigation papers?
Yes.
Kodil.
In fact, your lordship,
They-
various notices issued to him.
my lords. Thereafter, my lords,
Where are you in Doha?
no, my lords.
ಮತ್ತೆ ಎಲ್ಲಿದ್ದೀರಾ?
I am in Dubai, my lords, now.
Then cooperate.
My lords, kindly listen, my lords. At the time of investigation,
Kindly listen ಅನ್ಬೇಡಿ.
sorry,
I will
my
not
lords.
listen.
My lords, I am sorry.
Yes. Hmm.
My lords. On March 2023, I have been produced before the magistrate, my lords, and I was taken into custody. During this investigation period, during the custody, in 3 days, they asked me to give 5 lakh rupees. I pledged my gold ornaments and gave 5 lakh rupees to them, 2 lakh rupees cash and 3 lakh rupees they asked me to deposit in my account. At that time, 3 lakh rupees has been seized, my lords, during the investigation. That amount has been shown and I have been shown and accused. There is a record.
What is the hitch in cooperating with the investigation?
My lords, already false case has been implicated against me.
We have recovered the telephone and the computer
First,
from his possession.
You cooperate with the investigation, then I will consider interim order. You can't sit in Dubai and dictate that there is a false case in on you.
Already they have filed a false case, my lords.
ಅರೆ?
This, no,
ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
no, my lords, charge sheet illa, my lords.
Cooperate ಮಾಡಿ investigation. Already they have filed false case. According to you, it is false case.
My lords, kindly, my
Your
lords,
lordship may see the
kindly
FSL
see,
report, my
I
lord.
have submitted the memo with documents, my lords. The pledged the ornaments, gold ornaments, have received the money and on the same day I have deposited the money. Investigation officer is present, let him ask for how,
First, you come and cooperate with the investigation. I will then consider your application for stay. You can't sit in Dubai and dictate terms here. As simple as that. Whether you kindly listen, not listen, avela alvela. You come and cooperate with the investigation. If you're sitting somewhere else, you can't, how have you filed this petition?
I have filed on 37, my lords.
Awag he was here, is it?
Yes, my lords.
Huh? When did you go back?
No, my lords, I was not here, my lords.
Then how did you file this petition?
My lords, I filed this petition.
Where is the affidavit?
Affidavit I obtained from email, my lords.
Where is the ವಕಾಲತ್ ಅಲ್ಲಿ?
Wakalat,
ಕೊಡಿ ಅಲ್ಲಿ ವಕಾಲತ್ ಕೊಡಿ ಇಲ್ಲಿ. ದುಬೈಯಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಇಲ್ಲಿ ಯು ಕಾಂಟ್ ಕೊಡಿ ವಕಾಲತ್ ಕೊಡಿ.
let's, here, my lords.
Where is
Update.
the, wait, I'll see the wakalat affidavit. When did you come to Bangalore?
My lords, I will get instruction.
At Bangalore ಅಂತ ಸೈನ್ ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲಿ?
Yes, my lord.
You get the instruction, get your passport. When did you come to Bangalore?
Yes, my lords.
And if your whose signature is ಅವ್ರದೇನಾ?
Yes,
ಅಲ್ಲಿ
my lord.
ಇದ್ಕೊಂಡು ಇಲ್ಲಿ ಬೆಂಗಳೂರಿನ ಸಿಗ್ನೇಚರ್ ಮಾಡಿದ್ರೆ other proceedings I will initiate. By
Yes,
an
my
order of
lords.
this court. Don't sit in Dubai and try to dictate terms to the investigating officer.
Yes,
here.
my lords.
Come-
I am ready.
Come back.
My lords, I will come back with the instructions, my lord.
Not
What about the
instruction,
false
if you-
case,
if
my
you
lords?
want
What
to
about the
cons-
investigation officer has abused?
Not, first you come back
Yes.
and cooperate with the investigation and tell me how, when were you in Bangalore?
Yes, my lord.
Because you have signed wakalat and affidavit saying you are in Bangalore.
Yes, my lord.
Yes, both
That-
affidavit and wakalat are in Bangalore.
Yes.
Did you come to Bangalore and when did you go back to Dubai?
Yes, my lord. An observation may be made that I will cooperate with the investigation and say afterwards it may be heard, my lords. My
The
stay.
petitioner
Anyway, we are now seeking for cancellation of bail. The FSL report, my lord, speaks
The
about.
end, whatever it is,
Yes.
the petitioner shall cooperate with the investigation. List the matter on 23rd in the fresh matters list. The petitioner shall also place on record as to how he signed the wakalat and the affidavit in Bangalore on 30th July, sitting at Dubai.
Before he departing, my lords, he
No,
going, my lords, I have already.
passport, sir.
Yes, my lords.
That's the
before.
best evidence, yes.
Yes, my
List
lords.
on 23rd in the fresh matters list. Next.
My lords, that observation may be made. If I
Yes,
cooperate with the investigation, then.
ಹೇಳಿದ್ನಲ್ಲ ಅದನ್ನ ಕೋಆಪರೇಟ್.
Yes, my lords.
Serial number 3, I entered my appearance. But sir, the name has not
Sadappa
been
Naik.
shown. Yes,
You are there?
I entered my appearance.
Register
My
to
name-
delete the name of Sadappa Naikar and print the name of Parmeshwar Hegde as appearing for the respondent. 7A, pass over ಮಾಡಿ.
ಇದು ಅದರ್ ಸೈಡಿಗೆ ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
ಒಂದ್ ನಿಮಿಷ ಆತ.
Please,
ಎಲ್ಲ ಮಟ್ಟಿಗೆ ಮಾಡ್ತೀನಿ.
ಆಗು.
In all these cases, you file your synopsis
Please.
and authorities if you are wanting to rely on. I am delinking every case and each case we will take.
Please, please.
Yes, next.
It is
Split,
ಅಲ್ಲ,
Medical termination of pregnancy.
It's not
MTP.
the record, my lord, I got the record. In fact, I personally was not happy with investigation. I've spoken to the SP to change the
We
investigation.
will stay it.
No,
for now.
I've asked the SP to change.
For
the
now, we will stay it, then after vacation, we'll consider it.
Because
We'll- ಈಗೇನ್
person-
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನ್ ಮಾಡಿದೀರಾ?
the person who brought the records was, I'm not sure whether he's competent to conduct investigations. I'm placing the records.
Records ಕೊಡಿ.
In
Yes.
fact, my lord, the first petitioner is a pharmacist in a government hospital, my lord. Second petitioner runs the hospital.
We'll see.
But, Upon
List the
searching the
matter on 14th in the fresh matters list. Till such time, further proceedings shall remain stayed. Only till then, we will see and then vacate on that day if there is anything.
Yes.
Because these heinous offenses, ಮತ್ತೆ ಮಧ್ಯದಲ್ಲಿ ಏನಾದ್ರು ಸಿಗಾಕೊಂಡ್ಬಿಡಿ. Yes, next.
For petitioner in this matter. Petitioner is accused number 3, my lord, the offence under PC Act, my lord. The petitioner is
Pass
Arrow in municipal.
Pass over. Next. ಇದು ಅಷ್ಟೇ ಅಲ್ಲ?
13(1)B, my lord, the faulty report, annexure J, my lord, no check period. All ancestral property is taken into consideration as, my lord, assets of my assets. And my lord, they say, my lord, 134%.
BB Patil. Sorry, notice.
And, my lord, I have filed the assets and liabilities, my lord. Everything, my lord, known source of income, I have filed before the government. Annexure N, pay 218, my lord, will find.
Learned Counsel Shri BB Patil is directed to heard the Learned Senior Counsel MS Bhagwat appearing for the petitioner. Counsel Shri BB Patil is directed to accept notice for the respondent. Copies ಕೊಡಿ. List on vacation ಆದ್ಮೇಲೆ ಒಂದು
My lord, may,
20, list on 26th October.
please.
Yes.
Meanwhile, my lord,
Meanwhile ಏನಿದೆ? ಬೇರೆದ್ರಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಆಗಿದೆ ಅಷ್ಟೇ.
stay of,
ಬೇರೆದ್ರಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇನೆ. Nothing.
Not to file charge sheet without
That's
the leave
all.
of the court.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ ಇದರಲ್ಲಿ?
ಇಲ್ಲ.
Not to file charge sheet ಅಷ್ಟೇ.
Investigation is permitted.
ಜೈ ಬೇರೆದ್ರಲ್ಲೆಲ್ಲ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದೆ. 7A ಕೇಳ್ಕೊಳ್ಳಿ, ಚೇಂಬರ್ಲಿ ಕೇಳ್ಕೊಂಡು ಏನು ಆರ್ಡರ್ ಮಾಡಿ.
7A ಇವತ್ತಿದೆ.
ಅದು ಗೊತ್ತು, ಎರಡರಲ್ಲೂ ಒಂದು ಪರ್ಟಿಕ್ಯುಲರ್ ಆರ್ಡರ್ಸ್ ಮಾಡಿದ್ವಿ.
Yes,
Please, deeply
ಅಲ್ಲ,
obliged.
what happens, my lord, ಖಂಡಿಸಿ the,
Nothing happens, sir.
ಅಲ್ಲ, check
Yes.
period ಇಲ್ಲ.
Nothing happens till the next date. Yes.
Obligation.
ಏನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತಾರೆ, ಮಾಡ್ಲಿ ಬಿಡಿ.
But I will be kept under suspense for no reason, my lord. My lord knows.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡ್ಬಾರ್ದು ಹೇಳಿ.
13B, ಇಲ್ಲ, ಬೇಕಾಗಿಲ್ಲ ಅವರಿಗೆ. ಒಂದು ರಿಪೋರ್ಟ್ ಕಳಿಸ್ತಾರೆ. My lord knows how the order is passed.
Yes.
They will send report 34%.
ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಚಾಲೆಂಜ್ ಮಾಡಿ.
Obligation.
ಸರ್ವಿಸ್ ಕೋರ್ಟ್. ನೆಕ್ಸ್ಟ್.
I appear for this. This is a case where, my lord, civil dispute turned into a, my lord, criminal law.
ಇದು PC Act ಅಲ್ವಾ?
ಅಲ್ಲ,
ಇದು
it's a civil dispute.
ಮಗ is involved in.
ಎಸ್ ಸರ್.
ಸಬ್ಜೆಕ್ಟ್ ನಂಬರ್ ಪರ್ಚೇಸ್ ಮಾಡಬಾರ್ದು, ಮಾಡಲೇಬಾರ್ದು ಅಂತ.
ಅದೇ ಪ್ರಾಪರ್ಟಿ ಯಾಕೆ ಪರ್ಚೇಸ್ ಮಾಡ್ಬೇಕಾಗಿ? ಅದೇ ಪ್ರಾಪರ್ಟಿ ಯಾಕೆ ಪರ್ಚೇಸ್?
Not that, not the ಖಂಡಿಸಿ the, how, in this case, sale deed is executed.
ಭಾಗವತ್ ಸರ್,
ಹಾ.
ಅವತ್ತು ಅಷ್ಟೊತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದೇನೆ.
ಹೌದು.
ನಾಟ್ ಕನ್ವಿನ್ಸ್.
ನಾವು ಬೇಲ್ ಹೋಗಿ ಅಂದ್ರೆ
ಬೇಲ್ ತಗೊಂಡ್ರಾ?
SPP ಅವರು ಟೈಮ್ ಕೇಳಿದ್ರು ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ. ಖಂಡಿ ಅಪ್ರಿಷಿಯೇಟ್ ದಿಸ್, ಖಂಡಿಸಿ ದಿ
This is not a case where I can interfere at this stage.
ತಾವು
at all.
ಎಲಿಗೇಷನ್ ಎನೆಕ್ಷರ್ ಬಿ ಎಲಿಗೇಷನ್ ಇದೆಯಾ ನೋಡಿ ಒಂದೇ ನಿಮಿಷ
ಆಯ್ತು.
420 ಏನಾದ್ರು ಡಿಗ್ರಿ ಅಟ್ರಾಕ್ಟ್ ಆಗುತ್ತೆ ನೋಡಿ ಖಂಡಿಸಿ
ಹಾ.
ಪೇಜ್ 48
ಹಾ.
ಕಂಪ್ಲೇಂಟ್
Yes.
ದ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೇಲೆ ತಿಳಿಸಿದ ಚೌರಪ್ಪ ಮಾರ್ಟಿನ್ ಅವರಿಬ್ಬರ ಮಕ್ಕಳಾದ ಫ್ರಾನ್ಸಿಸ್ ಜೊರಾಲ್ಡ್ ಟೈಪ್ ಕಾಪಿ ಓದ್ತಾ ಇದ್ದೇನೆ. ತೀರಿಕೊಂಡಿದ್ದ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ ಉಳಿದ ನನ್ನ 3 ಗುಂಟೆ 3.25 ಗುಂಟೆ ಜಾಗ ಹಾಗೂ ಸರೋಜವನ್ನು ಸೇರಿದ 3800 ಅಡಿ ಜಾಗದ ಮೇಲೆ ಮಾರ್ಟಿನ್ ಮಗ ಜೋಸೆಫ್ ಕುಮಾರ್, ಆತನ ಹೆಂಡತಿ ಸಗಾಯಿ ಮೇರಿ ಮಕ್ಕಳಾದ ದಿವ್ಯಾ, ಪ್ರಿಯಾ, ಪ್ರದೀಪ್ ಮತ್ತು ಜೋಸೆಫ್ ಕುಮಾರ್ ಅಣ್ಣನ ಹೆಂಡತಿಯಾದ ಪುಸ್ತಾ ಮೇರಿ ಲೇಟ್ಸ್ ಫ್ರಾನ್ಸಿಸ್, ಮಕ್ಕಳಾದ ಆನಂದ್ ಪ್ರಸಾದ್, ಅನಿತಾ ಜೋಶಿ ಹಾಗೂ ಜೋಸೆಫ್ ಕುಮಾರ್, ಮತ್ತೊಬ್ಬ ಅಣ್ಣನ ದಿವಂಗತ ಜೊರಾಲ್ಡ್ ಪತ್ನಿಯ ಶ್ರೀಮತಿ ಶಾಂತಿ, ಮಕ್ಕಳಾದ ಕಿಶೋರ್ ಮತ್ತು ಚೈತ್ರರ ಕಣ್ಣು ಬಿದ್ದು ಅವರ ಜೊತೆಯಲ್ಲಿ ನಮಗೆ ತಿಳಿದಂತೆ ಬಂದಿರುವಂತಹ ಗಂಗಾನಗರ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಕಚೇರಿಯಲ್ಲಿ ಪಾರ್ಟ್ ಟೈಮ್ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಜೆ ಕಾರ್ತಿಕ್, ಸುಕೃತ್ ಆಯುಷ್ ಮತ್ತು ವಿನೋದ್ ಕುಮಾರ್ ವಿ ಅವರು ಸೇರಿಕೊಂಡು ನಮಗೆ ಮೋಸ ಮಾಡುವ ಸಮಾನ ಉದ್ದೇಶದಿಂದ ಸುಳ್ಳು ದಾಖಲೆಯನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು 28/7/23 ಗಂಗಾನಗರ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡುವ ಅದರಲ್ಲಿ ಪ್ರಸ್ತುತದಲ್ಲಿ ಇಲ್ಲದ 50 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಜಾಗವನ್ನು ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಳ್ಳುವ ನೆಪದಲ್ಲಿ ದಾಸರಳ್ಳಿ ಸರ್ವೆ ನಂಬರ್ 28/2 ನನಗೆ ಮತ್ತು ಸರೋಜವನ್ನು ಸೇರಿದ ಸೋ ಜಾಗ 421.9 ಸ್ಕ್ವೇರ್ ಮೀಟರ್ ಜಾಗವನ್ನು ಸೇರಿಸಿಕೊಂಡು ಈ ಮೇಲ್ಕಂಡ ಚೌರಪ್ಪನ ಮೊಮ್ಮಗ ಹಾಗೂ ದಿವಂಗತ ಮಕ್ಕಳು ಹೆಂಡತಿಯವರು ಮಕ್ಕಳು ಸೇರಿಕೊಂಡು ಜೆ ಕಾರ್ತಿಕ್, ಸುಕೃತ್ ಆಯುಷ್, ವಿನೋದ್ ಕುಮಾರ್ ಅವರಿಗೆ ಕ್ರಯ ಪತ್ರ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. That is for 420, 470 attracts me not. Condition the sale deed not. Which I have produced. That is annexure A.
Yes, sir.
But I have purchased the property. These 2 persons have purchased the property. Joseph Kumar. Joseph is son of Martin. According to them, Lord, they have purchased 92. Brother of Joseph. There is a clear dispute, blood, civil dispute. But allegation is no allegation against me. Only the blood vendors, according to them, they have told me they have created document according to them. But kindly see, they want to turn into criminal case,
Yes,
not.
sir.
My lord, this is firstly the petition itself is not maintainable. My lord. My lord, they have sought for prayer. There 13 accused persons are there, my lord. My lord, they have not restrict their prayer in respect of
ಅದು
petition.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಅದು ಆಡ್ ಮಾಡಿಸೋಣ. ಅದಕ್ಕೂ ಮೇಂಟೈನಬಿಲಿಟಿಗೂ
ಆಯ್ತು.
ಸಂಬಂಧ ಇಲ್ಲ ಆಮೇಲೆ.
My lord, this is a suit property bearing survey number 28/2. Originally purchased by one Chaurappa in the year 1954, my lord. Then, my lord, in the year 1972, Chaurappa entered into the partition with the one Martin, who is the son of Chaurappa, my lord, in the year 1972. Then, my lord, the Martin and Chaurappa and Martin's 3 sons all are executed the sale deed in favor of me in the year 1992, my lord. My lord, then again, all 26 guntas have executed 3 sale deeds in the year 1992 itself in favor of 3 purchasers in the year 1992, my lord. My lord, the entire property stands in the name of respondent number 2 and other owners, except my property, my lord. All other properties are farmed sites and developed the property, except my property is a vacant property, my lord.
ಎಷ್ಟು ಗುಂಟೆ ಅದು?
3/4 ಗುಂಟಾ, my lord.
3.25 ಗುಂಟೆ.
3.25 ಗುಂಟೆ. 3.25 ಗುಂಟೆ ಒಂದು ಪ್ರಾಪರ್ಟಿ, ಇನ್ನೊಂದು ಅಪ್ಲಿಯೇಟೆಡ್ ನಂಬರ್ 2 3,800 square feet, my lord.
ಆಯ್ತು.
Both the properties have entered into the sale deed in the year 2003, my lord. My lord, in the year 2003, there is no kata stands in the name of the petitioners. Then, my lord, the original owners have also not stands any kata and other records. They have created the kata in the year 2003 and they have entered.
ಒರಿಜಿನಲ್ ಓನರ್ ಅಂದ್ರೆ ನೀವಾ?
Original owner, the accused number 1, my lord.
ಅಲ್ಲ ಒರಿಜಿನಲ್ ನೀವ್ಯಾರು? ಹೂ ಆರ್ ಯು ದೆನ್?
I have purchased the property in the
When
year
did you purchase it?
1992. 32 years I am in
Since
possession.
92 you are in possession.
I am in possession. All the records stands in my name. All of a suddenly in the year 2023, my lord, they have created the documents and entered into the second transaction, and all the records, my lord, kata and other records all are created by the petitioners, my lord. My lord, kindly see, I have produced the document at in page number 39, my lord, my documents, my lord.
You produced.
I have produced.
But
my lord.
deliberately he don't produce power of attorney, which shows, my lord,
It
that
is,
is
sir.
One minute.
1 minute, it is. This is a encumbrance certificate, page number 39, my lord. Page number 39, I have produced that.
ಎಲ್ಲ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿದೆಯಾ?
ನನ್ನ ಹೆಸರಲ್ಲಿ ಚೌರಪ್ಪ ಮಾಲೀಕ ಜ್ಞಾನೇಶ್ವರ I have K Nagara, second one, my lord. Second one, I have my name is shown in the second one. First one is Ganeshwara Subaraya Bhatta. He is purchased
ಎಲ್ಲಿವರೆಗಿದು? 2004.
2004. Next document I have produced, my lord. Next page number 40, kindly see the page number 40. This is a page number 40, pertains to from 1/1/2003 to
3/7/24.
2024, my lord. My lord, these documents are very clear, my lord. Then again, my lord, in page number 42, my lord,
ಸೇಲ್ ಡೀಡ್ ಯಾವಾಗ ಆಗಿರೋದು?
sold it in the year 2023. Avardu.
ಎಲ್ಲಿದೆ?
28/7.
ವೇರ್ ಇಸ್ ದಟ್?
Their document at ink page number 22, my lord. 22, my lord. 22, my lord. Ink page number 22, their document. This is registered, actually, this is the area comes within the Shivaji-Nagara sub-register jurisdiction. This is registered in Ganga-Nagara sub-register. That property, one property is created. That property is not at all existence. The sub-register is working at Ganga-Nagara, who is the petition number 2 father, my lord. My lord, he is only sub-register. Even Azan today, he is the sub-register. He is participated in the registration proceedings. And petition number 1 is the cousin brother of the sub-inspector, who is working at Amrutali police station as on the date of incident, my lord.
Yes, sir. Anything else?
But it is incorrect to say, my lord, they are relatives, my lord. That,
It's all right. It's a matter of evidence.
yes, my lord.
Investigation.
Yes, my lord.
Fine, everybody.
But question is, no, my lord, all documents are seized by the police. But whatever,
You want me to give a finding? I'll give. Yes.
but can't you see the sale deed produced by him,
Hmm.
my lord will find
Hmm.
the sale deed according to them. That is not 27/8/1992.
Hmm.
No power of attorney is produced.
Sorry?
No power of attorney according to the.
Why are you worried? He's in possession for the last 32 years.
There is no.
Tell me about your purchase, sir.
He is, my lord, Martin family, my lord, one of the vendor is,
Yes, yes.
my lord, Joseph Kumar, son of Martin.
Let the investigation go on. I am not staying this.
My lord, otherwise, my lord, what is the allegation in the complaint? I can understand my allegation is there.
Let the investigation happen, sir. You will get the allegations.
Lord, on the face, according to me, my lord, complaint doesn't dispose either 417, 420 or anything, my lord. Entire allegation is taken into consideration according to them, my lord, vendors have done it.
No problem.
Procedural ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Purchaser is the son of the sub-registrar. Yes.
But there is no allegation on the sub-registrar.
And I asked you, where is your source of income? You are 20 years old. What are you? Second petitioner is 20 years. Oh, how did you purchase the property?
Part time ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೆ.
Part time.
Time ಕೆಲಸ ಮಾಡ್ತಾ. 3% totally purchase ಮಾಡಿ, not one.
ಪರವಾಗಿಲ್ಲ. ಅದು ಒಂದು
ನೋಡಿ ಅಲ್ಲಿ
son of a police officer, ಇನ್ನೊಂದು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್, ಮೂರನೇದು ಯಾರು?
ಮೂರನೇದು ಅವರು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಏಜೆಂಟ್ in that locality.
Anyway, you should explain how did this son of the sub registrar at 20 years purchase a prime property in ಎಲ್ಲಿದು?
my lord,
ದಾಸರಳ್ಳಿ, ಹೆಬ್ಬಾಳ್ ದಾಸರಳ್ಳಿ ಮೇಲೆ.
my lord,
Copy board, adjacent to
take
copy board.
instruction.
Ah.
And take instruction and make my submission.
About how he purchased
How?
it.
How income ಕೇಳ್ತಾ ಇದ್ದೆ, ಹಾಗಾಗಿ I did not inquire.
ಕೊಡಿ ಅದು ಸೇರಿಸಿ ಬರೆದು ಬಿಡ್ತೀನಿ. ಎಸ್ ಪಾಸ್ ಅವರಾ? ಪಾಸ್.
There is a daughter, lordship, she is just waiting for the
yeah,
template of her
what?
father.
No, there's already direction. No, I'm not on the petitioner, her father may not being released, may not to attend the.
Who's asking to be released?
But daughter is asking.
Petitioner father,
Father should be released ಅಂತ.
his father should be released.
ಅದೇನಾಗಿದೆ Monday, last minute on 21st August, the father's bail appeal minute has been rejected by the coordinate bench. ನಿನ್ನೆ ಕೊಟ್ಟೆ ನಾನು, ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ಬೇಕು. ನಿನ್ನೆ ಕೊಟ್ಟೆ. Prior to that, but in respect of the bail application of the co-accused which ended up to Supreme Court, Honorable Apex Court not directed the trial court to expedite the trial. But thereafter, this Honorable Court also has noticed the trial must not go on as early as possible. Not
Yes, sir.
There are hardly not another 5 witnesses not pending.
Wait.
The marriage is funny.
How many days you want?
45 days, 2 months I prayed, minimum 45 days, but Supreme Court has already considered.
ಅದು conviction appeal.
Every week we stay near. Every week we may mark an NS. It's not that we are asking some bail or a discharge. We want a certain relief to enable my petitioner's marriage to be happen. Sometimes ask this question to myself. The purpose of agency to try the accused or to put the discharge family. It must be carried out. And if yesterday one order I got in division, after 13 years it was
Acquitted.
If such things happen in this case. In this case, I didn't mention one fact in the case, but my learned friend aware about this fact. If after full-fledged trial, if we get acquittal order, what will be the state of the trial? And this marriage is fixed 1 year, but right, two families not aware about the entirety in the case.
I will permit 1 month.
45 days also.
Let them also not cooperate with the trial. My only concern is
Every day lordship trial is happening.
If non-cooperation emerges, then this order will go. That I will observe.
There's the jail. Therefore, trial will happen.
not why I say this.
ಜೈಲಲ್ಲಿ ಇದ್ದವ್ರು ಟ್ರಯಲ್ ಯಾಕೆ ಬೇಡ ಅಂತ.
Not why I say this. Not on last week. Not after lapse of about 3-4 years, one witness was summoned, recalled. Not for some reason again, the counsel representing the accused says I will not cross-examine. Witness was from Delhi. Not in spite of there being not the Supreme Court directions, if this is not the conduct. Better clarification, but my only request is.
He didn't got the document. But this lordship
Therefore, my only request is not.
All right. We'll permit this with some stringent conditions. And
Let them also not cooperate with the trial.
that I will observe, sir.
Please.
Yes, that I will observe.
Please.
Operative portion will upload and day after tomorrow the order will come. All right, yes.
My only request.
ಇವತ್ತೇ
is
ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಅಪ್ಲೋಡ್ ಮಾಡಿ ಜೈಲ್ ಅಥಾರಿಟೀಸ್ಗೆ ಮೇಲ್ ಕಳಿಸ್ತೀವಿ.
And every week lordship, it is mark attendance in the nearby police station.
All right, we'll see. We'll see. Yes.
Please.
Operative portion ಮಾತ್ರ. Day after tomorrow we'll get the order.
But even the full-fledged order release on 14th also is fine.
To operative portion today I will say.
But I have passed on the order of the Honorable Apex Court as well as the division.
I will follow those and then do
Please.
it. Are disposed.
Number 9.
Baby Patil. One copy kodi. Yes. We'll take it immediately after vacation. So what? Charge sheet, that order will be there. Not to file charge sheet on the order. Same order will calculate.
Please.
Yes. Next. 26th. No, don't worry. Yes. ಏನ್ ತೊಂದ್ರೆ ಆದ್ರೆ ಮೂವ್ ಮಾಡಿ. Yes, government. ಏನಿದು MMDR?
No, my lord.
ಕೊಡಿ. Tag this petition along with so and so. ಇಲ್ಲಿ 104 flag up. Same order. List on 5th, 24 alive. List on 5th November. Some 5th November.
orders, number 11.
7 ಏನ ಬಿ ವಿ ಪಾಟೀಲ್ ಇದಾರಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ?
No, my lords.
We'll
First
take- we'll-
orders will ಬಂದಿರೋ on 5
26th.
Please,
26th October, whatever order is there in every other case,
Please.
same order.
please.
Yes, next. Delete the name of Manmohan PN, office objections overruled. ಆಮೇಲೆ ಅಷ್ಟೇ ನೀವು ಮನಮೋಹನ್ PN, list on 26th October, next. And 26th working day ಅಂದ್ರಲ್ಲ. Yes. 12 in terms of the memo, 13 in terms of the memo, same terms of the memo, 15 same, 7 same.
15,
Special court.
Come up days back.
Ah.
We exhort bail mainly on the grounds of clarity. Allegations is that of cheating, breach of trust and.
Who state?
The special counsel.
ಎಲ್ಲಿದ್ದಾರೆ?
Praveen Gowda, he was that day not keeping well.
Oh, that matter, allergy. Ah, right.
Plus A1 at the crime, A2 at the crime stage itself has been.
It's all right, let him come. Must have been an antihistamine today also, yes. Password.
19,
I will take fresh steps, but.
Lords, this is 17A challenge. It's not
Ah, that's
7A.
not, ಅದಕ್ಕೆ, we'll take it later.
other-
List the
some-
matter on 24th October.
Please.
Interim order subsisting shall continue to the next date of hearing, subject to the condition that the petitioner would would do the needful in the next 1 week. Yes, next.
20,
My lords, they have not served a copy of the petition on me.
ಇದ್ರಲ್ಲ
Ah.
ಸರ್ವ್ ಮಾಡಿ. Counsel for the petitioner seeks, sorry. 25th,
The 24th.
24th special court matters. We'll take it on 29th. Petitioner to serve set of papers upon B.V. Patil forthwith, failing which the interim order interim protection subsisting shall stand automatically vacated. Yes,
21,
list on 29th.
7A.
20? Who? CBI. ಇಲ್ಲೇ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಇದ್ದಾರೆ ನೋಡಿ, ಇಲ್ಲ get him. Password, get Prasanna Kumar.
22,
My lord, 7A, I have to file a counter. It was served very recently, 24 months.
Already filed and no protection. Yes, ಯಾವ್ದ್ರಲ್ಲೂ ಇಲ್ಲ, ಯಾವ್ದ್ರಲ್ಲೂ ಕೊಟ್ಟಿಲ್ಲ. It's all right.
That is besides the point. That is besides the point.
ಅದೇನಾದ್ರು ಬರೆದು ಬಿಟ್ರೆ ಇವ್ರು ಯಾರು accept ಮಾಡಲ್ಲ. They will keep agents to accept. No, I'm not granted stay after charge sheet is filed in any case. Charge sheet file ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ ಮಾಡಬೇಡಿ ಅಷ್ಟೇ. ಮಾಡಿದಾರಲ್ಲ ಇಲ್ಲಿ.
26th.
Ah, yes.
26th. my lord.
List on 26th October, next.
mission 23,
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ. AVIO ಗೊತ್ತಾ ಜೆ ಮರ್ತು ಬಿಟ್ಟಿದ್ದೀರಾ? AVIO ಅಂದ್ರೆ ಮರ್ತು ಬಿಟ್ಟಿದ್ದೀರಾ? ಎಸ್. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದಾರಾ? List after vacation, interim order subsisting shall continue to the next date of hearing. 26th October. ಪ್ರಸನ್ನ ಕುಮಾರ್, ಬರೋ ಟ್ರಾವೆಲ್ ಮಾಡ್ಬೇಕಂತಲ್ಲ, ಅಫಿಡೇವಿಟ್ ಅಲ್ಲಿ ಕೊಡಿ.
ಅದೇನ ಸರ್ವ್ ಮಾಡಿದಾಗ ಹೇಳ್ದೆ ಅಫಿಡವಿಟ್ ಹಾಕಿ ನೀವು ಐಟನರಿ ಕೊಡಿ, ಐ ಥಿಂಕ್ ಅದು ಹೆಸರು ಬಂದಿರಲಿಲ್ಲ ನಂದು, ದಟ್ಸ್ ವೈ ನಾಟ್ ಐ ಥಿಂಕ್ ಐ ಹ್ಯಾವ್ ಮಿಸ್ಡ್.
No problem. Travel schedule. Bangalore, Frankfurt, Abu Dhabi. ಎಲ್ಲಿವರೆಗೆ ಬೇಕು? 26/10 Will permit you till 30th of October. Yes. 11/10, from 11/10 to 30th of October. That should suffice. ಇದು ಟ್ರಾವೆಲ್ ಶೆಡ್ಯೂಲ್ ನೀವೇ ಕೊಟ್ಟಿರೋದಿಲ್ಲ, ಅದರಲ್ಲೇ ನೋಡ್ತಾ ಇರೋದು ನಾನು. ಟೆಂಟೇಟಿವ್ ಟ್ರಾವೆಲ್ ಶೆಡ್ಯೂಲ್. Stuttgart. Is will permit. The petitioner is before this court calling in question registration of a crime. Calling in question a lookout circular so issued against the petitioner, the originator of which is the Central Bureau of Investigation. The petitioner has moved the matter on the score that he is intending to travel on his avocation to confirmed tentative to Germany, and has produced a tentative travel schedule and an affidavit of undertaking that he would return to the shores of this nation, back to the shores of this nation on 12/11/2024. In the light of the LOC hanging on the head of the petitioner, I deem it appropriate to permit the petitioner travel from 11/10/2024 through 15/11/2024 BDI, both days inclusive, so and so. The travel of the petitioner shall be unhindered, notwithstanding the LOC operating against him. The originator shall communicate to the Bureau of Immigration forthwith with regard to the unhindered travel of the petitioner, The affidavit of undertaking of the petitioner reads as follows. The travel schedule, madam, is page 1. Just quote that. So and so. The undertaking is, the affidavit is taken on record. In the event of any breach of the undertaking that the petitioner has submitted through the affidavit would be viewed very seriously and could run the risk of proceedings being initiated under the Passports Act, 1967.
Yes.
Yes.
Can I request order to be uploaded so that I can immediately
It will be.
communicate?
Yes. ಇನ್ನು 11th ಅಲ್ಲ ಹೋಗೋದು, ಟೈಮ್ ಇದೆ. ನಾಳೆ ರೀಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಹಾಂ, ಮತ್ತೆ ಬಿಡಿ. 11:10 ಶುರು ಆಗೋದು, ಕೊಟ್ಟಿರೋದೇ 11:10. Yes. It will be uploaded perhaps tomorrow or day after tomorrow morning.
Please. Yes.
ಅದು ಆರ್ಡರ್ ಐಎ ಇದೆಯಾ ಅದರಲ್ಲಿ? ಐಎ ಅಲ್ವಾ ಅದು? ಐಎ ಅಲ್ಲ, ಅಫಿಡವಿಟ್ ಹಾಕಿಲ್ಲ. ಅದು ಎಂಟ್ರಿ ಮಾಡಿ ಓರಲ್ ಆರ್ಡರ್ ಅಂತ ಆರ್ಡರ್ ಶೀಟ್ ಮಾಡಿ ಇದ್ದೇವೆ. ಎಸ್, ನೆಕ್ಸ್ಟ್. ಇಲ್ವಾ? Counsel P. Prasanna Kumar accepts notice to respondent registry to print the name of Prasanna Kumar and ಮಾಡಿ ಅವತ್ತು. Yes.
7A, my lordship. Charge sheet has been filed.
Filed. List on 26th. ನಿಮಗೆ ನೋಟಿಸ್.
My lordship,
Latif.
Latif sir's name may be shown.
Registry to print the name Prasanna Shetty ಅಂತಿದೆ, ನೀವು ಹಾಕಿದ್ದೀರಾ? Registry to print the name of B. Latif in place of Prasanna Shetty. The second respondent is served, no problem. List on 26th. Parmeshwar. ಅವತ್ತೇ ಹಾಕದ? ನೋಟಿಸ್ ತಗೊಂಡು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? All right, list the matter on 26th October. Counsel to B.B. Patil is directed to accept notice for the respondent, petitioner to serve set of papers upon the aforesaid counsel. ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ, ಅದು ತಗೊಳ್ಳಿ. ಟ್ಯಾಗ್ ದಿ ಪೆಟಿಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಸೋನ್ಸ್. ಎಲ್ಲಿ, ವೇರ್ ಇಸ್ ದ CO? ACO ಎಲ್ಲಿ? ಹಾಂ, ಸರಿ ಕೊಡಿ.
My lords, I need to file counter 7A only.
26. ಆಗಿಲ್ವಾ? ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಸೇಮ್ ಆರ್ಡರ್, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ.
26.
Whatever orders are passed in other cases will. Yes, next. ಇದೇನು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
28, it's a failed trap, my lords.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಫೇಲ್ ಟ್ರ್ಯಾಪ್ ಅವತ್ತೇ ತಗೋಣ.
ಅವತ್ತೇ 26.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ.
Objection ಹಾಕ್ಬೇಕು. I'll file with the compendium of judgment.
Yes. List the matter on 26th. Emergent notice to the second respondent returnable by the 26th. Next. Interim order subsisting shall continue to the next date of hearing.
29.
That's a failed trap.
No, this is
Seven.
not a failed trap according to us, my lords, we'll file a. Irrespective, besides the point,
That's wills.
besides the.
ಇನ್ನೊಬ್ರು accept ಮಾಡ್ಕೊಂಡದ್ದು ಯಾರಿಗೆ ಅಂತ ನೋಡೋಣ. Anyway, charge sheet ಆಗಿಲ್ಲ ಅಲ್ವಾ? Heard the learned senior counsel, so and so, learned counsel B.B. Patil is directed to accept notice for the respondent. Emergent notice to the second respondent ಯಾರು? Somotana. Emergent notice to the second respondent, list on 26th, same order. Identical orders in all the cases, not to file charge sheet,
Without the leave of the.
without the leave of the court.
Number 30.
Pipin sir,
Lords, this is a disproportionate asset case.
ಅದು ಇವತ್ತಿದ್ಯಾ?
ಇವತ್ತಿಲ್ಲ.
ಇವತ್ತು 7A ಮಾತ್ರ.
ಕೌಂಟ್ರು ಹಾಕ್ಬೇಕು ನಾನು ಇದಕ್ಕೆ. ಸರ್ವ್ಡ್ recently 24 ಇದೆ.
All right, ಅದ್ರಲ್ಲೂ ಸೇಮ್ ಆರ್ಡರ್, ಏನ್ ಆರ್ಡರ್ ಇದೆ ಎಲ್ಲದ್ರಲ್ಲೂ ಅದೇ. Learned counsel B.B. Patil seeks 2 weeks time to file statement of objections. Objections, if any, by the next date. We will list this on 29th.
Please.
List on
29th.
29th. Same order, that whatever order is there. 7A ಇದ್ರಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಇದೆ ಅದು. Next.
My counter is ready, 7A again, 26/10.
26th October. Charge sheet ಆಗಿದೆಯಾ? Interim order ಏನು ಕೊಟ್ಟಿದ್ದೀನಿ? Oh, defer, all right, yes. List on 26th. Interim order subsisting shall continue to the next date.
Objection file ಆಗಿದೆ. File ಆಗಿದೆ.
ಇದೇನು?
This is DA, my lords, on 29th it has to be taken.
29th.
Objection is filed.
29th, yes. Interim order ಇದ್ರೆ continue ಮಾಡಿ.
33.
Lords, 33 is served 2 days back.
7A ನಾ?
7A,
26th.
26/10.
Interim order. Cheat sheet is filed ಅಂದ್ರೆ interim order ಇಲ್ಲ. Yes, charges. ಏನ್ ನಿಶ್ಚಯ ಇದು? Last time ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದು? Stand proper. ಮತ್ತೆ ಎಸ್. ಇದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಆಯ್ತು ನೋಡೋಣ. B.B. Patil.
Please, my lords.
Incompetent authority has conducted the investigation is the allegation.
Please, my lords.
ಕಾಪಿ ಕೊಡಿ. ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy is given, my lords. My counter is yet to be filed.
We'll take it on 26th. Yes.
Reporting settlement. 4.
ಆಯ್ತು ಪಾಸ್. ಆಗುತ್ತಾ ಇವತ್ತು ಇಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕೋಣ?
35.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕ್ಬಿಡಿ, ಯಾರಿಲ್ಲ ಅವ್ರು. Offense, Kamar. Where are the respondents? Respondents ಇದ್ದಾರಾ?
Paragraph number K and 4.
Sir. Now, where is the order passed after this? By the civil court?
The past bill and
The heard the learned counsel Amar Korea appearing for the petitioner. The petitioner and the respondent, petitioners and the respondent were in dispute with regard to certain joint development agreement. And we're also before the civil court. Before the civil court, in OS 1512 of 2021, a petition for compromise is filed and is accepted by the concerned court, and which has resulted in closure of the proceedings before the civil court. The conditions stipulated in the terms of compromise, one of the conditions of the terms of compromise is closure of the present proceedings in crime number 106 of 2024. Adena idu? 106 of 2024. The learned counsel submits that after the settlement and receipt of the property to their hands, they are not cooperating with the closure of these proceedings. In the light of the said submission, I deem it appropriate to close these proceedings, recording the settlement. Idu settlement purti pen drive al kodi. Till then, copy won't come out. You can give it to the court officer. Jevai, ಇವರಿಂದ ತಗೊಳ್ಳಿ. So, pen drive al kodi, soft, whatever. Soft copy, how do you give? Adu and e order matra. Recording the compromise, the concerned court has closed the proceedings. Page 33, 34. ಅದನ್ನ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ. 32 ಮ್ಯಾಟರ್ ಅಡ್ವಾನ್ಸ್ಡ್, ಎಸ್. 32 ಇಂದ ಜೆವೈ ಇಲ್ಲದೆ 32 to 34. Right? Yes. You should give it an appendix. Yes. Disposed, quashed. Next.
37.
Here, you can just follow. Matter has got settled, my lordship. Terminal disputes, 498A. In filing compounding applications, my lordship. Both the parties.
You Vakalata. You are already in record?
Yes, ma'am. I filed a wakalat.
All right.
Now I am filing the application, compound the offenses.
ಜೆವೈ 498. ಗೊತ್ತಾ? Chamber. Yes.
Much.
Fine.
Please.
Another side.
ನನ್ನ ಯಾರು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿದ್ರು ಅದಕ್ಕೆ.
Another side.
230 ಹೆಂಗು ಬರ್ಬೇಕಲ್ಲ.
Give it to the other side.
230 ಮೂವ್ ಮಾಡಿದೆ. 2 ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಕರೆದ್ಬಿಟ್ಟು.
Further hearing?
ಎಲ್ಲ ಇದು 13 7 ಇದು.
7 in.
ಎಲ್ಲಿ ಸಂದೇಶ್ ಚೌಟ? Who is arguing?
My lords, this first one is a failed trap. Here, my lords, in all cases, we have made a short synopsis. I just want my lords
No,
to.
what I'll do is I'll dealing these tagged matters.
Please, ma'am.
Each case will separate synopsis.
Please. Illa hakidini, I'll ready ಮಾಡಿದ್ದೀನಿ.
ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ.
Once I'll give it to the
ಕೊಡಿ,
court. My lords may see
Format.
on format. My lords, this is for failed trap. That is why there is some details missing. Name of the accused, whether he's, what is his designation, accused number, demand for, what it is demanded, seized amount,
ಇದು ಬೇಕಾದಷ್ಟು.
page number, demand ಎಲ್ಲಿದೆ, acceptance ಎಲ್ಲಿದೆ, pre-trap.
ಇಷ್ಟಿದ್ರೆ ಸಾಕು. We can do it. No issues.
In all cases, it is
All
ready.
cases you do this.
It's ready.
By the next date we'll do it or we'll hear it today?
Lords could have it on next date. I only say because we'll file it in the registry by that time, all of this.
ಎಲ್ಲ ಫೈಲ್ ಮಾಡ್ಬಿಡಿ.
ಎಲ್ಲ file
Petitioners,
ಮಾಡ್ಬಿಡ್ತೇವೆ.
let all the petitioners file. ಒಂದೊಂದ ಕರೆದ್ಬಿಡಿ ಮಾಡಿ. ಒಂದೊಂದ ಕಾಲ್ ಮಾಡಿ will let.
Please, please.
39.
39, huh? 39.
File a detailed synopsis of ಇದು and the judgments that you're wanting to rely on. We'll take it on 26th of October. Whatever orders is there, it will continue. Yes.
40.
Parmeshwar.
My lords, 40, I would like to show the format to my lords, sir, because that was a failed trap. And
ಇದೇನು?
it's a successful trap according to us. Exoneration is there, but
ಅಲ್ಲ,
nevertheless.
Departmental inquiry exoneration, make it separate.
Please.
ಅದು category separate.
But here, my lords may take a look at the synopsis that we have prepared.
Trap ಅಲ್ಲಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಏನ್
But
ಕಂಡಕ್ಟ್
this
ಮಾಡಿದ್ರು?
is ಒಂದು KT order ಇದೆ ಒಂದು My lords, it has to, the whole concept of Ashu Tiwari has to be revisited, my lords. It is, it's actually a travesty that we are noticing.
Sir, you tell me one thing. Disproportionate assets and trap. Disproportionate assets on 13 whatever ಇದೆ. ಅದರಲ್ಲಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಏನ್ ಕಂಡಕ್ಟ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಅಥವಾ 7A ಅಲ್ಲಿ ಯುವರ್ ಕಾಟ್ ರೆಡ್, ಒಂದ್ ನಿಮಿಷ, 7A ಅಲ್ಲಿ ಯುವರ್ ಕಾಟ್ ರೆಡ್ ಹ್ಯಾಂಡೆಡ್. ಅದರಲ್ಲಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಆಯ್ತು, ಇಸ್ಕೊಂಡೆ, ಆಲ್ ರೈಟ್.
Based on the charge sheet, the Karnataka police and the department inquiry of that. Subsequently, both the parties are exonerated. And against one, I think, they don't find a charge. Only I think one another.
No, this will have to answer.
Please. I leave it. I'm only filing that. I wanted to show the synopsis pattern to my lords. In terms of saying that, we have pointed out in every single case, my lords, where is the demand, what page it is, and in the pre-trap mahazar, where he was concluded, all of that. Now, in as much as, my lords, the issue only is now deflected to another angle altogether in terms of saying that there is an exoneration in another parallel proceedings where the degree of evidence is at a much
See,
lower
these
level.
three categories will make an answer. 7A,
Please.
13 and DA, DE and DE and DA.
DE and
DE
DA
and
and
7A.
7A. DE and DA and 7A.
We'll see.
These synopses are ready in all the
7A
cases.
ದೆಲ್ಲ on 26th will take, you file all the synopsis.
All the synopsis. will-
Hindu Prasanna Kumar. Okay, today ಬೇಡ. Yes. Last day ಯಾಕೆ? Yes. So we'll take it on 26th October. By
Please.
then, all of you file your synopsis
Please,
and authorities in advance,
please, please.
so that it comes to me earlier.
I have prepared one synopsis, but this is the
ನಿಮ್ ಬೇರೆ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆಯಾ?
ನಾವು ಒಂದೇ ಪೇಜ್
I'll place
ಕೊಟ್ಟಿದ್ದೀವಿ,
it.
ಅವರು ಒಂದು 5-6 ಪೇಜ್ ಬರ್ದಿದ್ದಾರೆ.
ಎರಡ್ page ಮುಗಿಸಿದೆ. Gist of the complaint and the trap, where the, how much he has received and who received that was extracted.
See, this is what work pen in the office, 14 documents where work was pending was recovered.
Yes.
This is what you highlight on that. in
Please.
7A.
Please.
Yes. ಎಲ್ಲ ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಅವರು ಕೊಟ್ಬಿಡಿ, ಎಕ್ಸ್ಚೇಂಜ್ ದಿ ಕಾಪೀಸ್, ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ 26th.
Please.
What orders are there? They'll continue all the matters.
49.33 million, we have already filed synopsis.
ಎಲ್ಲಿ ಹಾಕಿದಿರಾ ಅಲ್ಲಿ ಇರ್ಲಿ, ತೊಂದರೆ ಇಲ್ಲ. ಎಲ್ಲಿ ಹಾಕಿಲ್ಲ ಅದು ಮಾತ್ರ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಒಳಗೆ ಹಾಕ್ಬಿಡಿ. ವಾಟ್ ಎವರ್ ಪ್ರೊಟೆಕ್ಟಿವ್ ಆರ್ಡರ್ಸ್ ಆರ್ ಗ್ರಾಂಟೆಡ್ ಇನ್ ಆಲ್ ದೀಸ್ ಕೇಸಸ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ.
Please.
I'll call that.
We have filed counters.
I am on 49 still. 49 connected cases. ಅದನ್ನ
41, my lords.
41.
41, my lords are at 41.
41, yes, 42 ತಗೊಳ್ಳಿ.
41, my lords, our name may be deleted.
40?
41 ನಲ್ಲಿ,
ಹಾ.
my name has to be deleted. My friend has filed power.
ಯಾರು? Latif. Registry to delete the name of ಇದು 41 JY. Registry to delete the name of BB Patil as appearing for the first respondent, BB Patil and Prasanna Shetty for the first respondent, and retain the name of Latif. ಇದು same 7A ಅಲ್ವಾ?
Please.
26th. 41 ಹೇಳಿದ್ದೀಗ.
42, my lords, counter is ready, we'll file.
ಫೈಲ್ ಮಾಡ್ಲಿ. ಲಿಸ್ಟ್ ಆನ್ 7A ನಾ?
7A, 7A.
26th, yes.
Lords, all of them till 100 or 7A.
Then all on 26th.
For 1 or 2 where DA is.
All on 26th. ಅದು ಒಂದೊಂದಾಗ ಕರೆದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. Wait, yes.
Please.
42 ಆಯ್ತು, 43,
7A, my lords.
same.
7A.
Common order. One ನಿಮಿಷ ಮೇಡಮ್. Common order that petitioner and the respondent shall file their short synopsis and the list of authorities they are wanting to place reliance upon ಅಂತ ಮಾಡಿ interim order earlier granted stands sectioned to the next date of hearing. Yes. ಮೇಡಮ್ ಯಾವ ಫೈಲು ಕರೆಯಲ್ಲ, ಯಾವ ಫೈಲು ತಗೊಳಲ್ಲ. Yes. Next.
46.
46.
46.
My name has to be deleted. My friend.
Registry to delete the name of BB Patil and retain the name of Latif.
But in that case, the charge sheet is filed, discharge application was rejected.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿರೋದ್ರಲ್ಲಿ ನಾನು ಏನು ಎಂಟ್ರಿ ಮಾಡರ್ ಕೊಟ್ಟಿಲ್ಲ.
Please.
Yes. Balraj,
47, 7A, my lord. 7A.
26th, yes.
48 copy was not served. Copy, sir.
Anil Kumar. Petitioner to serve set of papers upon counsel Shri B. Latif. Same order, synopsis. So on.
My lords, 49, all of them,
Huh? Wherever charge sheet is not filed, I have granted
Lord.
protective orders that will continue.
all of them count as a file.
26th. Yes. Allah, 49, 49, 49, 1.12 so and so, dealing money, seriatim, dealing these matters.
Please.
Allah, detag these matters and post them in seriatim. Anta order ಮಾಡಿ. ಮಾಡಿ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಏನೇನು ಆರ್ಡರ್ ಇದೆ ಸಪ್ರೇಟ್ ಮಾಡಿ.
ನಿಮ್ ಜೊತೆ ಇದ್ರೆ safe ಅಂತ.
ಹಿಂಗೆ ಇರ್ಲಿ ಅಂತೀರಾ? ಆಯ್ತು, ಹೀಗೆ ಇರ್ಲಿ ಬಿಡಿ. ಹೀಗೆ ಇರ್ಲಿ.
ಸುಮ್ನೆ ನಮ್ಮ ತಲೆ ತಿನ್ಕೆ
40? ಹಾ. ಹಾ. ಇಂಟ್ರಿಮ್ ಪ್ರೊಟೆಕ್ಷನ್ ಇಲ್ವಾ? ಸಾಕು, ತೊಂದ್ರೆ ಇಲ್ಲ, ಅವತ್ ನೋಡು. ಪರವಾಗಿಲ್ಲ. It won't become a failed case, don't worry. Just because it is with someone, some other case, it won't become a failed case. You're all right. Next, yes.
57, my lords. 7, my lords.
Up to 100, ಎಲ್ಲ 7.
No, my lords, 53 is DA.
53?
Is DA.
55 is 13, my lord.
ಅಲ್ಲ, 53 on
53 is
29.
DA.
ಒಂದು ನಿಮಿಷ. ಹಾ.
55 also, I'll mention it. I'll come. When it comes, I'll tell.
53,
53 is
29th.
DA. 29.
29th.
29.
29th, yes.
54 is 7, my lords. 55 is DA. 29th.
55, Somana.
It's a DA, my lords.
29th, yes.
ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ, file ಇಲ್ಲ.
My lords, 56, there is, file is not served on us.
First time ಬರ್ತಾರೆ. Zamir. Huh?
File has to be served.
ಆಯ್ತು. Petitioner to serve set of papers upon counsel Shri B. B. Patil. ಕಾವ್ಯ, ಪ್ರೊಟೆಕ್ಟಿವ್ ಆರ್ಡರ್ಸ್ ಏನೇನಿದೆ ಎಲ್ಲದ್ರಲ್ಲೂ, ಎಸ್. ಸೇಮ್ ಎಲ್ಲದ್ರಲ್ಲೂ.
ಯಾವ್ದ್ರಿ 7 ಏನ DA ನ ಇದು?
ಎಸ್.
Yes, sir, ಇದೆ.
Lords, 57 is DA.
DA 20, 29,
sorry.
same orders.
Apologies, my lords. 7A, 7A, 7. 57,
7 ಅಂದ್ರೆ 26th.
26.
ಎಲ್ಲ 26th. Yes.
ನಮ್ದು ಇಲ್ವೇ ಇಲ್ಲ.
58.
ನಮ್ದಲ್ಲ.
I have granted interim orders in all the cases and posted it to 26th.
My lords, 58,
Cash sheet file ಆದ್ರೆ ಏನು ಮಾಡಲ್ಲ.
58 notice ಮಾಡು.
ಮೈಕ್ ತಗೊಳ್ಳಿ.
The lower court in this. is
ಅದೇ
posted
ಯಾರಿಗೂ
for-
ಕೊಟ್ಟಿಲ್ಲ, ವೇಟ್.
My
ಚಾರ್ಜ್
lords,
ಫ್ರೇಮ್ ಆಗ್ತಾ ಇದೆಯಾ?
ಹೌದು ಸರ್, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ, ಎಪಿಡಿಟಿಗೆ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಫ್ರೇಮ್ ಆಗೋಗಿದೆ.
ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ಆಫ್ ದಿಸ್ ಪಿಟಿಷನ್.
After filing the petition,
ಹೌದು ಸರ್.
ಅಲ್ಲಿ the concerned court shall defer its ಯಾವ್ದು serial number?
Serial number 57.
Concerned court shall defer its proceedings till the next date of hearing. 50, that is
26.
26th October.
Please.
Next.
Much obliged.
My lords, 58 notice has to be issued. No one has got notice yet.
Learned counsel Shri B. B. Patil is directed to accept notice for the respondent petitioner to serve set of papers upon the said counsel. Less 7A na?
Please,
26th, yes,
59.
Lordship same.
7A.
same. ಇದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ, ಆಗಿದೆ.
Same, heard the learned senior counsel.
60 is DA, my lords.
Yes. 60?
DA,
In
DA.
serial number 60, no interim protection has been granted till now.
If it's not, the charge
Charge
sheet
sheet is
ಆಗಿದ್ರೆ
not
ಏನ್
filed.
ಮಾಡ-
Charge sheet file
ಆಗಿದ್ಯಾ?
ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಆರ್ಡರ್, ಎಸ್.
My lords, it's
ಇದು
DA.
29th,
29.
ಎಸ್.
Much obliged.
ಅದು ನೋಟಿಸ್ ಆಗಿದೆಯಾ ಬಿ ಪಾಟೀಲ್?
ಗೊತ್ತಿಲ್ಲ. ಆಗಿದೆ,
ಆಗಿದೆ.
ಆಗಿದೆ.
ಎಸ್.
60 ಆಗಿದೆ.
61,
Copy not served.
61 is
Leonard.
7A.
serve a copy on Latif. Learned counsel for the advocate and record shall serve set requisite set of papers upon B. Latif. Next,
62.
this is
DA, DA, my lord, 62 DA.
62 7A na?
File ಕೊಟ್ಟಿಲ್ಲ, file.
ಕೊಡಿ, ಕಾಪಿ ಕೊಡಿ. 7A ಅಂದ್ರೆ 26th.
Copy ಕೊಡಿ sir. DA, 63 is DA.
This is DA. This is 29th. Order, interim order ಇದೆಯಲ್ಲ? Interim order ಇದ್ರೆ continue ಮಾಡಿ. Next,
64 file is served yesterday, my lords.
7A,
DA.
29th,
Discharge application came to be rejected.
29th, yes.
Like, before the trial court on.
They defer, the concerned court is directed to defer its proceedings till the next date of hearing, 29th.
Please.
Next,
Not 65.
7A.
65,
ಅದಲ್ಲ ಇಂಟ್ರಿ ಮಾಡಲಿಲ್ಲ
idre continue.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಮೊನ್ನೆ ನೋಟಿಸ್ ಆಯ್ತು
65,
ಪ್ಲೀಸ್
7A, my lords.
7A, same order on 26th.
7A again, my lords.
7A, same order,
7A, my lords.
same order. Whatever order is there, ಬೇರೆದ್ರಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅದು?
68 ಯಾರು? 68 ನಿಂತಿದ್ದಾನೆ. 68 ಯಾವುದು?
CB, wait, ಅದು separate. Yes.
68.
I'll take it separately because Prasad
9 is
Kumar.
DA, my lords.
70, 69 DA,
DA.
29th
7A, my lords.
DA, 29th,
7.
26th. Order ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ. Concerned court shall defer its proceedings till the next date of hearing. Yes, next.
My lords, failed trap.
21 failed trap.
26th.
26.
This is not listed. 22.
No, charge not is
7A.
framed in 72. Charge
Yeah.
is
Charge
72 ನಲ್ಲಿ.
ಏನಾಗಿದೆ?
Charge sheet not is failed trap. It's a case of failed trap.
7A na?
7A.
7A, 26th.
Not
Concerned court shall defer its proceedings till the next date of hearing. ಅದ್ರಲ್ಲಿ
72.
charge sheet ಆಗಿದೆ ಅಲ್ವಾ? Yes, next.
23.
ಹಾ,
76 ಅಲ್ಲಿ.
ಅಷ್ಟೇ. 26th, yes.
ಲೆಫ್ಟಿ
Not filed ಅಂದ್ರೆ order.
ಆಗ್ತೀಯ ನೀನು?
ಮಾಡ್ತಾರೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಯಾವ್ದು?
ಬರ್ತೀನಿ.
ಯಾವ್ದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ? 73 ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ, that order. Not to file final report. ಅದು ಗೊತ್ತಲ್ಲ, not to file final report if final report is not filed. Yes.
24.
29th. Yes, next.
75.
Prasanna Kumar,
DM.
29th.
76.
My name needs to be deleted.
74, 26th. Correct ಆಗಿ ಹೇಳಿ ಇಲ್ದಾರೆ.
My lord, 76, my name needs to be deleted. My friend has
History to
filed.
delete the name of Baby Patil as appearing for the respondent and retain the
Yes.
name of Latif B.
77.
DM.
DA,
Please.
yes. 29th. The 26th, that is
ಎದ್ದ ಮೇಲೆ ಹೇಳ್ತಾನೆ.
28.
7A, my lord. 7A.
7A, 26th.
29.
Same, 26th.
80.
80 is DA, my lords.
29th,
DA.
29th,
81.
DA, my lords.
29th,
82.
DM.
29th.
13C. My lords.
Correct. That is disproportionate assets.
ಅದೇ 13C.
That is DA.
83.
29th.
83, my lords, is 13C, misappropriation of government funds.
Huh?
83 is 13C, my lords.
It is separate, huh? We'll take it on 30th. ಹಾಗಾದ್ರೆ.
Please.
List on 30th. Entry ಮಾಡಿದ್ಯಾ? Entry ಮಾಡಿದ್ರೆ continue. Yes, next. 85. Sir, whatever order is there, that will continue. Next.
84.
84. Chandrakant Patil,
84 DM.
84, 29th,
85 D.
85 DA.
29th,
86 DA, my lords. DA.
29th,
7.
7A, my lords. 7A.
7A ಅಲ್ವಾ? 26th. 26th, yes. Tag along with so and so. ಎಲ್ಲಿ ಇಬ್ರು ಇದಾರಲ್ಲ ಮೇಡಮ್, ಏನಾಗಿದೆ? ಇಬ್ರು ಅವ್ರೇನಾಗಿತ್ತು?
ಇಲ್ಲ ನಾನು
ಅವ್ರು
230 criminal appeal ಇದೆ.
ಇಬ್ರು ಅವ್ರೇ.
ನಾವದನ್ನ ಹಿಡ್ಕೊಂಡು ನಿಂತಿದ್ದಾರೆ. ಕಂಪ್ಲೇಂಟ್ ಅಷ್ಟೇ ಎಲ್ಲ ಬಿಟ್ಟಿದ್ದಾನೆ.
88.
7A, my lords.
89.
DA, my lords.
89 and 98.
89 DA.
ಒಂದ್ ನಿಮಿಷ.
One sufficient.
ಒಂದ್ ನಿಮಿಷ. 88,
88 is 7A.
88, 26th, 89,
89,
DA.
not one submission, not the agency not has moved, not for suspension of not this petitioner, not even in a DA case.
that is difficult. See, I cannot direct, don't suspend ಅಂತ ಹೇಳೋದು.
Service material rate ಹಾಕಿ.
And your lordship should not
I
order in
have
other
further
matter.
said, we'll pass final order and not to take any precipitative action in the
Sorry.
meantime ಅಂತ ಅದೇ.
ಅಷ್ಟು
That's all I can say, but
please, that may not, I think.
ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಒಂದು extent remote extended, the respondents are restrained from taking any precipitative action. ಅಷ್ಟ್ ಮಾಡಿ.
Even in 98, in ಮಿಕ್ಕಿದೆಲ್ಲ I am not asking.
ಆಯ್ತು.
89 and 90.
89 and
98.
90?
98, as and when it is called.
98 ಬಂದಿಲ್ಲ ತಾಳಿ. 89. No, 89 ಕೇಸ್ ಇಲ್ಲ ನಿಮ್ಗೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿ.
His wife, not his
No,
husband.
no.
ಅದೆಲ್ಲ I'm not- I-
89 ಲೇನ್ ಆರ್ಡರ್ ಬರಿಬೇಡಿ. ನ್ಯಾಷನಲ್ ಹೈವೇಸ್. I have told you last time. ಎಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ ಇರಲ್ಲಿ?
87 and 97.
89%. ಇವತ್ತು ಸೀರಿಯಲ್ ನಂಬರು 89. ಅದರಲ್ಲಿ ಏನು ಬರೀಬೇಡಿ. ಓನ್ಲಿ ವಾಟ್ ಎವರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಲಿಸ್ಟ್ ಆನ್ 29. DA ಅಲ್ವಾ ಅದು?
90 is DA.
Well, it's 90 FIR stage, interim order has to be passed,
That-
it's not yet passed.
90
90 and 92, 96, sorry.
ಒಂದೊಂದಾಗಿ ಹೇಳಿ. ವೈಟ್ ಸರ್.
ಕರ್ದಾಗ ಹೇಳಿ.
90
90 is DA.
Interim order to be passed, well, it's
90 ಸೇಮ್ ಆರ್ಡರ್ ಏನು ನಾಟ್ ಟು ಫೈಲ್ ಫೈನಲ್ ರಿಪೋರ್ಟ್. ನೆಕ್ಸ್ಟ್ 91
91 7A. 7A.
7A ಅದರಲ್ಲೂ ಅಷ್ಟೇ ಸೇಮ್. ನೋಡ್ಬಿಡಿ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮಾಡಿ ಅಷ್ಟೇ. ಇದ್ರೆ
7A my lords. 7A.
7A 26th
DA my lords.
AM.
DA 29th
7A. 7A.
Interim order needs.
94
7A.
Ah.
DA my lords.
94 7A same 26th October.
Well, it's 96 again. and
DA.
58.
ಒಂದು ನಿಮಿಷ. 95
95 is DA, 96 is DA.
both 29th.
Well, it's 96 only because of the suspension, similar orders which were passed, well, in the other petition, I just passed. It's passed in a WP number. could I-
ನಾಟ್ ಸಸ್ಪೆನ್ಷನ್. ಸಸ್ಪೆಂಡ್ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿದಿನ ಮತ್ತೆ. ನೋ ನೋ
Same order if it is going to be there.
ಇವರೇ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಒಂದು ಯಾವ್ದ್ರಲ್ಲ ತಗೊಂಡಿದ್ದಾರೆ.
ಮಾಡ್ತಾರ ಅವರು. CBI ಜನ ಹಿಂಗೆ ಮಾಡೋದು.
Not
That's
to
the order
suspend
which
ಅಂತ
was
ಹೇಳಿಲ್ಲ.
passed.
Not to take.
ನಾಟ್ ಟು ಪ್ರೆಸಿಪಿಟೇಟ್ ಅಷ್ಟೇ.
ಆ ರೀತಿ
ನೋ
ಬಂದ್ರೆ ಸಾಕು.
ಪ್ರೆಸಿಪಿಟೇಟಿವ್ ಆಕ್ಷನ್ ಶೆಲ್ ಬಿ ಟೇಕನ್. ಅದು ಆರ್ಡರ್ ಬರಿ ಅದರಲ್ಲೇ. ಕೋರ್ಸಿವಲ್ಲ ನಾಟ್ ಟು ಟೇಕ್ ಎನಿ ಪ್ರೆಸಿಪಿಟೇಟಿವ್ ಆಕ್ಷನ್. ಐ
Precipitative
ಕರೆಕ್ಟ್ ಇಟ್. ಡೋಂಟ್ ವರಿ.
Please.
ನೆಕ್ಸ್ಟ್
97 is DA my lords.
96 29. Yes.
DA my lords.
97
DA.
29th. Yes.
98 ಅಲ್ಲಿ ಅದು. Not to.
ಫೈಲ್ ಕೊಡ್ಬೇಕು. ಫೈಲ್
98 ಅಲ್ಲ. 98 ಅಲ್ಲಿ DA ನಾ ಅದು?
my lords 98 ಫೈಲ್ ಕೊಡಕ್ಕೆ.
ಕೊಡ್ತೀನಿ. If I missed it, not I'll give.
29th ಅದು ನಾಟ್ ಟು ಫೈಲ್ ಫೈನಲ್ ರಿಪೋರ್ಟ್ and shall not
99
take any precipitative action in the meantime. Next.
ಅದು CBI ಮೇನೋನ್.
89 ಯಾರ್ದು?
ಇದು CBI wait.
CBI.
ಅದು ವಿವೇಕ್ ರೆಡ್ಡಿ ಅವ್ರ ಜೊತೆ ಹೋಗುತ್ತೆ. Yes.
100 is DA. DA.
29th same order, whatever order.
Please.
There's
101
ಏನಾದ್ರು?
29th
My lords, 101 I notice my lords may check because from there on I don't have any instructions after that.
100 ಆದ್ಮೇಲೆ
100 ಆದ್ಮೇಲೆ.
ಲತೀಫ್
ಅವರು ಇಲ್ಲ, ಲತೀಫ್ ಇಲ್ಲ, ಯಾರು ಇಲ್ಲ. ಅವರು ಹೋದ್ರು, ಯಾವ್ದು ಆಗಿಲ್ಲ.
ಲತೀಫ್
ನೋಟಿಸ್ ಆಗಿದೆ ನಾ ಇಲ್ಲಿ ನೋಡ್ಬೇಕಾದ್ರೆ.
ಆಯ್ತು. 101 ನಿಮಗಾಗಿದೆ.
ನನಗಾಗಿಲ್ಲ.
Petitioner to serve. ಸತೀಶ್ ಕಾಪಿ ಕೊಡಿ. Learned counsel ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ.
ಸರಿ ಬಂದಿ.
Counsel for the petitioner to serve set of papers upon a counsel Shri B.B. Patil.
ಇಲ್ಲ BBP.
101 ನಲ್ಲಿ. ಈಗ ಉಳಿದಿದ್ದು ಯಾವ್ದು? ವಿವೇಕ್ ರೆಡ್ಡಿ ಅಂಡ್ ಇದ್ರೆ ತಗೊಂಡ್ಬಿಡಿ. ಮುಗಿಸ್ಬೋಣ. ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಆಯ್ತು ಸರಿ. ಓಕೆ ಅಲೌಟ್ ಮಾಡ್ಬಿಡಿ ಇದ್ರೆ. ಅಲ್ಲ ಅದಕ್ಕೆ ಏನ್ ಬರ್ತಾರೆ ಅಂತ ಏನಿದ್ ಮಾಡ್ಬೇಡಿ. ಅಂದ್ರೆ ಅದು ಮಾಡ್ಲಿ. ಬಟ್ ಈಗಿದ್ರೆ ಅಡ್ವೊಕೇಟ್ ತೊಂದರೆ ಮಾಡ್ಬಾರ್ದು ಆಮೇಲೆ. ಅಂದ್ರೆ ಕರೆದ್ರು ಅಷ್ಟೇ. ನೆನ್ನೆ ತರ ಮಾಡಿದ್ರು ಅಷ್ಟೇ. ಆಲ್ ರೈಟ್.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಕೂಡ
ಯಾವ್ದು ಹೋಗ್ತಾನೆ?
ಈಗ ವಿವೇಕ್ ರೆಡ್ಡಿ ಸರ್ ತಗೊಳ್ಳಿ.
One submission.
ಆಯ್ತಲ್ಲ ಇನ್ನೇನು?
Serial number 22, where charge sheet has been filed in section 7A, direction to defer the proceedings.
ಅದು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗ್ತಾ ಇದ್ರೆ ಮಾತ್ರ. ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ ತಕ್ಷಣ ಚಾರ್ಜ್ ಫ್ರೇಮ್
Next date for hearings for HBC.
To move the matter if charges are being framed. ಇನ್ನು HPC ಆಗ್ಬೇಕೆಲ್ಲ ಇರುತ್ತೆ.
Serial number 51, it is posted for charge.
51.
51, I'm sorry, I did not make it.
ಸುಮ್ನೆ ಹೇಳ್ಬೇಡಿ.
HBC ಆಗಿದೆ ಈಗ ಅದಕ್ಕೆ.
51 ನಲ್ಲಿ ಡೆಫರ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಮಾಡಿ.
Great.
Yes. So with serial number 130 ಅಲ್ಲಿ, the respondent police have filed
ಅದು
B report, my
ಒಂದ್
lord.
ನಿಮಿಷ ಅದೆಲ್ಲ ನೀವು ಯಾರು ಇರೋದ್ ಬೇಕಾಗಿಲ್ಲ, ಅದ್ ನಾನು ಕ್ಲೋಸ್ ಮಾಡಿ ಎದ್ದು ಹೋಗ್ತೀನಿ. 2:30.
ಆಗ್ಲಿ.
2:30 ಈಗಲೇ ಕರಿತೀನಿ, ಇದ್ರೆ ಆಮೇಲೆ ನೋಡೋಣ.
Bacha please.
ವಿವೇಕ್ ರೆಡ್ಡಿ, ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್.
Please.
ವಿವೇಕ್ ರೆಡ್ಡಿ ಅವರಲ್ಲಿ ನೀವಿದ್ದೀರಾ?
Yes.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy has served, not both these matters.
ಯಾವ್ದು
68 and
ಬೋತ್
90
ಯಾವ್ದು?
68 and 99, both may not arise out of Delhi, may not special unit matters. But I couldn't may not contact anybody.
60?
68 and 99, may not.
ಒಂದ್ ನಿಮಿಷ ಫೈಲ್ ಕೊಡಿ.
Short issue, my lord. A2, it appears, A2 gives 25,000 to A1. A2 is a notary, my lord, named Vani. Notary recruitment.
A4 and A5 ಯಾರು?
A4 and A5, the only allegation against them is 3 months prior to this date, to the date when the 25,000 is given, WhatsApp message is sent by A4 and A5 of about 2 candidates. 3 months
ಯಾವ
before,
ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಸ್ಕ್ಯಾಮ್ ಇದು?
is a notary recruitment.
ಹಾ.
3 months before, on 16/2/2023. The trap is on 16/5/2023. The recruitment occurs on March 2023. Interviews take place, recruitment occurs. Now, my lord, what I send is a letter, my name along with the letter of recommendation of an MP to A2. They are connecting this WhatsApp communication regarding names sent of 2 persons to the 25,000 graft that A2 pays to A1 3 months later.
Yes, Prasanna Kumar.
And all these WhatsApp
That allegation is at page
Of
120.
evidence ನಿಜ, but you get the information and file your objections if you want. What stage is the proceeding now?
Charge sheet is filed. Charge sheet is filed ಅಷ್ಟೇ, ಮತ್ತೇನಾಗಿಲ್ಲ.
Charge sheet file ಆಗಿದೆಯಲ್ಲ?
Charge sheet file agide, but now they want to frame
That
charge.
stage.
Frame charge will see, will defer the proceedings. ಇದು these two matters will take it separately because you are for the
Please,
respondent here.
please.
We'll take them on 30th.
Yes.
Heard the learned senior counsel Vivek Reddy appearing for the petitioner and the learned counsel P. Prasanna Kumar. Learned counsel P. Prasanna Kumar seeks 3 weeks' time to secure instructions and file his objections, if any. List the matter on 30th in the fresh matters list. The concerned court shall defer its proceedings till the next date of hearing. 99, same order.
Please.
Banu Prakash,
Obliged.
Prasanna Kumar,
Please,
99, same order, 30th.
please.
Same order, take note, same submission ಮಾಡಿ, objection.
Accused number 1
ಯಾವ್ದ್ರಲ್ಲಿ?
of this 99.
Banu Prakash.
ಹೌದು, ಅದರಲ್ಲಿ.
ಒಂದೇ.
He was our officer.
ಆಯ್ತಾಯ್ತು, ಏನಿಲ್ಲ. Something else. Yes, please.
Orders?
ಲಿಸ್ಟ್ ನಲ್ಲಿ ಒಂದು ಮ್ಯಾಟರ್ ಇದೆ ಸ್ವಾಮಿ, 7A.
List 2 ಇದೆಯಾ?
ಲಿಸ್ಟ್ ಅದೇ ಎರಡೇ ಮ್ಯಾಟರ್ ಏನು ಬಂದಿದೆ.
ಓ, ನೆನ್ನೆ ಕರೆಕ್ಟ್.
List 2 serial number 1 is 7A. I'll serve on Mr. B.B. Patil.
ಬಿಬಿ ಪಾಟೀಲ್ ಲತೀಫ್ ಯಾವ್ದಾರು ಮಾಡಿ.
Please,
Counsel B. Latif is directed to accept notice for the 26.
please.
ಏನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ sir.
ಆಗಿದ್ರೆ 26th ಅಷ್ಟೇ.
Please,
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಮೂವ್ ಮಾಡಿ
please, I shall.
ಪಾಸ್ ಮಾಡಿ.
Please.
ಇನ್ನೊಂದು ಯಾವ್ದು ಆನಂದರಾಮ್ ಇದೆ,
In this case, I
ಸೆಟಲ್ಮೆಂಟ್.
may be permitted to file power for the.
Yes, sir. You are permitted, yes. Settlement ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, ಕ್ವಾಶಿಂಗ್ ಆಗಿದೆ. I mean, charge sheet has to be quashed. Family court ಅಲ್ಲಿ settlement ಎಲ್ಲ ಆಗಿದೆ.
ಕ್ಯಾಶ್ ಶೀಟ್ ಕ್ವಾಶ್ ಆಗಿದೆ.
ಇಲ್ಲ sir.
Quash ಆಗ್ಬೇಕು.
MC ಅಲ್ಲಿ they have settled the matters.
Before the family court is the matter is settled. Mediation ಅಲ್ಲ, ನನ್ನ ಹತ್ರ
ಎಂಪ್ಲಾಯ್ಸ್ ಮಾಡಿದ್ದೀರಾ ಪಿಟಿಷನ್ ಜೊತೆ ಮಾಡಿದ್ದಾರೆ.
Annexure F is the memorandum of settlement.
ಏನ್ offense ಏನ್ 498 ಏನು?
498 and 320.
Section 3 and
Where is the ಇದು? ಯಾವ್ದು ಮೇಡಮ್? ಆನಂದರಾಮ್ದ ಇದು? ಪ್ರಸನ್ನ ಕುಮಾರ್ ಏನೋ ಕೊಟ್ಟಿದ್ದೀರಾ? ಇದಾಯ್ತು.
Page 255 to 258.
Two fifty?
5.
255 to 255 to 258.
ಓ, ಇದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ ಕೇಸ?
Yes.
I had filed review petition, father-in-law and exclude.
ಅದೇ
ಮಾಡಿದ್ದಾರೆ,
father
ಅದೇ
in law
case
ಈಗ ಸೆಟ್ಲ್
ಆಗಿದೆ.
Now you don't want the father-in-law. Yes. Flag ಹಾಕಿ. ನಾಲ್ಕು ಪರ ಇದೆ ಅಷ್ಟೇ. Yes.
Outline.
Alright, orders?
ಟೂ ತರ್ಟಿ ಕಲ್ಬಿಡ್ತೀನಿ, ನೋಡ್ಕೊಂಡಿದ್ದೀರಾ ಎಲ್ಲ?
Please.
ಆಮೇಲೆ ಯಾವ್ದು ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಹೇಳಿ ಮೇಡಮ್. 102
102?
ಚಾರ್ಜ್ ಶೀಟಾ?
Please, my lord. CC number 2090 of 22.
ಹಾಕೊಂಡ್ಬಿಡಿ. ಸರಿ, ಮತ್ತೆ ಅವ್ರಿಗೆ ಕೊಡಿ. ಏನ್ ಬೇಡ ಬಿಡಿ, ಕೊಡ್ತಾರೆ.
ಬರ್ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ನಾನು.
She would have done a perfect job, no problem.
Please.
Yes.
104?
Acquitted.
105?
Charge sheet filed, madam.
ಬೇಡ, ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ಬಿಡ್ಲಿ, ಹೋಗೋದೇನ್ ಬೇಡ. ಹೋಗ್ಬೇಕು. ಕರ್ಬಿಡಿ ಮಧ್ಯದಲ್ಲಿ. ಎಸ್. ಬಿ ರಿಪೋರ್ಟ್, ಎಸ್.
107?
Charge sheet is filed, madam.
ನಂಬರ್?
Number I'll provide.
ಆಯ್ತು. ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ಫೈಲ್ಡ್. ನೆಕ್ಸ್ಟ್.
108?
Acquitted, my lord. Acquitted.
Acquitted.
Please,
Yes.
Acquitted on 2/9/23, my lord. In CC number 28 of 23.
ಎಲ್ಲ ಬರ್ಕೊಂಡ್ರ?
109?
Acquitted on 7/9/23.
Hmm.
In CC number 12943 of 20.
110? Withdraw.
Acquitted on 2/9/23.
ವಿಡ್ರಾಲ್ ಹಾಕಿದ್ದಾರೆ.
Please, ma'am.
111?
Charge sheet is filed, my lord. I'll provide.
CC.
I'll provide, my lord.
ಆಯ್ತು.
112?
CC number 249 of 23.
113?
38200 of 22. CC number.
114?
B report, ma'am.
115?
CC number 210 of 22. It 115.1, my lord, I'll provide the CC number. I have not got the CC number.
Next.
116?
CC number 3671 of 22.
117? Withdraw.
This may kindly be passed over, my lord. I have received that 117.
ಮೆಮೊ ಹಾಕಿದೆ.
116 ಅಲ್ಲಿ 3671 of
117
22.
ವಿಡ್ರಾಲ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Please, madam.
ಆಲ್ ರೈಟ್. ಅದು ಸಬ್ಮಿಷನ್ ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ ಮೇಡಮ್.
Memo.
ಅದು ಕಾವ್ಯ. ಮೆಮೊ ಇದ್ರೆ ಹೇಳಿ, ಇಲ್ಲಾಂದ್ರೆ ಸಬ್ಮಿಷನ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಪಿಟಿಷನರ್ಸ್ ಗೊತ್ತಲ್ಲ? ಎಸ್.
118?
B report.
I paid for the petition, my lord. One short accommodation will be given.
ಲಾಂಗ್ ಅಕಾಮಿಡೇಷನ್ ತೊಂದರೆ ಇಲ್ಲ. ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ, ಕ್ಲೋಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಮೇಡಮ್. ಎಸ್.
119?
Petitioner in this case, so it may be adjourned.
CC
Charge sheet is
1263
fine.
of 24.
ಚಾಲೆಂಜ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್. ಎಸ್.
120?
B report, my lord.
121?
B report, ma'am.
122?
CC 27 of 23.
27 ಆಫ್
23.
123?
CC 52290 of 7. My lord, I'll just provide this number, my lord. The year I have to just verify.
ಎಸ್.
123, I'll just give the CC number.
124.
120.
I've challenged the charge sheet. in
1
fact.
minute. 124 ಏನು?
My lord, the challenge the charge sheet, my lord, in
ಸರಿ.
CC 99 of 20.
ಲೆಸ್ ದ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ 2 weeks.
But
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
illa. And I accept the husband
498 ಏನು?
498. There can be an interim order.
There can be. There will be.
Your lordship is the best judge.
Accused number 1 ಯಾರು?
The husband.
All right. ಈ ಫೈಲ್ ಇದೆಯಾ ಮೇಡಮ್? ನಿಮ್ದೇ ಕೊಡಿ.
Yes.
ಇದೆಯಾ? ಸಿಗೋದ್ ಕಷ್ಟ ಆದ್ರೆ ಅವ್ರಿಗೆ ತಗೋಣ. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
Charge sheet is enclosed also.
ಕೊಡಿ. ಕೊಡಿ ಕಲ್. ಬರಲ್ಲ ಬಿಡಿ.
Parents, older sister and brother-in-law.
The petitioners
My
are
lord,
accused
this,
1 to 5.
charges framed, my lord.
No, my lord. Charges is for framing of charges. on
Framed
6th.
after the petition or before?
No,
the
no, not framed, my lord. 6th of November is the.
The petitioners accused 1 to 5 are before this court calling in question proceedings in CC so and so. A perusal at the summary of the charge sheet as obtaining in column number 7 would not indicate any offense, much less ingredients of the offenses alleged against the petitioners, except a sprinkling few against the accused number 1 husband. In that light, permitting further trial to go on against these petitioners, except the husband accused number 1 in CC 1416 of 2021 would run foul of the judgment of the apex court in the case of so and so 2024 SSC online SC page 2621. Therefore, there shall be an interim order of stay qua accused 2 to 5 till the next date of hearing, 1 HCGP, 2 emergent notice.
Please.
Yes. ನೀವು ಇದ್ದಿದ್ದು ಒಳ್ಳೇದಾಯ್ತು, ಇಲ್ಲ ಅರ್ಜನ್ ಆಗ್ಬಿಡ್ತಾರೆ.
Grateful. Yes, my lord.
But 2 years ಇಂದ ಯಾಕೆ ಮೂವ್ ಮಾಡಿಲ್ಲ ಇದನ್ನ? We have got it listed, ನಾವೇ ಕೇಳಿ ಹಾಕ್ಸಿದ್ವಿ. ಯಾರು ಮೂವ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
Didn't receive instructions from the court.
Anyway, yes.
125.
Charge sheet, yes, so and so, yes.
26.
Same.
PC number 409.
ಅದು ಕೊಟ್ಬಿಟ್ಟು ಬರ್ಕೊಂಡಿದ್ದೀರಾ ಮೇಡಮ್? ಸರಿ, ಎಸ್.
27.
My lord, in this matter, they have challenged the charge sheet, my lord. It has to be.
ಫೈಲ್ 120?
127, they have challenged the charge sheet, my lord.
ಏನು ಒಫೆನ್ಸ್ ಏನು? ಮಧುಕರ್
506, 504, 323, 320, 341.
341.
Please.
ಲಾಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ ಅದು ಇವತ್ತು 230 ಇದೆಯಲ್ಲ, ವಿ ಕಾಂಟ್ ಸೇ ದಟ್ ಅಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ 506, 504 rapid car number 777. Yes.
127.
List after vacation. Yes. Next.
128.
My lord, in this matter also, they have challenged the charge sheet, my lord. It has to.
28, I'm for the petitioner, Your Honor.
Ah.
Thrice we have filed this one at the counter.
Offense ಏನು? File ಅಲ್ಲಿ. What is that file you're holding? Keep that on the table and stand. Four 48, 320.
But for the offense punishable under section 323.
ಯಾವುದು ತಲೆ ಮೇಲೆ ಹೊಡೆದಿದ್ದಾರೆ ಕೈಯಲ್ಲಿ ಅಂತ, ಅದಕ್ಕೆ ಅಟೆಂಪ್ಟ್ ಮಾಡ್ರ? ಎಸ್, ಇನ್ ದಿ ಮೇನ್ ಟೈಮ್ ಅದು ಮಾಡ್ಬಿಡಿ. ಸ್ಟೇಡ್, ಎಸ್, ವಿತೌಟ್ ಫೈಲ್. ಎಸ್.
129.
B report, madam.
ಎಸ್.
130.
B report, madam.
130, B report ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಆಯ್ತು,
ಅದು
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಕೊಡಿ,
ಎಸ್ ಸ್ವಾಮಿ.
ಮೆಮ್ಮ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ.
ಇದೆ ಸ್ವಾಮಿ.
ಆಲ್ ರೈಟ್.
131.
131 ಏನು? 131 B report, yes.
132.
Milords, in 132, I appear for the petitioners,
Charge sheet
Milord.
is filed.
Charge sheet, I've also filed a charge sheet, Milords. I've challenged the charge sheet.
Challenge the charge sheet only?
Yes, yes, Milords.
What's the offense?
The matter concerns the list between brothers, my lord, regarding access to common pathway cart track to their agricultural
Case
property.
and counter case,
Please.
then ಎರಡು ನಡೀಲಿ ಬಿಡಿ.
There is stay, my lords, in the FIR that
The
I
other
had lodged
case?
against him. Same date incident, my lords. In fact, I
Number,
have a stay by
criminal petition
RS
number.
criminal petition number in 9238 of 2021, my lords.
Tag this petition along with 9. ಎಲ್ಲಿದೆ ಅದು? Annexure ಮಾಡಿದ್ದೀರಾ?
ಅದನ್ನ annexure ಮಾಡಿಲ್ಲ, my lords.
993.
9238 of 2021, my lords.
Tag this petition along with 9. ಅದೇನು ಬರ್ಕೊಳ್ಳಿ. This is on 2021. The learned counsel submits that in the case filed against the complainants, this court has granted an interim order of stay in the aforesaid petition. In the light of the interim order operating in the case filed by the petitioners, there shall be an interim order of stay in the case at hand as well. Tag zones.
I'm so grateful. So grateful.
Appearing on behalf of the
B report.
My lord, in 133 B report is.
B report. Yes.
34.
CC 657 of 22.
CC 657. Yeah, then we come back. ಬೇರೆ ಏನು ಉಳಿದಿದೆ ಮೇಡಮ್? ನಿಮ್ದು ಯಾವ್ದು? ಯಾವ್ದು ಪಾಸ್ ಓವರ್?
Serial number 18. Real matter.
ಸೀಲ್ ನಂಬರ್
18.
ಇವರೆಲ್ಲಿ?
ಅದೇ
ಪರವಾಗಿಲ್ಲ. You're all right.
Total number.
You're all right. Yes.
Perfectly all right.
Well, the submission that I made was A2 being the chairman, he was granted bail in the crime stage itself. A3 to A5 have been granted anticipatory bail, my lord.
Special court matter.
It'll come under the, because my lords, the A2 chairman was an earlier MLC.
All right.
That's the reason. Now, my lords, when I pointed out that A2 stood on the same footing, or probably the allegation against him is worse and he's been granted bail during crime, it was pointed out that he was granted on medical grounds. But that is not so. If my lords would have page 13 of this memo along with documents, my lords, which was produced. Page 13.
Yes.
My lords may notice the date, 24th July 2024. One three early. My lords, this is dated 24th July 2024. Now charge sheet has been filed on 23/8/2024. Post this. So at the crime stage, A2 was granted bail. Please notice, my lords, in this bail order, right from paragraph 5, that contains the gist of what the entire allegation is. Paragraph 5, my lords.
Since how long are you in custody?
My lords, I have been in custody now for about 4 months, 120 days.
Yes. You are the managing
My lord,
director.
my date of custody was 27/5/2024. Now, please notice this order itself, my lords. It's a very detailed order containing all the allegations. And what is it that they have argued insofar as A2, paragraph 7 at page 16. My lord should get it as on the other hand. On the other hand, senior APP has submitted in its objection and argument that offenses alleged against the accused are economic offenses, and as such, bail application made by this accused has to be viewed seriously. Though this accused was not named in the complaint, similar to me, my lords, and FIR, in the course of investigation and more particularly upon arrest and interrogation of A1, the involvement of this accused in the alleged crime was revealed, and as such, the investigating agency has implicated this accused also in this case and arrested. The allegations of complaint and also the investigation done so far and the materials collected by the investigating agency prima facie show sufficient materials against this accused in the alleged crime. Next is important, my lords. The accused being the chairman of the said committee as well as non-officio director, all the proceedings and transactions were done under the direction and guidance of this accused. The materials available with the investigating agency clearly reveals an active role of this accused in committing alleged offenses Further, there is sufficient materials to show that this accused has harvested the monetary benefits out of the said fraud. As such, there is a prima facie case against this accused. As to the commission of the alleged or economic offense, this accused is a politician, and as such, there are chances of this accused thwarting the course of justice and hampering the investigation by tampering the evidence. Investigating agency is yet to identify and seize the money that was routed through various hawala operators. Now, answering this, my lords, at paragraph 10, page 19.
Yes.
In this background, let us examine one by one of the said circumstances in the case on hand. Firstly, whether there's any prima facie case or reasonable ground to believe that this accused has committed the alleged offense. No doubt at the stage of considering the bail application, it may not be necessary to do detailed examination of evidence and documentation of the merit of the case, but it is necessary to indicate the reasons for prima facie conclusion as to why bail is being granted or refused, particularly where the accused are charged with any heinous or serious offenses. As such, it's necessary to examine the material available on record to come to any conclusion. The facts alleged in the complaint and FIR disclose offenses punishable under 120B, 409, 420, 465, 468, and 471, which can be grouped into two folds: forgery and fabrication of document like board resolutions and misappropriation of funds under the guise of such fake document. No doubt, while lodging the complaint and registering of FIR, none of the accused are named. Rather, FIR was registered against unknown accused. However, in the course of investigation, investigating agency has implicated accused 1 and 2 and arrested them. On perusal of the allegation of complaint and the material collected by the investigating agency, like copy of alleged board resolution number 194 dated 25/10/2021, and the copies of the same resolution that were alleged to have been sent to the directors along with the invitation for attending the board resolution number 194, coupled with the opinion of some of the directors of the said resolution, copies prima facie created doubt as to fabrication of such board resolution and creation of fake documents. Then, my lords, 409 is dealt with. My lords, the judgments on that aspect dealt with. 11, character, conduct, means, and position of the accused. Tripod test is considered at page 22. And then, my lords, after tripod test, page 23, just above paragraph 12, the nature of the offenses alleged in this case depends mostly on documentary evidence for their proof. Moreover, almost all the documents pertaining to alleged offenses were seized by the investigating agency and the lokaयुक्त under an inquiry. That being the case, the chances of this accused tampering with any such document is very remote. And then, my lords, paragraph 12, under section 41 notice which was given, then Sanjay Chandra's case is quoted at page 24, and object of bail is to secure the appearance of the accused during trial. And thereafter, the order we get at page 25. Charge sheet, my lords. Copies in Kotila charge sheet. Charge sheet has been filed.
Charge sheet has been filed.
Agide.
Number
And we have sought for,
number
Swami, number agila. We have sought for prosecution. The 70 sanction of prosecution. It is, we are awaiting for the sanction.
So charge sheet is filed.
Charge sheet
Charge
filed.
sheet is filed.
All right.
PC Act has been
Charge sheet is
invoked.
ready, not yet filed.
Yes, not it.
They've submitted before
they-
the court. They have submitted before the court, but without a sanction, I guess, my lords. That's what they say.
ಅಲ್ಲ
in the
cognizance
objection.
ತಗೊಳಕ್ ಮುಂಚೆ sanction.
Out. They've submitted it before the court.
And however, with respect to 17A has been granted with respect to
That's
this
an
petitioner.
approval.
No, let me.
17 ಆಗೋಗಿದೆಯಲ್ಲ.
Agide with respect to this petitioner and moreover with respect to 19, it has been pending. We are awaiting for the sanction for the prosecutor.
All right.
File agide.
All right.
Right, and we are further going to file supplementary charge sheet also.
But that liberty you always have.
May make a,
ಹೇಳಿ.
Lord, as my learned senior counsel expressed with the order bail order which has been passed by the trial court, I will try to impress upon this court with respect to paragraph 13, my lord.
Yes.
At page number 24 and 25, in the light of all the above stated principles on analyzing the facts and circumstances of this case, the nature of the gravity of the offense alleged and also character and position of the accused herein, no doubt there is a prima facie case against this accused. And the gravity of the alleged against this accused is also serious like economic offense, but there appears no justifiable grounds to hold that this accused, if enlarged on bail, would attempt to hamper the investigation or tamper the prosecution evidence and thereby thwart the course of justice. More so on the considering the age of the accused as well as his position in the society and his family background, there appears no ground to hold that this accused, if released on bail, would flee from justice. More so, it is pertinent to note that there are no such antecedent criminal activities by this accused. I have furnished one of the judgment along with my objections, my lord, at page, madam. And the roles of the accused number 2 and accused number is entirely different. He is a politician and he is an
Who's a
executive.
politician?
A2 is a politician. A1 is a petitioner, is a chief executive officer. The entire role is upon him to see that how the
You are the chairman, na?
he
No,
is
chairman
the
is
MD,
I am
managing
MD.
director.
Oh, chairman is the politician.
Chairman is politician. The petitioner is A1. This petitioner is a chief executive
ಯಾವ
officer.
judgment ಹೇಳಿ?
My lord, at page number
14.
14, my lord.
All right.
I'll draw your lordship attention
Hmm.
at P, my lord,
Hmm.
with respect to parity,
Hmm.
as your lordship got.
Hmm.
As per the accused, all the main accused individuals, including managing director and KMP of the company, as well as owners, operators, control of various shell companies, were granted bail on the ground of infirmity and medical reasons. Additionally, a co-accused who was internal auditor also granted bail. While denying bail to the accused, court had distinguished his role as a vice president of purchaser as he was responsible for day-to-day operations. This is what I would like to mention it, my lord. In fact, he is responsible for the day-to-day activities. I've also furnished official memorandum where I would like to read it subsequently, my lord. Irregularity, and if any wrong orders has been passed, the others cannot claim a similar benefit. As a matter of right, bail was not granted to the accused. I'll draw your lordship attention to the next page, my lord, at D. The offense of cheating, fraud, and misappropriation of funds in furtherance of the criminal conspiracy, economic offenses constitute separate class and need to be visited with a different approach in matter of bail. Such offenses have a deep-rooted conspiracy and involving huge loss of public funds must be viewed seriously as it affects the economy of the country as a whole. Economic offenses have seriously repercussion on development of the country. Minute exercise is expected to be undertaken by investigation officer to see that no innocent person is wrongly booked and no culprit escaped from the clutches of the law. Bail was not granted. My lord, I'll draw your lordship attention to the last page, my lord, page number 25. The entire community is aggrieved if the economic offender who ruins the economy of the state are not brought to the books. A murder may be committed in the heat of moment upon passion being aroused. An economic offense is committed with a cool calculation and deliberate design with an eye and hope on personal profit regardless of the consequences of community. A disregard for the interest of the community can be manifested only at the cost of the forfeiting the trust and faith of the community in the system to administer justice even and manner without fear of criticism from the quarters which view white-collar crimes with a permissive eye, unmindful of the damage done to the national economy and national interest. My humble submission before this honorable court is that, my lord, first and foremost thing the senior counsel had expressed with respect to the parity, my lord, where I would rely upon this judgment, and more so ever, his role is totally different from the role of a chairman. He is a managing director, where I have furnished an official memorandum where it clearly speaks about his conduct and discharging of the duty. At page number 11, it is clearly said that what is our if something error has been found by the managing director, he will be solely held responsible to see that he should avoid that and see that what has to be made.
ಈಗ ಬೇಲ್ ಕೊಟ್ರೆ ವಾಪಸ್ ಪೋಸ್ಟ್ ಹೋಗ್ತಾರಾ?
ವಾಪಸ್ ಪೋಸ್ಟ್ ಹೋಗಲ್ಲ ಸ್ವಾಮಿ. ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ನಾವು page number 12, my normally only board para 6, my lord. Sorry, class 6.
ಏನ್ ಸ್ಕ್ಯಾಮ್ ಇದು?
ಇದು 49 ಕೋಟಿ. It's a Devraj structure mill case where they were supposed to get works executed. ಈಗ ಅವರು 10 ಲಕ್ಷಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕೊಟ್ರೆ ಟೆಂಡರ್ ಕರಿಬೇಕಾಗುತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 10 ಲಕ್ಷಕ್ಕಿಂತ ಕಮ್ಮಿ ಕರೆದ್ಬಿಟ್ಟು ಏನಾಗಿದೆ, ಕೆಲಸನೇ ಮಾಡಿಲ್ಲ. There are some documents which I would violated the transparency.
ಈಗೇನ್ ಕ್ವಾಶನ್ ಕೇಳ್ತಾ ಇಲ್ವಾ?
ಅಲ್ಲ ಬೇಲ್ಗೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ, ಮೊನ್ನೆ ಅವ್ರ ತಮ್ಮನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದೀವಿ. Arrest ಮಾಡ್ಕೊಂಬಂದ್ರೆ, the reason why I'm saying this, I have also clearly mentioned in my objections, almost 50 accounts we have recovered. We are almost 5,000 transaction has to be looked into it. We don't know where the funds have gone. There are funds who are the syndicate members who are involved in this, some criminals who are involved, and there's been transferred through Hawala also. And one transfer of the person is involved is Barmer on Rajasthan border. It's a border of the Indo-Pakistan. We don't know where the funds have gone.
Don't get into other.
No, I'm just trying to make out. No.
Overtones with border, yes.
No, the what has been found, I'm just making my submission with respect to the what has been found in the investigation, my lord. In fact, if the bail has been granted, ತಮ್ಗೆ ಈಗ ನಾನು ಗಮನ ತರ್ತಾ ಇದ್ದೀನಿ ಅಂದ್ರೆ 2 ದಿವಸದ ಹಿಂದೆ ಅವ್ರು ತಮ್ಮನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಕರ್ಕೊಂಡ್ ಬಂದ್ರೆ ಅವನ್ನ ರಿಕವರಿ ಮಾಡಕ್ಕೆ ಅಂತ ಕೇಳಿದ್ರೆ ಇಟ್ಸ್ ಎ ಕ್ಲಿಯರ್ ಕಟ್ ಪಿಕ್ಚರ್ ವೇರ್ 20 lakhs amount is directly transferred to this brother of the accused number 6. That is this petitioner's brother. Subsequently 25,000 30,000 ಪಾನ್ ಶಾಪ್ ಇಂದ ಹಿಡಿದು ಬೇರೆ ಬೇರೆ ತರ ಟ್ರಾನ್ಸ್ಫರ್ಸ್ ಗಳಿಂದ ಒಂದು 75 ಲಕ್ಷ ಅವನ ಅಕೌಂಟ್ ಬಂದಿದೆ. ರಿಕವರ್ ಮಾಡಕ್ಕೆ ಅಂತ ಹೋಯ್ತು ಅಂತಂದ್ರೆ ಈ ಮೇಕ್ಸ್ ಅ ಸ್ಟೇಟ್ಮೆಂಟ್ ದಟ್ ನಾನು ನಮ್ಮ ಅಣ್ಣನ್ ಕೇಳಿದೆ, ನಾವು ಜೈಲ್ಗೆ ಹೋದಾಗ ನೀವೇನಿಟ್ರು ಎಲ್ಲ ಪೊಲೀಸರು, ದಿಸ್ ದ ವರ್ಡ್, ಲೆಟ್ ದ ಕೋರ್ಟ್ ಡಸ್ ನಾಟ್ ಮಿಸ್ಟೇಕ್, ದಿಸ್ ದ ವರ್ಡ್ ಎಸ್ ಯೂಸ್, ಪೊಲೀಸರು ಬಂದು ಎಲ್ಲ ಗೋರ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ತಾರೆ ಅಂತ ನಾವೆಲ್ಲ ಡಿಸ್ಪರ್ಸ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ ಸ್ವಾಮಿ ಅಂತ ಪೊಲೀಸರು. ದಿಸ್ ವಾಟ್ ಎಸ್ ಸೆಡ್. ನೌ ಇಫ್ ದಿಸ್ ಪಿಟಿಷನರ್ ಹ್ಯಾಸ್ ಬಿನ್ ರಿಲೀಸ್ಡ್ ಆನ್ ಬೇಲ್, he is the mastermind behind everything. And there are a lot of dots which has to be connected.
Connect.
ಅಲ್ಲಿ ನಮ್ಗೆ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ರಿಕವರಿ
ಒಳಗಿದ್ರೆ ಏನ್ ಕನೆಕ್ಟ್ ಮಾಡ್ತೀರಾ ನೀವು?
ಅಲ್ಲ, ಅವ್ರು ಅಲ್ಲಿ ಆಚೆ ಬಂತು ಅಂದ್ರೆ ಈಗ ಅವ್ರ ತಮ್ಮ ಮಾಡಿದ ಕೆಲಸನೇ ಬೇರೆಯವರೆಲ್ಲ ಹಣಕಾಸನ್ನ ಏನ ವಹಿವಾಟ್ ಆಗಿದ್ದಾರೆ, won't be able to recover this 49 crore, at least on 50% or 70% ರಿಕವರ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಸ್ವಾಮಿ ರಿಕವರ್ ಆಗೋದಿಲ್ಲ. ಆಮೇಲೆ ಇಟ್ಸ್ ಎ ಪಬ್ಲಿಕ್ ಮನಿ ವಿಚ್ ಹಸ್ ಬಿನ್.
ಚೇರ್ಮನ್ ಸುಮ್ಮನೆ ಆದ್ರೆ ಬೈಲ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಲ್ವಾ ಅದನ್ನ? ಚೇರ್ಮನ್ ಬೇಲ್ ಕೊಟ್ಟಿದ್ದು ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡಲಿಲ್ಲ?
No, I had given an opinion to challenge. At that point of time, my lord, I would like to bring it to notice of the court is this PC Act was not invoked at that point of time.
Right. Why did you not challenge it?
No, I have given an opinion with respect to challenging that order. ತಮಗೂ ಗೊತ್ತಿದೆ ಸ್ವಾಮಿ, ಗೌರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೋಗಿದ ತಕ್ಷಣ ಅದು ಎಲ್ಲರ ಹತ್ರನು ಹೋಗಿ ಬರೋ ಅಷ್ಟರಲ್ಲಿ ಐ ಡೋಂಟ್ ನೋ, ಐ ಮೀನ್ ಲೆಟ್ ಮಿ ನಾಟ್ ಮೇಕ್ ದಿಸ್ ಎಲ್ಲರ ಹತ್ರ ಅಂದ್ರೆ ಅವ್ರು ಅಫಿಷಿಯಲ್ ಆಗಿ ಟು ಪಾಸ್ ಎನ್ ಆರ್ಡರ್. My lord,
It's A3 to A5 were granted anticipatory.
ಅಲ್ಲ, they are all contractors. ಅವ್ರಿಗೂ ಎಲ್ಲ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ in the only with respect to the matter has been the trialable by magistrate ಅನ್ನೋ ಒಂದೇ ಕಾರಣಕ್ಕೆ it has been granted. I will establish, my lord. In fact, there are some documents. He himself has given a MD. He is the one who has certified the work, sir. He is not supposed to. And the technical team has to supposed to certify the work which has been executed.
ಅವರು ಕ್ವಾಶನ್ ಕೇಳಿದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇವೆಲ್ಲ ಬೇಕು. ಬೇಲ್ ಹೇಳಿ ನೀವು.
ಈಗ ನನಗೆ ಅವರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡೋ ಸಂದರ್ಭದಲ್ಲಿ ಇವ್ರನ್ನೆಲ್ಲ ಹಿಡಿಬೇಕು ಅಂತಂದ್ರೆ ಆತನ್ನ ಆಚೆ ಬಂತು ಅಂತಂದ್ರೆ ಎಲ್ಲಾನು ನಮ್ಗೆ
ಹಾಕಿದಿರಲ್ಲ.
ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಫರ್ದರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇಸ್ ದೇರ್, ರಿಕವರಿ ಆಗ್ಬೇಕಾಗ್ತದೆ.
That is cyclostyle format. Yes.
ಅಲ್ಲ, ರಿಕವರ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಸ್ವಾಮಿ. ಫಾರ್ ದ ರಿಕವರಿ at least for few days if is behind bars.
Just one submission, my lords. I said A3 to A5, they were given anticipatory bail on 15th April 2024. The allegations against 3 to 5 is 39 crores had gone into their account. Now, this order of anticipatory bail, they choose not to, it's there, my lords. It's along with my main petition, page 51, annexure D. They have not chosen to even challenge this. Page 51, annexure D.
A3 to A5.
Yes, my lords. In so far as A2, the order is dated 24th
A2 is chairman.
July, chairman, 24th July 2024, in which, my lords, their objection is he is the basic kingpin, they say. And that they don't choose to challenge. Now they say investigation is complete. We want to do further investigation, let him remain inside. This seems to be the approach, my lords.
No, really, I don't. Those accused are none other than the middlemen, sir. The contractors, their role is only that taking their money, the money which has been transferred to them, and subsequently they are transferred to somebody else. They have routed through some third middlemen also. Now the key role is this chairman as well as the petitioner herein. In order to further investigation and secure some of the documents as well as to recover funds, he should, if the bail is granted, it will be very difficult for an investigation to exercise his power and see that the recoveries cannot be made out, my lord. One humble submission. I don't know how far I'm fair enough in making this submission, my lord. In fact, if the bail has been granted in this kind of cases, my lord, ಎಲ್ಲಾರು ಏನಾಗ್ತದೆ?
ಚಾಲೆಂಜ್ ಮಾಡಬೇಕಾಗಿತ್ತು. If you want this dialogue to be put.
No, I am not saying that's the reason I said in the beginning of my
this see ಎಲ್ಲ ಆದ್ಮೇಲೆ don't bring in this saying that ಇಂಥದ್ರಲ್ಲಿ ಕೊಟ್ಬಿಟ್ರೆ argument in terrorism will never.
In a view of public interest, my lord, it's a public money which has been involved. ಅಲ್ಲ, ಅವಾಗ PC Act invoke ಆಗಿರಲಿಲ್ಲ.
Whatever it is, why did you give up?
PC Act was not.
A3 to A5 ಯಾಕೆ ಬಿಟ್ರಿ?
They are all middlemen and the private person. These are the one who have been connected with the government.
We'll see. Yes. ಅಷ್ಟೇ, heard reserved. 14th only.
Okay.
Yes, on the reopening day.
Please.
ನಿಮ್ದು ಯಾವ್ದಿದೆ?
Serial number 3 pass over ಆಯ್ತು.
ಯಾವ 3?
Serial number 3, 1.
7A.
7A, but
Oh.
I have one small submission to make. I think the petition needs a better pleadings and backgrounds.
Not yours, sir.
Alla, I entered my
Appear,
appearance,
all right.
I entered my appearance in that. In fact, that the
Withdraw
pleadings
ಮಾಡಿ ಹಾಕಿ.
requires- with
14th ಹಾಕಿ.
please,
With liberty you withdraw it, file it on the 14th.
the liberty to
Yes.
file a fresh petition.
Same. Learned counsel the petitioner takes leave of this court to withdraw the petition and file a separate petition on the same cause of action.
Please.
They said liberty is granted, disposed as withdrawn.
Please.
Pending. Serial number
Yes.
5, my lord.
ಏನಾಗಿದೆ?
Pass over ಆಗಿದೆ.
ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಆಯ್ತಿದೆ? ನೀವು ಇರ್ಲಿಲ್ವಾ?
ಅಲ್ಲ, ಐತೆ.
ಇದ್ರ?
ಹಾ,
ಯಾಕಾಯ್ತು?
It's under PC Act, my lord, offense under PC
ಏನ್
Act.
7A?
It's not 7A, 7, 13, 1A and 13.
DA,
Both
yes.
act.
Hmm.
Yes.
Hmm.
Lord, the accused number 3 is petitioner here in my lord.
No, you need not say Constitution of India. Now 7A and 13 ಆದ್ರೆ 13(1)D and 13(2), 29th. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
BB Patil is directed to accept notice for the respondent petitioner to serve set of papers upon so and so list on 29th.
Interim order.
ಯಾವ್ದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಕ್ ಕೊಟ್ಟಿಲ್ಲ. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗ್ತಾ ಇದ್ರೆ ಅವಾಗ ಮೂವ್ ಮಾಡಿ. ಎಸ್. ನೆಕ್ಸ್ಟ್.
Please.
7 ಸತೀಶ್. ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ?
ಬೇಲ್ ಮ್ಯಾಟರ್ ಇವತ್ತೇ ಇದೆ, ಅದು ಹೋಗ್ತಾ ಇದೆ ಮೆಲೋಡ್ಶಿಪ್ ಕೊಟ್ಟ.
ಬೇಲ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಬನ್ನಿ.
ಇಲ್ಲ, ಈ ಸೇಮ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಕೊಟ್ಟ 20 ನಲ್ಲಿ ಅಡ್ರೆಸ್ ಮಾಡಿ.
ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ಪಾಸ್ ಓವರ್.
ಎಸ್ ಮ್ಯಾಮ್.
ಯಾವ್ದಿಲ್ವಾ? ಸಿರಾಜುದ್ದೀನ್, ದುಬೈ. ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
Yes, my lords. Already I sought.
ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ?
No, my lords, I am not withdrawing, my lords.
ಇಲ್ದರೆ ಪಾಸ್ಪೋರ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Yes,
When
my
did he
lords.
go to Dubai and
My
come
lords,
back?
if I be given a.
No merit submission.
No, my lords, submission ಏನಿಲ್ಲ. If I come, then I should be permitted to travel. I will cooperate with the
First you
investigation.
come,
Yes, my lord.
then
I
you
will-
move the court. We will
Yes.
permit you to go back.
Yes, my lord, because I am the only sole breadwinner of my family. Entire family is dependent on me. And ಇದ್ರಲ್ಲಿ, my lords, ನಮ್ಮ ಹತ್ರನೇ ದುಡ್ಡು ತಗೊಂಡು ನಮ್ಗೇನೆ ರಿಕವರಿ
ಅದು
ಮಾಡಿ.
ಬೇರೆ, ಆಮೇಲೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ.
Yes, my lord.
First cooperate with the investigation.
Yes, my lords. If
Then
this
I will
is-
hear you on merits.
Yes, my lords. I will file an IA from the father that he will undertake that he will come and cooperate the investigation officer. There should be no, they should not take any coercive step. My lords. Already I am on the. bail.
ಮಾಡಿ.
Yes, my lord.
ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಫೈಲ್ ಮಾಡಿ.
Yes, my lord.
ಇಲ್ಲ ಅಂದ್ರೆ 14th ಫೈಲ್ ಮಾಡಿ.
Yes, my lord.
14th?
14th.
ಆಯ್ತು, we'll take it on 14th.
Yes, my lord.
Yes,
My lord, that food matter, it may be taken, my lord.
14th ಹಾಕಿ.
That food matter may be taken, my lord.
ಇವತ್ತಿದೆಯಾ?
No, my lord, ನಾನು ಮೂವ್ ಮಾಡಿದ್ದೀನಿ.
ಫುಡ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಹೆಂಗ್ ಕೊಡಕ್ಕೆ?
No, my lord, ಅದ್ರಲ್ಲಿ ಏನೈತೆ ಅಂದ್ರೆ.
ನೋಡಿ ಮಧ್ಯಾಹ್ನ ಬರುತ್ತಲ್ಲ.
ಅದು ಬರುತ್ತೆ, my lord.
ಮಧ್ಯಾಹ್ನ ಬರ್ಲಿ.
ಆ ಟೈಮಲ್ಲಿ ಏನೈತೆ. That
You
my lord,
finish your food and come. We'll decide the food matter.
oblige.
Yes.
An entry matter may be passed in that. 15 days time ಕೊಟ್ರೆ.
ಈಗ ಇಂಟರಿಮ್ ಫುಡ್ ಮುಗಿಸ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ.
Yes.
ಎಸ್.
Yeah, make an appeal to your lord.
May I please, my lord?
Yes, sir.
Serial number
Number
134 ಅಲ್ಲಿ, my lord. Now, I have challenged the charge sheet only, my lord. CC number ಅನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು.
ಆಯ್ತು.
ಅದು 134
ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ಹಾಕುವ ಹಾಗಾದ್ರೆ.
ಅಲ್ಲ, ಅದು ಏನು ಇನ್ಫ್ರಕ್ಚುವಸ್ ಅಂತ ಹೇಳಿದಾಗ ಆಯ್ತು ನನಗೆ.
ಇಲ್ಲ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬರುತ್ತೆ ಬಿಡಿ.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋದು ತುಂಬಾ ಅಗತ್ಯ ಉಂಟು ಸ್ವಾಮಿ. ಯಾಕೆಂತ ಹೇಳಿದ್ರೆ
2 ವರ್ಷದಿಂದ ಬೇಕಾಗಿಲ್ದರೆ ಎಂಟ್ರಿ ಮಾಡಿ.
ಅಲ್ಲ ಅದು ಸ್ವಲ್ಪ
ನೀವೇನ್ ಮೂವ್ ಮಾಡಿಲ್ಲ. ನಾನ್ ತರಿಸಿರೋದು ಕೇಸಸ್ ಎಲ್ಲ ಇವೆಲ್ಲ.
ಅಲ್ಲ, ನಾನು ಅದು ಸುಮಾರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೇನೆ.
ಎಂತದು ಇಲ್ಲ.
ಇಲ್ಲ, ಮೆಮೋ ಸುಮಾರು ಹಾಕಿದ್ದೇನೆ.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ 2.5 3 years ತಗೊಂಡಿದ್ದೀರಾ.
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಸುಮಾರು ಮೆಮೋಸ್ ಹಾಕಿದ್ದೇನೆ ಸ್ವಾಮಿ. ಇಲ್ಲ, ಸುಮಾರು ಹಾಕಿದ್ದೇನೆ.
ಎಂಟ್ರಿ ಮಾಡ್ರ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ನೋಡುವ.
ಅಲ್ಲ, ಸ್ವಲ್ಪ ಒಂದು ಎಂಟ್ರಿ ಮಾಡಿ, ಇಲ್ಲಾದ್ರೆ
ಸ್ವಲ್ಪ ಏನಿಲ್ಲ. 2 ವರ್ಷದಿಂದ ಇಲ್ದಿರ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇವತ್ತೇ ಸ್ವಲ್ಪ.
ಅದ್ರಲ್ಲಿ ನಮ್ದು ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ. A3 ನಮ್ದು ಅದ್ರಲ್ಲಿ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಇಲ್ಲ. A1 ಮತ್ತೆ A2 ವಾಟ್ ಎವರ್ ದ ಇನ್ಕ್ರಿಮಿನೇಟಿಂಗ್ ಮಟೀರಿಯಲ್ಸ್ ಹಸ್ ಬಿನ್ ಸೀಜ್ಡ್ ಫ್ರಮ್ A1 and A2.
ಲಿಸ್ಟ್ ಆನ್ ಯಾವ ಡೇಟ್ ಬೇಕು? 15th ಹಾಕ್ತೇನೆ ಬಿಡಿ.
ಆಯ್ತು, 15th.
I argued sometime in the morning. Number 7, fresh list, my lord. I argued for some time. So, my lord,
You want to argue for some more
I
time?
wanted some more information to collect it, my lord. The advocate on record unable to contact because they are all anticipatory bail is filed, my lord. They are unable to.
ಏನಾಯ್ತು? ಬೇಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ
ಬೇಲ್ ಇವತ್ತಿದೆ,
ರೀಚ್ ಆಗಿಲ್ಲ.
ರೀಚ್ ಆಗಿಲ್ಲ. ಕಾಯ್ತಾ ಇದ್ದೇನೆ. ಇನ್ಫಾರ್ಮೇಶನ್ ತಗೊಳ್ಬೇಕು ಅಂತಂದ್ರೆ ಅಡ್ವೊಕೇಟ್ unable to do it.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕೋಣ.
ಆಯ್ತು, 1 day. ಏನ್ ಮಾಡೋದು?
There is no warrant to grant entry order at this juncture. List the matter.
Date ಕೊಡಿ ಅವತ್ತು.
Post the matter on 23rd for admission. There is no warrant to interdict the proceedings today. Yes. Next.
Voting settlement.
ಯಾವತ್ತು ಇಟ್ಕೊಂಡಿದ್ದೀನಿ? preliminary hearing. B group. Preliminary B group. Yes.
Reporting settlement, my lord. One matter. Please.
Wait, list ಕರೆದು ಬಿಡ್ತೀನಿ.
Please.
ಎಷ್ಟಿದೆ ಫಸ್ಟ್? ಕರೆದು ಬಿಡಿ. ಅದೇ ಸೆಟಲ್ಮೆಂಟ್ ಏನಾ? ಹಾಗಾದ್ರೆ ಇದು ಕರೆದು ಬಿಡಿ, ಮುಗಿಸ್ ಮಾಡಿ.
30 more matters. Fresh matter still number 1. Allah.
For reporting, please, my lord.
ಇದು ಸೆಟಲ್ಮೆಂಟ್.
Responding, filing wakalat.
Parties are brother and sister, my lord. Offense 392 IPC, my lord.
390?
392, my lord.
392.
It was stated as the chain is robbed, my lord. The chain was lost at home, my lord. It has been recovered.
Yes. Brother and sister. ಎಲ್ಲಿದೆ ಸೆಟಲ್ಮೆಂಟ್ ಕೊಡಿ.
I gave just.
ಹಾಕಿದ್ದೀರಾ?
Please, joint affidavits and Aadhaar card.
ಏನ್ ವಿಜಯ್ ಎಲ್ಲಿದೆ? ಏನ್ ಚೈನ್ ಕಳೆದೋಗಿತ್ತಾ?
Please, my lord. Chain was lost and it is.
So and so undertakes to enter appearance ಮಾಡಿ. Yes, next.
Bill number 2, Shri R.V. Gautam.
Now, the petitioner is accused number 2. But it is involved in a business of solar energy production project. But it had entered into an agreement with the state, not for production of solar energy.
The ಲೋಕಾಯುಕ್ತ police are troubling ante adena?
Same thing.
You are not an accused.
No, ma'am, petitioner is accused.
He is an
accused number 2.
Said he is not an accused.
No.
Yes.
He is accused.
All right.
Case is not registered. Case is not registered, but he is an accused.
Case is not registered ಅಂದ್ರೆ?
Not.
Case register ಆಗದೆ accused ಹೆಂಗಾದ್ರಿ?
ಆಗಿದೆ.
ಮತ್ತೆ? Yes.
But annexure B is the order. But that your lordships will find on page 75.
What are you challenging, sir?
But I have challenged on this order, page
Which
75.
order?
Yes.
Which orders?
Page 75, no. The order is register the complaint as PCR and call for status report, etc. Page 75, please, not.
Register the complaint as PCR
Yes.
and call for status report from.
from Inspector of Police,
Lokayukta.
Karnataka Lokayukta.
What's
and
wrong
from
with
there.
this? Special court, huh?
Yes,
What's wrong with this?
but in the first place, not the private complaint, not is not accompanied, not with the order approved under section 17A. But that part,
17A,
not,
ನಿಮಗೂ 17A ಏನ್ ಸಂಬಂಧ?
ultimately, not 120B, not is the offense.
That's a
again.
different thing. ನಿಮಗೂ 17Aಗೂ ಸಂಬಂಧನೇ.
But so far as not.
Are you a public servant?
But I am not the public servant,
yes,
but
sir.
not, will also make kind
You're standing with the public servant doesn't mean that ನಿಮಗೂ 17A ಬೇಕಾಗುತ್ತೆ.
Not 120B, but ultimately, not
120B,
investigation will not be completed.
120B, no problem.
Not there are two petitions not filed by this honorable court. And they are accused number 17 to 22. But your lordship was pleased to grant an interim order.
ಕೊಡಿ. ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, madam, I agree.
ಯಾರಿಗೆ? ಲೋಕಾಯುಕ್ತ.
But the other
ಯಾರಿದ್ದಾರೆ?
side,
ಯಾರಿಲ್ಲ? 230 ಮೂವ್ ಮಾಡಿ ಕಾಪಿ ಕೊಡ್ಲಿಲ್ವಾ ಇಲ್ಲಿ? ಸ್ಟೇಟ್ಗೂ ಕೊಟ್ಟಿಲ್ವಾ?
state ಕೊಟ್ಟಿದೆ.
ಸ್ಟೇಟ್ ಇಲ್ವಾ
It is,
ಇದರಲ್ಲಿ?
sir.
State is not there.
Advance copy, sir.
As a
But respond number 1, what is the.
ಅದು ಧಾರವಾಡದ ಇದ್ದಂಗಿದೆ ಇದು.
But one accused not had preferred not writ petition. In Dharwad court, not other accused not they had filed writ petition on the file of this honorable court. I have.
17A ಇಲ್ಲ ಅಂತ.
ಹೌದು, ಇದ್ರಲ್ಲಿ.
Correct.
So far as not
ನಿಮಗ್
they are
ಸಂಬಂಧನೇ.
concerned,
ನಿಮಗ್ ಬರೋದೇ ಇಲ್ಲ.
but that is my first submission. Not my next submission is, not similar allegations not are against, not against the accused. And those cases not were closed not by Lokayukta after
Where?
holding not,
ಆಯ್ತು, ವೇರ್ ಇಸ್ ದಟ್?
not that I have produced not on page 352 and 368.
352 and
368. sir.
ಈಗ ಸ್ಟೇಟಸ್ ರಿಪೋರ್ಟ್ ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ನಿಮಗೇನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
But every now and then, my lord, they are.
Now and then. Then or now?
352. But every
You
now
are
and
being
then.
harassed then or now?
Next. Pardon, but
You are being harassed by the ಲೋಕಾಯುಕ್ತ every now and then ಅಲ್ಲ ಅಂದ್ರಲ್ಲ, ಅದಕ್ಕೆ then or now?
if your lordship kindly turn to note page 368. 368. It is seen from the materials on record that the complainant had written to his authority stating that he intends to withdraw the matter because of the settlement reached. However, later on the rights to state that he has not entered into any settlement, be that as it may. Admittedly, a sum of rupees 2 lakhs has been received.
Where is the complaint?
But complaint is not on page 97. But the main allegation is, not even accepting the allegation, main allegation is that without not obtaining not NA, not for the entire extent of land not in which the project is not likely to be established, but was not obtained. In fact, not the state policy not itself says, but if once not an application is filed, not the project can go on. But main allegation your lordships will find not on page 107. 107. Para 11, please.
No warrant to grant any interim order. Where is the ground?
Not the entire allegations not are totally barred away not and baseless. But so far as not the very same allegations not were considered not by very Lokayukta police after holding not detailed inquiry. But
We'll hear the complaint, no problem. We will issue notice.
not notice can be ordered not, but in the meantime not. since-
Meantime ಏನಿಲ್ಲ.
Like meantime is very important.
Meantime vacation.
No, not what I respect to submit is, not the, even not according to the state policy itself, not. There
There's
is
a
no
ma-
need. No, I will take a lot through that, not order, government order.
No, there is no order against you today for grant of any protection. What is the order that is passed against you?
Case is registered.
Case is registered.
Yes.
Registration of the case ಗೆ ಎಲ್ಲ ಬಂದ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
But without there being not any material so far as not.
ಅರೆ
present
ಇನ್ನು ಸ್ಟೇಟಸ್ ರಿಪೋರ್ಟ್ ಕೇಳಿದ್ದಾರೆ. Case is not even registered.
Registered, not.
ಎಲ್ಲಿದೆ?
I
Where is
read
the
to
FIR?
last page 75.
Sir, Status
now I did.
report by the Lokayukta police. That is how 31/20/23.
Yes,
The order is dated 7/3/2023.
yes, my lord.
ಈಗ almost 2 years ಆಗ್ಬಂದು ಈಗೇನ್ ಪ್ರಾಬ್ಲಮ್?
23, my lord, 23.
23 ಅದು almost 2 years ಅಂದ್ರೆ ಇನ್ 4 ತಿಂಗಳು ಹೋದ್ರೆ.
What I respect to submit is, but the project is complete in the year 2018.
Why have
After
you
lapse of
moved
5 years, the project complete.
Why have you moved it today? 2 ವರ್ಷ ಆದ್ಮೇಲೆ 2 ವರ್ಷ ಸುಮ್ನೆ ಇದ್ರಿ.
Now, my lord, they have not because of not the present situation. Now, my lord, this investigation is taken up now.
So what?
Seriously.
So what? Seriously.
Yes.
ಇಲ್ಲಿವರೆಗೂ ಸೀರಿಯಸ್ ಆಗಿರ್ಲಿಲ್ವಾ?
ಅಷ್ಟು ಇರ್ಲಿಲ್ಲ ಅಂತ ಅನ್ಸುತ್ತೆ.
ಹಾಗೆ let them be serious till due the in the vacation also.
But the very complaint is filed not in the year 23. But that too, not complaint is filed not after lapse of 5 years. But the
All that we will see. ಈಗ ಏನ್ ತೊಂದರೆ ಆಗಿದೆ ಹೇಳ್ಬಿಡಿ.
ತೊಂದರೆ is investigation. But without there being any, but I am made to face not this investigation after lapse of 5 years. Not I have not violated
17
any of
ಏನಾಗಿದೆ ಇದರಲ್ಲಿ? ಇದನ್ನು ಸ್ವಲ್ಪ ಟ್ಯಾಗ್ ಮಾಡೋಣ.
page 400. Not 400 is
We'll tag these petitions.
not your lordship's order.
ಅದು 17 ಅಪ್ರೂವಲ್ ಇಲ್ಲ ಅಂತ.
No, not only that, my lord, your lordship should find it comes the.
Not only that,
First
only
of the
that
complaint
17A.
No, your lordship may kindly see, the first of the complaint which was registered before the Lokayukta on the complete examination of the veracity of the complaint stands closed on 24/10/19. A second complaint comes to be registered before the government, which also comes to the closed on 5/4/23.
Where are those orders?
But I have produced, my lord, I have.
Page.
But I have produced, but that is on page 352 and 368. 352, my lord, is the first order. 352. Page 352, if approved, this complaint may be closed with notice to parties and the file may be sent to the record room after issuing closure notice to the parties.
Who was the complainant there?
But one Basuraj Murad is the complainant. Not same allegations. NA is not obtained for the entire project and that's how that is the first. And the second is, that is page 368. That is the second closure. That your lordship should find not on page 368, para 182. Another complainant. It is seen from the materials or records that the complainant had written to this authority stating that he intends to withdraw the matter because of settlement reached, however, so and so.
We'll tag these petitions.
Pardon?
ಇದ್ರ ಜೊತೆಗೆ
Yes,
ಕರೆಯೋಣ ಎಲ್ಲ.
Yes. You will also be tagged not in the meantime, not interim order may be granted. No.
Interim order will not be tagged. Only petitions.
But if, but your lords may otherwise not grant, no coercive test can be taken so far as the present petitioner.
ಈಗ ಏನ್ ತೊಂದರೆ ಆಗಿದೆ ಹೇಳ್ತಾನೆ ಇಲ್ಲ ನೀವು. ನಿಮ್ಮನ್ನ ಕರೀತಾ ಇದ್ದಾರಾ, ನೀವು ಹೋಗಿದ್ದೀರಾ?
ಹೋಗ್ತಾ ಇದ್ದೀವಿ, ಅಬ್ಜೆಕ್ಷನ್ ಕೊಡ್ತಾ ಇದ್ದೀವಿ. But it in spite of it, it is practically harassment, for no fault of us. But we have not violated.
No fault will see.
Your lords may kindly see, we have
Then no
not
fault liability alone.
violated any of the conditions. I will, if your lordship permit me, my lord, I will read, my lord, the government order.
All right, we'll tag these two. Madam.
Page 158.
We'll tag these petitions.
But page 127 may also be kindly seen, madam.
We heard the learned senior counsel CH Jadhav appearing for the petitioner. The learned senior counsel would submit that this court in so and so criminal writ petitions has passed the following order. He would though contend that the observation with regard to 17A is qua the public servants. The earlier observation would inure to his benefit. The observation is that the identical complaint was entertained and closed by the Lokayukta themselves. No further precipitative action should be taken against the present petitioner. He would submit, though status report is called in the garb of status report, the petitioners are being harassed. Therefore, the petitioner shall cooperate with the investigation, but no precipitative action shall be taken against them till the next date of hearing. List these petitions on 25th.
Please, no, tag with the, not the connected. Tag with the connected petition.
I highlight. Yes.
Abhilash.
No precipitative or coercive action shall be taken. ಎರಡು ವರ್ಡ್ ಜಾಸ್ತಿ ಮಾಡಬೇಡ. Coercive action. Yes.
3.
Dark cell. ಅದು ನೆನ್ನೆ ಜಲ್ದಿ ಎದ್ದೋಗ್ಬಿಟ್ಟೆ ಅದಕ್ಕೆ ಹಂಗಾಗಿ. ಎಸ್ ಎಸ್ ಸರ್. ಸಿರಾಜುದ್ದೀನ್ ಇಲ್ಲೇ ಇದ್ದಾರಾ?
ಸಿರಾಜುದ್ದೀನ್ ಮ್ಯಾಟರ್ ಇದೆ.
ಅವರು ಫುಡ್ ಜೈಲ್ ಫುಡ್
ಅಲ್ಲ ಅದಿಲ್ಲ ಇವತ್ತು ಇದೆಯಾ?
ಅದಿರ್ಲಿ ಬಿಡಿ, ಅದು ಇನ್ನೊಂದ್ ದಿನ ಮಾಡೋಣ. ಅವ್ರಿಗೆ ಇಂಟರಿಮ್ ಫುಡ್ ಬೇಕಂತ ಈಗ.
Which is provided is not proper.
Wait, sir. Wait. Yes. First one by one.
ಅಲ್ಲಿ ಇದು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡುವಾಗ he has not applied his mind.
Where?
Kindly see, my lord, is what the contention of the other side is.
Yes.
No reasons assigned.
Yes.
While making a requisition, my lord, some certain documents were placed before the magistrate, which is not considered.
On what documents did you transfer, sir?
That these are involved in, of course, my lord, nothing in particular about this man. So,
Because the picture went around everywhere and you did this. Is it
the wrong signal, of course.
It sends what, sir?
It could intimidate the witnesses also.
Exactly.
Allah.
What intimidate?
Allah, it could.
You saw this and straight away sent everyone everywhere.
No, it could intimidate the witnesses is what I'm saying.
For what?
To come before the court, to go before the investigating officer, all these, my lord. Therefore.
Where will it intimidate? Because they are seen there.
No, what
That cannot be the reason.
What prejudice would it cause if he is kept in a separate jail?
That's a different
The
thing.
convenience is.
Sir, that's a different thing. Every convict or an under trial has his rights. Prisoners have their rights.
Yes.
Definitely have their rights. But if you want to stifle those rights, it should be in accordance with.
What is the right that he is complaining of?
No, very transfer is what he is challenging.
No, what is the right or the prejudice that is going to
What
be
is
caused to
the
his right?
the transfer that you have made is contrary to law is what is said.
No, law provides, but
Under what provision you can transfer?
Lord, it's the jurisdiction of the magistrate under 167(2) when he remands. He has the control and supervision over the.
Under what circumstances that can be exercised?
Yes, non-application of mind is now there is nothing. We will Lord, let the magistrate pass a fresh order within a couple of days based on whatever requisition we have made. And then.
Where is your requisition?
Lord, requisition is not produced.
But where? Nimatra ilva?
Page number 114 and 115, my lord.
Requisition,
Connector E. Yes, ma'am. Connector E.
114?
114 and 115, ma'am. Connector E.
ವರ್ಗಾವಣೆ ಮಾಡಲು ಅನುಮತಿ ಅದೇನಾ?
Please, my lord. Dated 27/8/2024. List all the accused. ಮುಂದುವರೆದು
ದೃಶ್ಯ ಮಾಧ್ಯಮ ದಿನಪತ್ರಿಕೆಗಳಲ್ಲಿ ಸಹ ಸೋಣ್ಸು ದಸ್ತಗಿರಿಯಾಗಿರುವ ಆರೋಪಿಗಳು ಮೇಲ್ ಕಾಣಿಸಿದ ಪಟ್ಟಿಯಲ್ಲಿ ನಮೂದಿಸಿರುವ ಅಂಡರ್ ವಾಟ್ ಪ್ರೊವಿಷನ್ ಸರ್ ನಾವು? You submit a requisition and the magistrate passes an order.
Yes.
Neither the requisition has some application of mind nor the order of the magistrate.
Lord, manual, of course, correction manual provides for it. But then the Supreme Court would say.
What Supreme Court says?
The one which is cited It is the jurisdiction of the magistrate and not the prison authorities when he is under trial. This is what
All
in
right, now
effect.
magistrate
yes,
has passed an order.
Yes, magistrate has passed an order. Now, what is the basis for the magistrate to pass the order is the question.
Is your
That
requisition.
is my requisition. Whether he has.
What is the basis for requisition is the photograph.
Yes, photographs.
Can
And-
that result in this?
Yes, my lord, inside the prison, if something like this happens and.
What has happened?
My lord, where the crime is registered against them.
All right, what
for
has happened
certain
inside the
offences,
prison?
For certain offences,
What
which is
offense?
violative of prison.
So
rules
what
and
has
man-
happened?
The pictures which are shown,
All right. Holding a cigarette.
holding a cigarette,
Chewing tambak and kanalla ಅಲ್ಲಿ
No.
cigarette matra.
the
Hold it.
audacity that is conveyed,
No, that's all right.
the audacity which is
Holding a
conveyed,
cigarette. Who is
might
responsible?
hold against everything. my
Who
lord.
is responsible?
They-
What action have you taken against the jail authorities?
They are, my lord.
What action have you taken against them?
Under investigation. They are also.
What
under
investigation? In crime register ಮಾಡಿದ್ದೀರಾ? Departmental enquiry
Departmental
ಮಾಡಿ.
enquiry
ಎಲ್ಲಿದೆ? Where is the show cause notice issued or
Next
charge sheet filed?
The preliminary inquiry is that because it could be.
Where is the show cause notice issued to them? In the least, to those jail authorities, how did you let the cigarette come in?
They itself sell the cigarettes, my lord.
ಅದು ಗೊತ್ತು ಸರ್, ನೀವು ಎಲ್ಲ ಓಪನ್ ಆಗಿ ಹೇಳ್ಬೇಡಿ, ಸುಮ್ಮನೆ ಇರಿ.
No, it appears crime is also registered against the prison authorities.
Where?
I will place that.
Place it.
Produce the copy of the FIR.
ಯಾರು ಅವ್ರ ಮೇಲೆ ಮಾಡಿದ್ರು?
ಅವ್ರ ಮೇಲೆ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, ಅದು
ಬೇರೆ
ಇವ್ರ ಮೇಲೆ
accused
first
ಯಾರ
ಮಾಡಿದ್ರು.
ಮೇಲೆ ಮಾಡಿದ್ರು?
ಅಲ್ಲಿ ಜೈಲ್ ಅಥಾರಿಟೀಸ್ ಮೇಲೆ ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲ?
ಅದೇ ಅದು ವೆರಿ ಡಿರೆಲಿಕ್ಷನ್ ಆಫ್ ಡ್ಯೂಟಿನ ಅಲ್ಲ ಕ್ರೈಮ್ ಕಾನ್ಸ್ಪಿರಸಿ ಇದೆಯಾ ಅಂತ ನೋಡಿದ್ರು ಒಂದು ಪ್ರಿಲಿಮಿನರಿ ಎನ್ಕ್ವೈರಿ.
Dereliction of duty departmental enquiry.
ಅದಾಗುತ್ತೆ.
Where is it?
Now crime is registered.
ಹಾ,
The matter where the prison officials were asking for quashing of FIR.
ಇದ್ರದ್ದೇನ ಅದು?
So
ಸ್ಟೇ ಮಾಡಿದ್ವಾ?
ಇಲ್ಲ, ಇಲ್ಲ.
ಎಲ್ಲ ಫ್ಲೋ ಅಲ್ಲಿ ಏನಾರು ಆಗ್ಬಿಟ್ಟಿದೆ?
So all these
Lordship particularly said that they, in fact, the order of your lordship with respect to not this matter, not to investigate, but then your lordship got shocked to see whether what is the matter. Then your lordship did not have.
ಎಸ್ ಎಸ್ ಸರ್,
ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಇದೆ.
ಅದೆಲ್ಲ ಇದೆ.
They are all even especially this petitioner wields a lot
ಇದೆಲ್ಲ ಇದೆ.
ಅಲ್ಲ lot of influence
ಈಗ
ಯಾಕಂದ್ರೆ
ಸಿಗರೇಟ್ ಒಳಗ್ ಬಂತು ಅಂತ ಹೇಳ್ತಾ ಇದೀರಿ. Why you still have smoking zones in your jail?
ಅದು ಹಳೆ ಮ್ಯಾನ್ಯುಯಲ್ ನಾವು
ಯಾಕೆ?
ಈ ಅಲ್ಲ ಆವಾಗ ಬ್ರಿಟಿಷರ್ಸ್ ಇದ್ದಾಗ ಮಾಡಿರೋ
Why ಈಗ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಅಂತ
ಚೇಂಜ್ ಮಾಡ್ಬೇಕು
ವೈ ಮಾಡಿಲ್ಲ?
ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಇದನ್ನ ಕ್ರೈಮ್ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಸಿಗರೇಟ್ ಒಳಗಡೆ ಇದೆ ಅಂದ್ರೆ ಕ್ರೈಮ್ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ,
ಅಲ್ಲಲ್ಲ.
ಬಿಕಾಸ್ ಯು ಹ್ಯಾವ್ ಡೆಸಿಗ್ನೇಟೆಡ್ ಸ್ಮೋಕಿಂಗ್ ಝೋನ್ಸ್.
ಅಲ್ಲ ಬಟ್ ರೂಲ್ಸ್ ಡಸ್ ನಾಟ್ ಪ್ರೊವೈಡ್ ಫಾರ್ ಡೆಸಿಗ್ನೇಟ್ ಮಾಡಿದೀವಿ. ನಿನ್ನೆ ಅಂತ ರೂಲ್ ಇತ್ತೋ ಇಲ್ಲ ನಾಳೆ ಅಂತ ರೂಲ್ ಬರ್ಬೋದೋ, ಈಗ ಡೆಸಿಗ್ನೇಟ್ ಮಾಡಿದೀವಿ ಅಷ್ಟೇ.
ಇನ್ ಆಂಟಿಸಿಪೇಷನ್.
ಅಲ್ಲ ಇಟ್ ಕುಡ್ ಬಿ ಬ್ರಿಟಿಷರ್ಸ್
ಅದನ್ನ ನೀವು ಫಾಲೋ ಮಾಡ್ಬೇಕು ಅಂತಿಲ್ಲ.
ಇಲ್ಲಿ
ವೆನ್ ದಿ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಕ್ಲಿಯರ್ಲಿ ಸೇಸ್ ಸ್ಮೋಕಿಂಗ್ ಇಸ್ ಕಂಪ್ಲೀಟ್ಲಿ ಬ್ಯಾಂಡ್, ಹೌ ಕ್ಯಾನ್ ಯು ಹ್ಯಾವ್ ಸ್ಮೋಕಿಂಗ್
just remove those provisions.
smoking zones in the prison? And if you have smoking zones in the prison,
Doesn't
how
mean-
can you hold someone responsible
mean-
for holding a cigarette?
If I have a zone, unless I permits smoking,
Who permits, sir?
Oh.
ಇವ್ರು ಎಲ್ಲಿಂದ ತರ್ತಾರೆ?
ಅದು ಬೇರೆ ವಿಚಾರ.
ಅದೇ ವಿಚಾರ, ಬೇರೆ ಅಲ್ವೇ?
There is what is called the Karnataka prison rules. Karnataka prison
ಎಲ್ಲ
act.
ರೂಲ್ಸ್ ಬಿಡಿ.
Prisoners-
How do the prisoners get cigarette
There
inside
are
the
in all about 6 acts. ಇದನ್ನೆಲ್ಲ
acts ಬಿಡಿ sir?
ಅದೇ.
How do the prisoners get cigarettes or other things inside the prison?
it is in conspiracy with the
Without
inmate
the,
also. Inmate also.
without the connivance of the jail authorities, can it happen?
ಹೌದು.
Can it happen?
ಅಲ್ಲ it could happen otherwise by the food being brought by somebody else. Where
ಯಾಕೆ
dereliction-
ಸ್ಕ್ಯಾನರ್ ಇಲ್ವಾ?
Scanner.
Not allowed from 4 years, my lord.
Huh?
From 4 years, food is not allowed.
ಸರಿ, ಆಲ್ ರೈಟ್. ಫುಡ್ ಇಸ್ ನಾಟ್, ದಟ್ಸ್ ವೈ ಹಿ ಇಸ್ ದೇರ್.
ಅಲ್ಲಲ್ಲ ಅವ್ರಿಗೆ ಫುಡ್ ಏನಾದ್ರು ಹೋಗ್ತಾ ಇರ್ತದೆ ಅದೆಲ್ಲ ಬಿಡ್ತಾರೆ.
ಹೆಂಗ್ ಹೋಗುತ್ತೆ? ನಾಟ್ ಅಲೌಡ್ ಆದ್ಮೇಲೆ ಹೆಂಗ್ ಹೋಗುತ್ತೆ?
ಫುಡ್ ಸರ್ಟನ್ ಥಿಂಗ್ಸ್ ಆರ್ ಅಲೌಡ್.
ವಾಟ್ ಇಸ್ ಅಲೌಡ್?
ಅಲ್ಲ ಫುಡ್ ಪರ್ಮನೆಂಟ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ
ಎಲ್ಲಿದೆ? ಇಲ್ವಾ ರಿಕ್ವೆಸ್ಟ್ ಅಲ್ಲಿ?
ಯಾರು ಕೊಡ್ತಾ ಇಲ್ಲ?
ಅಲ್ಲ ಅದಕ್ಕೆ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ.
ಏನು ಫುಡ್ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತನಾ?
ಅಲ್ಲ ಇವರು ಬೋತ್ ಡೆರಿಲಿಕ್ಷನ್ ಆಫ್ ಡ್ಯೂಟಿ ಅಲ್ಲ, ಇದು ಕಾನ್ಸ್ಪಿರಸಿ ಕೊಲ್ಯೂಷನ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಸೊ ಅದನ್ನ ವಿ ವಿಲ್ ಲುಕ್ ಇನ್ ಟು ದಟ್.
I'll tell you, if you dig deep into it, it gets
Yes.
terribly murkier.
ಅಲ್ಲ should
Many skeletons will come out of the cupboard.
lot of skeletons is
Yes.
always there. ಕಬೋರ್ಡ್ ಅಲ್ಲಿ ಅದನ್ನ ಓಪನ್ ಮಾಡಿದ್ರೆ
ಅದಕ್ಕೆ
skeletons ಬಹಳ ಇದೆ.
ಅದಕ್ಕೆ ಈಗ we will concentrate on this
Yes, this
and set this aside and leave the law to take its course.
my
This
only
This is a perfect case where the impugned order is set asideable.
I can only defend saying that they sends a wrong signal to the
What
Yes.
signal, sir? ಈಗ ನೀವು ಮಾಡಿರೋದು wrong
ಅಲ್ಲ,
signal ಅಲ್ವಾ?
not your lordship judgment.
ಮತ್ತೆ?
The acts of the
Exactly, I'm going to observe that if cigarette is banned in prison, you still have a smoking zone. If you still have a smoking zone, there are smokers. If there are smokers, how does the cigarette come into the prison?
No, I can have so many zones. But if the rules
Why
does
do,
not.
why do you want to keep the zones?
No, the zones were there when the cigarettes were permitted. Let us assume that.
No,
those days
no,
were
cigarettes are not permitted. Your rules,
permitted.
your rule is not amended. It still shows zones.
Yes, we are in the process of amending the act itself.
Act itself.
Yes,
ಯಾವ
now.
10 years ಇಂದಾನ ಈಗ್ಲ?
ಅಲ್ಲಲ್ಲ ಈಗ
ಈಗ.
ಹೊಸ ಪ್ರಪೋಸಲ್ ಬಂದಿದೆ.
ಹಾ.
So ಅದಿನ್ನು 2-3 months ಅಲ್ಲಿ ಆಗುತ್ತೆ.
All right.
So therefore, all this, of course, there is no application of mind. ಅದೊಂದೇ, but the apprehension is that is all. That these can do anything inside the jail with the connivance of the authorities.
Exactly. That's
ಹೌದು.
the submission.
Where ordinary prisoners will not be able to do.
In
And
fact,
won't
I am
be
the,
able to smoke.
my lord, in fact, I am the ordinary prisoner here.
No,
I'm getting
he's
the
the man
celebrity.
who's attempted to destroy evidence with 30 lakhs was found from him.
My lord,
It was the
my
main one.
deed-
Accused number?
14.
my lord, my deeds outside outside the prison and inside the prison have to be taken
He will
independently.
destroy evidence.
Just because I'm been under trial, I'm an under trial prisoner for one particular offense, that doesn't mean anything that happens in the prison, I will be held responsible despite.
ಇವರೇ ತಂದ್ಕೊಟ್ರು ಅಂತ
ಏನೂ ಇಲ್ಲ ಸ್ವಾಮಿ, ನನ್ನ ಮೇಲೆ ಏನೇನೂ ಇಲ್ಲ.
30 lakhs he was
Or
found.
was he there sitting with him?
No, he was not.
He was not
He
there.
was not. No, 30 lakhs was recovered from him.
But that is all right. He is facing trial for that.
Hundreds of
ಏನೋ
reasons
ಭಾಷೆ ಕೇಳ್ತಾ
other
ಇಲ್ಲ
under
ಇದು.
trial prisoners are there.
ಹಾ?
ಎಲ್ಲ hundreds of prisoners are there for different reasons in the
That's
prison.
all right. ಅದಕ್ಕೆ ಕ್ವಾಶನ್ ಕೇಳ್ತಾ ಇಲ್ಲ ಇಲ್ಲ.
With reasons they are there. Different reasons, of
Different
course.
reason
It's
I'm there.
also
This
there for
cannot
some
be the
reason.
reason.
Yes, yes.
Whether his shifting is with reason or not ಅಂತ ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
If they bar smoking,
could be.
they cannot control the prison, my lords.
Huh?
If they stop smoking, they cannot control the prison. First, staff will only. Smoking is not, it may be injurious to health, but it is not a big offense, my lord. Yeah, because all the criminals,
So I don't know how he knows.
no, the police will, I know everything, sir, because the police cannot.
How do you know everything?
That's, I have faced everything, my lord.
Faced everything.
Yes. No, my lord, without the prison authorities' permission, the cigarette.
And
and
that
the
is
will
there.
not go, my lord.
Without SPP sir, without the connivance of your authorities, nothing will go in. Not here, not in remand homes.
Not for a moment I will
No,
say,
not
deny
here and not in remand homes. ಇಲ್ಲ.
The mobile phones are also allowed. The mobile, the possession of prohibited articles, they will book a case for the person who is in possession. Even the prohibited articles like ganja and all, if a person is found in the possession, he is booked. While the transportation of the prohibited articles, he should also book under NDPS Act also. There are so many officers involved. Some officers with Karnataka State Industrial Security Force who are in charge out of the prison, they are allowing the prisoners to.
Wait, we'll see.
No, I will not for a moment say there is no corruption. Corruption is rampant there. Corruption is everywhere. But where is the remedy, my lord? To balance it, my lord, we cannot check corruption at every point.
No, it's.
To eradicate corruption is something.
No, we are not here in a
Even in the
no,
greatest.
speaking forum about corruption,
Yes, yes.
sir.
Greatest
Not
of
that.
economy, even US, you'll find
That's all
corruption.
right. No, we are not on that.
More,
We
yeah.
are on the
On a
present
case basis,
case.
on a case basis, what I'm saying.
We are on
is-
this case, there is blatant non-application of mind
Yes, by the
in
magistrate.
making a requisition and the magistrate passing an order. The order on the requisition will go,
Yes, yes.
has to go.
Yes.
One
But,
submission. And SPP suggested that the matter may be remanded back for fresh hearing. The apex court judgment which I furnished on the last date. of
ಯಾವ್ದು
hearing-
ಕೊಟ್ರಿ ಇಲ್ಲಿ?
State of Maharashtra.
Marathra,
Yes.
Said Sohail.
Please, my
Ah.
lord. In that, my lord, the High Court itself had directed for retransfer, which was confirmed by the Supreme Court. So this honorable court itself can pass the order.
We'll
as
see,
my
we'll see. Yes.
submission.
Ashta will do that. Set it aside, follow this judgment and
And we
allow
will,
law to take its course.
with the
Law to
liberty-
take its course the way the apex court has held.
with liberty for the prosecution to.
With
make
liberty
such
you'll have,
application.
I will, for just follow this judgment,
No, that
the
shouldn't,
state of Maharashtra's
Yeah.
judgment.
yes, I'm sorry. That shouldn't put stop for us to make a requisition before the court.
You make any requisition.
Yes.
See, you should penalize the persons who are found there,
Yes, no.
accused 1, 2, 3 or whatever. En masse, how can you send everyone?
ಅಲ್ಲ ಎನ್ಮಾಸ್ ಅಂದ್ರೆ ಆ ಇದ್ರಲ್ಲಿ ಕ್ರೈಮ್ ಅಲ್ಲಿ ಇದ್ದವ್ರನ್ನ
ಆಯ್ತು, ಏನು ಅವ್ರು ಕ್ರೈಮ್ ಅಲ್ಲಿ ಕಾನ್ಸ್ಪಿರಸಿ ಮಾಡ್ತಾ ಇದ್ರ ಅಲ್ಲಿ? Were they creating problem for the witnesses? Were they creating problem for the jail authorities?
No,
No, were they doing such things?
No, that
ಇಲ್ಲ ತಾನೆ?
action itself would.
Action
the
itself.
apprehension, the
Who was in the action? Accused 1, 2 or 3, whoever it
No,
is.
inside
All the
the-
14 accused you transfer?
Alala, that group with audacity, if you can send messages
Who has sent?
to the
Who has sent?
media.
Who has sent? Has he sent it?
No,
Do you have any prima facie material that he has sent it?
Even
He
one
was somewhere
material
else in some other cell.
No, the main accused.
Main accused. You transfer him, no problem. If he is found in possession of a cigarette or whatever and unexplainable, you do it. But why all the persons who are somewhere else in some other prison, some other cell rather, or see, they are not in the scene, they are not involved in anything, or no tagda.
Of course, they are in some other cell, but they get to meet.
Sir, what triggered the situation, Lauridara? He is in some other cell.
No, we have said in so many words that they could be a threat because they have conspired and.
ಅದಕ್ಕೆ ಏನು no material for that at all.
Yes, yes.
No material.
No
It
material,
is
no
not
supporting
correct.
material, except.
And there is
the
an
crime
interim order
register-
granted, by then he was in transit.
Yeah, well, that of course, he was in transit and the order was
Call
made
it back.
2 days prior to the passing of the order by the Supreme Court. There is no intention to hurry up. On the day of the interim order passed, he was
And what
underway
is this
at 3:30 in the morning.
affidavit to dark cell ಹಾಕಿದಿರಲ್ಲ, right?
ಹಾಕಿದ್ದೀವಿ. That he is not complaining about now.
No dark cell ಈಗ.
My lord, page number
But it
17
has
of the,
dismissed with cause
my lord,
ಏನು?
of
Malad.
the affidavit.
my lord,
ಈಗ
very same submission, my lord, may be noted. My lord, page number 17 of the affidavit.
You
my lord.
still want to
I'm-
pursue
I-
that application?
ಒಂದ್ ನಿಮಿಷ,
Affidavit, we will.
17 ಏನು?
My lord, page number 17 of the statement of
I am
objection,
there
the
only,
affidavit.
please. Hmm.
My lord, top and corner, my lord. It's written in, it's been written in marker.
Ah.
That explains my entire affidavit, my lord.
Yes, sir.
Yes, Lord.
ಇದೇನು ಮುಂಬೈ ಅಂಧೇರಿ ಅಲ್ಲ ಇದು.
Except for the dark cell, that's the only other reference of Andheri
the-
I can take. Sir,
Page 17.
Page 17 of
What is the indication
affidavit,
there?
sir. Top and
Top corner.
the affidavit
SPP, sir,
itself
is it?
says, I'm put
Here.
in a single cell.
ಅಂಧೇರಿ.
How many under trial
Name is
prisoners?
there.
Name is there.
Name is there. Name in the.
Correct.
ಅವ ಬ್ರಿಟಿಷರ್ಸ್ ಇಂದ ಅಂಧೇರಿ ಅಂತ ಬರೆಯೋದು ಆ ಸೆಲ್
ಅದೇನು
ಹೆಸರು.
ಮುಂಬೈ ಅಂಧೇರಿ ಅಲ್ಲ
Let
ಇದು.
him swear to an
Cell ಅಲ್ಲಿ
affidavit.
ಕೇಳ್ತಿರೋದು.
Let
No,
him
no, no.
swear to, yes.
Sir, why have you endorsed this as ಅಂಧೇರಿ?
No, I mean.
Why have you endorsed it as ಅಂಧೇರಿ?
No, Andheri is that block is Andheri during
ಅದೇ
the.
ಕೇಳಿದ್ದು ಮುಂಬೈ ಅಂಧೇರಿ ಹೇಳ್ದಂಗೆ ಹೇಳ್ಬಿಟ್ಟು
ಅವ-
ಜೈಲಲ್ಲಿ.
ಇಲ್ಲ,
Yes.
let him say
ಹಾ.
one word that I was put in a dark cell. It was all based because as the inmate was being transferred from Bangalore to
No,
Belgaum.
ಬೇರೆ inmates transfer ಎಲ್ಲಿದೆ requisition?
My lord, it's
Give me the inmates
No,
transfer
their
requisition.
requisition.
same requisition, my lord.
Same
Page number
requisition. ಎಲ್ಲರಿಗೂ
114.
ಅಂಧೇರಿ ಅಂತಿದ್ಯಾ?
ಇಲ್ಲ ಇಲ್ಲ their respective prisons they have been sent, my lord.
ಇದು
I am housed
ಮಾತ್ರ
only in this prison.
It is
This
only
prison.
based on this, he would build a story.
My lord,
Yes.
Lord, my IA,
Correct.
my lord, my IA, when I say that there's a Deccan Herald article, they say I build a story on that.
Yes.
Now I show their own affidavit and their document, they say I build a
Okay.
story.
Let him say.
How should an under trial
What
prisoner in
is
prison
it
prove his case,
different
my lord?
from other cell? If he says that,
Shall I
no,
submit,
then
my lord?
let him say.
The difference, my lord. Shall I submit, my lord? That Andheri cells, they don't have any bathroom.
ಅದು ಗೊತ್ತು ಸರ್.
Yes, my lord. That
Wait.
21st
Let him say that. Let him say that. Let him
21st
swear to an affidavit, except saying.
ಆಲ್ರೆಡಿ
Andheri-
sworn sir.
Not,
Is already sworn. ಅದಕ್ಕೆ ಕೌಂಟರ್ ಹಾಕಿದ್ ನೀವು.
yes, my lord, let there be an inquiry.
You are caught in contradiction in the counter.
Yes,
Yes.
let there be
Yes.
inquiry by the.
No
Supreme-
problem. Yes.
No. I want, if he is pursuing this application, he did not open his mouth today with regard to his affidavit. Why? Because he knows it is not a fact. Now he is sworn to a wrong affidavit. Let there be an inquiry, but not for perjury. I will file an application under 340.
First get over your action of transfer
Transfer. That's
without
fine.
application
That's
of
fine,
point.
that's fine, that's fine.
Perjury ಆಮೇಲೆ ನೋಡೋಣ.
ಆಯ್ತು.
Yes.
ಈಗ ಅವ್ರು if he wants to pursue that
No,
application.
this observation I will have to make because why is the communication to the Kalburgi cell depicts him to be Andheri.
Andheri is the name of the cell. Doesn't mean that it is dark and without a toilet.
Andheri is the name of the cell.
Yes.
All right.
Yes. Don't let him not harp on that. If he's harping on that,
My
let
lord,
there be an inquiry.
my lord, I did not, my lord. They wanted,
yes.
they asked
Now,
for an
So
explanation.
is he going
I-
back? Is he going
No,
back?
my
on
lord,
that?
I'm not going back, my lord. I'm clear on my
That's what
stand.
the affidavit.
I am not, my lord. Why am I being told
Why
that
is
I
it-
am going back? I am
No,
not.
One minute, 1 minute. SPP sir, first day I told you. Offense is the best force of defense, but it will not work here.
No.
Yes.
Let there be an inquiry. I'm willing to. Let there be an inquiry if there is an under cell and if it is different from other cells, my lord, we will face the consequences. Your lordship may take action. As otherwise, action should be taken against him. He is not willing to pursue that affidavit.
My lord, how many under trial
is not.
prisoners? Why is
Let him
my
pursue.
SCP telling
All
that
right, wait.
I am not ready to pursue? That is the
Yes.
question. Why is he telling whether I have not made the submission to the court,
Okay.
telling that I am
No,
not
he-
willing to pursue?
No, he said he is only.
My lord, my intention of this petition is to get a retransfer. my lord.
retransfer. That's all.
That's the intention of the petition. But
Matter was-
how
matter-
I'm being
Get a
held up
retransfer.
Retransfer.
But how-
Andheri to Ujala.
Andheri to open.
to Ujala?
Leave it. We'll do it.
Please,
14th.
please,
We'll release it on 14th.
please.
Next. Prasanna Kumar. ಇದು ಮೂವ್ ಮಾಡಿದ್ರೆ ಮೇಡಮ್ 26th BB Patil is directed to accept notice for the respondent. ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಒಂದು ಆರ್ಡರ್ ಇದೆ. ಎಸ್
Number 5.
Sarvan.
For the petition number. Says section 7 of PC Act. My lord,
When?
state charge sheet has not filed, my lord.
Same 26th same order. Sachin,
Much of this.
grounds of arrest. ಕೊಡಿ ಅದ್ಯಾವ್ದು ಜಡ್ಮೆಂಟ್ ಇದೆ ಅಂದ್ರಲ್ಲ.
I have challenged the remand order.
ರಿಮಾಂಡ್ ಆರ್ಡರ್.
Yes, on application and it is passed mechanically.
ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್ ಬೇಡವಾ?
That is one of the ground under which I have taken.
376 POCSO. Offense ನೋಡಿ ರಿಲೀಫ್ ಕೊಡ್ಬೇಕಾ ಅನ್ಸ್.
1 year, my lord,
ಯು ಆರ್ ಅನ್ ಅಸ್ಟ್ರಾಲಜರ್. ಅದೇ ಅಲ್ವಾ?
1 ವರ್ಷದ ಹಿಂದಿನ ಇನ್ಸಿಡೆಂಟ್. That is the reason why I am.
1 ವರ್ಷ?
1 ವರ್ಷದ ಇನ್ಸಿಡೆಂಟ್ belatedly they filed it. No parents will keep mum by not filing a complaint. And she is also suffering from ill health and
Giddiness.
ill health ಅಂತೆಲ್ಲ ಹೇಳ್ತಾರೆ. Even before incident, even after incident also belatedly she was admitted in the hospital.
ಅಲ್ಲ ಇದು ಜಗದೀಶ್ ಸರ್, ಕಂಪ್ಲೇಂಟ್ ನೋಡಿದ್ರೆ ನೀವು ಇವ್ರೇನೋ ಒಂದು ಮಂತ್ರ ಹೇಳ್ಕೊಟ್ರಂತೆ. ದೇರ್ ಆಫ್ಟರ್ ವೆನ್ she was made to chant this shloka, she suffered giddiness 1 year ago. ಅದು ಕಂಪ್ಲೇಂಟ್. Anyway, we are on grounds of arrest. ಕ್ವಾಶಿಂಗ್ ಅಲ್ಲ. ಜಡ್ಮೆಂಟ್ಸ್ ಕೊಡಿ. ನೀವ್ ಯಾವ ಗಿಡ್ಡಿನೆಸ್ ಶ್ಲೋಕ ಹೇಳ್ಕೊಟ್ರಿ?
That's what the complaint says.
ಜಡ್ಮೆಂಟ್ಸ್ ಕೊಡಿ ಜಗದೀಶ್.
3 judgments I rely on, my lord. Before going there, my lord, may.
ಅಲ್ಲ ಆಫ್ಟರ್ ಪ್ರವೀರ್.
No, there is that one context, my lord. I address this issue, my lord. The Praber is.
It was PMLA.
PMLA and UAPA and section 41A and section 41 and 50 of CRPC, your lordship may have to see. These judgments are in fact Praber, my lord, though section 50 was advanced. Supreme Court doesn't pass any order on 50. They only purely go on the question of PMLA itself, because there the language used is something else. In fact, these 3 judgments, my lord, is extensively deals with this issue.
ಎಲ್ಲಿ ಪ್ರವೀರ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ?
Prabir is a part of record. They are relied upon full court judgment of Apex Court.
ಒಂದ್ ನಿಮಿಷ.
Page 58, para 20B looked into, my. Article 22 applicable to all offences is what I want to point. Para 20, page 58. Page
All right.
58, Prabir though. Page 58, my lord's got it. Page 58 of the.
I am there.
In that, para number 20.
Yes.
resultantly, there is no doubt in the mind of the court that any person interested for allegation of commission of offence under the provisions of UAPA
or for that matter,
or for
any
the
offense
offences.
has a fundamental, sir, fundamental rights.
We'll come there, my lord. In fact, this judgment deals with the fundamental rights issue, my lord, where Article 22.
It is fundamental sir, to every case.
Yes, yes. I have no request your lordship to UAPA, my lord, section 43B.
Really, I'm aware of that. Tell me.
Any person any officer arresting a person under section 43A shall, as soon as may be, inform him of the grounds of such arrest. The issue, my lord, there was inform him on the grounds of arrest.
So it is statutorily prescribed.
Yes.
All right.
Now your lordship may see section 41B of CRPC, my lord. 41B of CRPC. 41B, bare accurate, etc.
Procedure for arrest.
Yes, my lord. C, my lord. C.
Inform the
person arrested, comma, unless the memorandum of attested by a member of his family that he has a right to have a relative or a friend named him to be informed in his arrest. So what is required is this one. The language used in UAPA and language used in section 41B are extremely different languages. In fact, this issue, my lord, now your lordship may see section 50. They are relying on section 50 of CRPC. Let's see section 50, my lord. What does section 50 say? Person arrested to be informed of grounds of arrest and of rights to bail. Every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offences for which he is arrested or other ground for such arrest.
Yes.
What is required, my lord? We have to inform him why we are arresting him.
Yes.
Or other grounds of arrest.
So information saku nim prakara.
Information is enough. In fact, these three judgments, my lord, may request your lordship to the Maharashtra High Court, Bombay High Court judgment, my lord, the first judgment which I placed on three judgments.
ಕೊಟ್ಟಿದ್ದೀರಾ?
1998 Maharashtra Law Journal.
ಈಗ ಕೊಟ್ಟಿ.
Yes, sir. Para 13, my lord, is Para 13, my lord.
Yes.
Now, as far as contentions of so-and-so regarding requirement of provisions of section 50 of the Code of Criminal Procedure Code being interpreted in the light of provisions of Article 22(5) is concerned, I think the submission cannot be accepted. There's a basic and fundamental difference between the person detained, because detained, my lord, is section 22 has been applied in preventive detention law. So that is where, my lord, the Article 22 issue is brought in here. Person detained under the provisions of law providing preventive detention and detention of person arrested.
Yes.
On acquisition of commission of offense. In these cases, in the case of preventive detention, the person is detained without trial and he has only the right to make a representation. The purpose of communication of the ground to the detainee to enable him to make a purposeful and effective representation. Therefore, under Article 22(5), the basic facts constituting the ground have to be imparted effectively fully to the detainee in a written, in writing, in a language which he understands. Now, therefore, my lord, thereafter, my lord, the para 14, my lord, in the next page, they goes into the entire preventive detention laws and section 50. And then para 14, my lord.
Yes.
As far as these cases relied on by so-and-so and referred to above by me are concerned, with great respect to the learned judge, I am unable to subscribe to the view of the view that the non-compliance with provisions of section 50 of the Code of Criminal Procedure renders the arrest of a person concerned illegal. At best, further detention without complying with provisions of section 50 may become illegal. However, in view of the fact that I'm holding that the fact of the case before me, provisions of section 50 of the Code of Criminal Procedure are fully complied with, it is not necessary for me to decide is this issue in effect of non-compliance of provisions there itself. Now, the second judgment, my lord, is of 1995, SCC online.
Yes.
This is the full bench judgment of Allahabad High Court. Para 16, my lord. I'm sorry, para 14, my lord.
This interpretation of section 50.
Yes, my lord. The next question, which is referred to as whether it is duty of the prosecution to prove compliance with
So these are all law which is long before Prabir.
No.
Is it whether Prabir should be made applicable to all cases?
No, my respectful submission. In fact, my lord, Prabir also, my lord, your
No,
lordship.
Prabir, PMLA also says grounds of arrest and
Yes,
UAPA also
Yes,
says.
my lord. And more in the one other judgment, my lord, Allahabad High Court, para 21, 1998, my lord, your lordship may see para 21. Para 21, my lord, section 50 of the CRPC states that every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offences for which he arrested or other grounds of such arrest. This provision flows from a Constitution of India, provided in Article 22. This article protects a citizen against arrest, detention, certain cases, and states that no person who is arrested shall be detained in custody without being informed as soon as may be for the grounds of such arrest. The article further requires that every person who is arrested or detained in custody shall be produced before the nearest magistrate within the period of 24 hours of such arrest, excluding the time necessary for the journey so-and-so from the place of arrest to the court of magistrate. Article 20 of the Constitution protects personal liberty to the citizens and state that no person shall deprived of his life or personal liberty except according to procedure established of law. Section 50, subclass 1, CRPC. In such a procedure established by law, and it echoes the requirement of Article 22 that person after being arrested, it is be informed the grounds of such arrest. It was urged merely stating that petitioner was being arrested under so and so was not sufficient as no gun was required, etc. Then your lordship may see the para 24. Under these circumstances, in our view, even the petitioner was told that he was being arrested for an offence punishment of section 307 of IPC.
Now this is 376 POCSO.
Yes, ma'am.
What is to be complied is 50.
Yes, my lord. Section 50 says, my lord, we have to inform him.
We'll
We have
see
given
discussion.
the
Anything else?
Page 59. Page 59, Prabhu's case judgment.
Yes.
Where the Supreme Court has relied upon Constitution bench judgment. Page 59, para 25.
Yes,
The
Hari
Prabhu's case has not laid on any new law. It has reiterated the law laid on by the full bench judgment of the Apex Court.
Yes.
Kindly see, my lords, it is held that communication of the grounds of detention to the detainee in writing and in language which
No, that
he
is also UAPA.
No, that is
No,
preventive
that is
detention
one
law.
thing.
That is a preventive detention law. That
Correct. Then again, my lords,
detention law.
para 26, another Supreme Court decision also is being quoted.
That
Para
is
26. That is Lalu
grounds of detention.
Yes. Lord, the grounds of detention must be communicated to the detainee in writing in
That
a
is
language.
preventive detention.
Correct.
Also preventive detention.
Next, my lords, again it is
29.
no, in page 60, para 26, 27 also.
No, Hari Krishna.
Hare Krishna. Then, my lords, kindly see, my lords, the court came into conclusion that at para that is 30. Hence, we have no hesitation. Kindly see.
Yes.
In reiterating that requirement to communicate the grounds of arrest or grounds of detention in writing to a person arrested in connection with the offence or person placed under the preventive detention under Article 22 subclause 1 of the 22 subclause 5 of the Constitution of India is sacrosanct and cannot be breached under any situation. Non-compliance of the constitutional requirement would lead to custody or detention being rendered illegal as the case may be. Then, my lords, I have placed also Bombay High Court judgment. The similar, this is also an offence under the provisions of IPC. Kindly see,
Which Bombay High Court, sir? IPC the other.
IPC is the offence, page 97. Page 97, my lords. Here also the IPC is
And
also
also
an offence.
MPID.
Page number 98, para 3, my lords. Para 3, sorry. Page 98, para 3.
406, 420.
ಹೌದು. IPC offence. My lords, habeas corpus was filed, and this the Bombay High Court has quoted the decision of Prabiru ಮತ್ತೆ ಇದು
Pankaj Bansal. We'll see.
There is one issue, my lord. Your lordship may see the Mazar has been drawn at the time of arrest. He signs this Mazar. This Mazar has entire details about the
My lords,
crime and everything.
The arrest memo also is placed on record. My lords, investigation papers was supplied after the remand order. In addition to that, my lords, the remand application copy also is not been
Your
supplied.
lordship sees.
No, anyway, you're in custody, alva.
I am in custody.
His signature is now found in that Mazar, the arrested Mazar. The next page, man.
My lords, particulars of grounds of arrest also is narrated in that is Prabhi's case. That is, my
No,
lords,
that is-
find it at.
Anyway, that is under UAPA, whether it is
No, what are the grounds of arrest?
neutralized law, we'll see.
What is the grounds of arrest which is indicated at page 65, para 49?
We'll pass orders on 15th.
Great.
List on 15th, because this has ramifications.
Great.
But ಆದ್ರೂ grounds of arrest ಕೊಟ್ಬಿಟ್ರೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ಬಿಡುತ್ತೆ?
Alla, the
ಎಲ್ಲ offense ಅಲ್ಲಿ grounds of arrest ಕೊಟ್ರೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
word used are, my lord, that I understand.
That's all right. If you give grounds of arrest, what is going to happen?
In fact, one of these judgment, my lord, also speaks about the remand application. Remand application, we have discloses everything. What is required law under section 50, the requirement is that
You should know the grounds.
You should know why are we arresting him and where are we taking him, what is the bail. We have make him to make a phone call, allow him to make a phone call to his family, inform his family. That is what the grounds of arrest. That is what is down to.
My lords, Article 20, my ground is that, my lords, I am harping upon Article 22. It speaks about grounds of arrest.
Let's see.
The apex court interpreted it should be in writing, the
Let's-
knowledge which is known to the accused.
But that both this judgment, my lord, doesn't deal with section 15 particularly to
15th. Great. List on 15th in the fresh matters. Yes, food and
Interim bail.
that day will pass.
Great.
ಹೆಂಗೋ ನೀವು ಅಸ್ಟ್ರಾಲಜಿ ಅಲ್ಲೇ ಹೇಳಿ ಅಲ್ಲಿವರೆಗೆ.
Great.
And don't make anybody giddy by your astrology. Yes.
Number 7.
Sirajuddin. Jail food.
Yes, my lord.
Ah.
Well, there are around 16,000 prisoners, my lords,
16,000
in
prisoners.
the entire state, my lords.
Ah.
And 72% of prisoners are undertail, my lords. There is no bar in any provision of law that the undertail prisoners should not be allowed with the home food, my lords. And the food which is provided by the prison authorities is not sufficient and not nutritious, my lords.
Put this we had after.
SPP, no, I want you to bring in something to demonstrate that nutritious food is given to the prisoners also. What is the diet that you follow?
Dietary
there?
is in the correctional manual, my lord.
My lords, 218 rupees is charged for per prisoner, my lords.
Ah.
If we consider blindly 30 rupees or 10 rupees 10 ರೂಪಾಯಿ ಕೊಟ್ರೆ ಇದರಲ್ಲಿ ಇಂದಿರಾ ಕ್ಯಾಂಟೀನ್ ಒಳ್ಳೆ ಊಟ ಸಿಗುತ್ತೆ. Let the government may install Indira canteen there itself. 30 rupees, 150 rupees will be saved for the government itself, my lords.
No, one prisoner gets to
218 rupees they are charging, my lords,
who pays
per day.
this?
Two
Government
only.
pays.
Yes,
Balanced diet we provide them.
Balanced diet.
Yes, yes, of course. Well, my lord,
Could you, what is that
yes,
balance,
yes, yes.
imbalance?
My lord, I'll show you.
The food which they provide is not eatable, my lord. I have videos, my lords, for the court's kind perusal, my lord.
ಅದನ್ನೆಲ್ಲ ಆಮೇಲೆ ಒಂದು ಪೆನ್ ಡ್ರೈವ್ ಕೊಡಿ.
Yes, my lord.
Lord, each item is measured and given. You cannot make a broad statement like that.
The study report made by the Honorable Justice Veerappa also, my lords, is it's 2 volumes, my lords. It's regarding food and that cells and everything it has been mentioned, my lords. The food is not sufficient. So, my lords, my prayer is that, my lords, once in 15 days, and then the under trial prisoner may be allowed to have his homemade food, my lords. Even the prison manual also speaks about the food, my lords. Food can be obtained by the civil and under trial prisoners by outside, my lords.
No, SPP, you file an affidavit of a responsible officer of what is the food provided in the prison to these inmates,
Yes, I'll do.
and what is the diet that you have followed, whatever nutritious food, which is what is said under this.
Yes,
In a scale of diet for A and B class convicts idu under trial ge.
ಎಲ್ಲರಿಗೂ ಇದೆ.
Ah.
I will have an affidavit filed by the chief superintendent of.
See, class of diet, who would fix the class of diet?
Lord, as per the manual, they will have to supply.
Non-vegetarian diet in grams, vegetarian diet.
Let him have the affidavit of somebody saying that I have not been provided with the.
You also file affidavit, whatever you want to file.
I'll
get
file
them
videos also, my lords.
Huh?
The present food which they are providing, the ragi balls and the everything I will file in the pen drive, my lords.
ಎಲ್ಲ ಮಾಡಿ ಮಾಡ್ಬಿಟ್ಟು
But here, my lords, the prison manual speaks even the model prison manual for the in prisons of India speaks that food can be allowed, my lords.
Now that I will answer.
Yes,
That is what I will answer. But let's see what is being given to the prisoners, whether it is food that is palatable or unpalatable.
My lord, till 2020, their food was allowed, my lords. Now after 2020, after COVID-19, the food is stopped, my lords.
Outside food.
Outside food is stopped. Till then it was allowed, my lords. Now they are coming claiming that the prohibited items are entering inside the through food. It is not like that, my lords.
Lord, the basis on which the submission is made is not known. I don't know what is the basis.
All right. ಇಲ್ಲ,
Yes,
ಅದು-
Armand.
You don't be taken by surprise.
Yes.
So
Well, Lord,
file an affidavit of
Yes,
the-
so far as the guidelines is concerned, Lord, the proposal to amend the prison manual and prison act. So therefore, that could be deferred. By
which one?
Your lordship was.
ಯಾವ್ದು this
wanting to-
smoking zone?
ಅಲ್ಲಲ್ಲ, guidelines.
Guidelines ನೀವು ಮಾಡಿ.
ಇನ್ನೊಂದು correct and
Nah,
fact
why
ಇದೆ.
should I pass guideline? You
Yes.
should issue
No,
guidelines.
the other matter, your lordship said we will frame guidelines. So
Which
of
one?
course, if the other matter, corrected matter.
That premature release.
Food-
guidelines.
That definitely I will.
Yes, yes.
There you have been fumbling throughout. ಏನು ಇಲ್ದೇನೆ you ಇಡದೇ ಇಲ್ಲ committee ಮುಂದೆ. Committee, I said 6 times in a year the committee should sit. Is it sitting?
Even it is sitting, the result will come after 1 year. If 3 accused are placed before same case, 3 accused are placed before the committee, then 2 or 1 will be released and 2 will remain in the jail itself. I have records to show, my lord.
No, that's all right. On merits, 6 times in a year are you sitting, sir? Supreme Court directs. Are you sitting 6 times in a year? I said 6 times ಕಷ್ಟ ಆಗುತ್ತೆ, 4 times ಕೂತ್ಕೊಳ್ಳಿ. 4 times are ಕೂತಿದ್ದೀರಾ.
I will ascertain.
No.
And I'll place.
In fact,
Don't follow
Notification.
anything.
that Maharashtra guidelines which I.
Yes, Maharashtra guidelines ಕೊಟ್ಟಿದ್ದೀವಿ. Following that way, that I will pass.
Yes.
That definitely I will pass because courts have done so.
In
We
fact,
will do it.
this committees, my lord, have been told there is no uniformity with respect to application of a set off given for life conviction.
No,
all
that
other
I will
things.
go
There
through
are-
everything. Vacation ಅದೇ ಕೆಲಸ ಮಾಡಿ.
It's interim order to the effect.
Interim
At least
food ಹೆಂಗ್
from
ಕೊಡಕ್ಕೆ?
4 years, my lords, they are not
Wait,
provided
sir.
food, my lord.
Interim food.
No, my lord, for interim order till the next date
ಏನು?
of hearing,
ಏನು?
at least one time the food may be provided for the home.
Lay down everything. 4 ವರ್ಷದಿಂದ ಇಲ್ಲ ಈಗ ಸಡನ್ ಆಗಿ ಇಂಟ್ರಿ ಮಾಡಲ್ ಕೊಡಕ್ಕಾಗತ್ತಾ?
4 ವರ್ಷದಿಂದ ಊಟ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತಾನೆ ಹೇಳ್ತಾ ಇರೋದು, my lord.
ಊಟ
Because the
ಕೊಡ್ತಾ ಇಲ್ಲ
court
ಅಲ್ಲ, ಮನೆ ಊಟ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತ
ಹೌದು, ಮನೆ ಊಟ ಕೊಡ್ತಾರೆ.
ಹೌದಲ್ವಾ?
ಅವ್ರು ಕೂಡ ಊಟ ಸರಿ
By
ಇಲ್ಲ.
by way of an interim order, we
At
can't
least, my
tell
lords,
what is
to
there.
bring out the truth, amicus curiae maybe appointment, they will find out, my lords.
Wait, I'll do all that, not today. List this on 14th. List this on 14th and the other council is ಅವರಲ್ಲಿ ಪ್ರಭುಲಿಂಗ್ ನಾವದ್ಗಿ.
Yes, sir. Yes,
Let him also
because it
come.
was moved in the morning, so therefore it is not come up.
Yes, list on 14th, madam. List on 14th at 4 PM. By then,
Yes.
the learned SPP shall file an affidavit of a responsible officer of the jail with regard to the diet that is followed, the diet and the nutrition that is followed in the food that is given to the inmates of the prison, particularly under trials. as the under trials under the law are entitled to get their food, have a right to get their own food, which is now stopped, is the allegation. Yes, the counsel for the petitioners is also at liberty to file respective affidavits with regard to the nutrition or diet in the maintained in the food in the prison. Yes, list on 14th at
It
4.
we had on the
15th, 16th at 4 p.m. for further hearing. Further hearing is there. Yes. Okay, bro. Further hearing? Wait, Aditya. Yes, sir.
No, no. Lordship has spent a lot of time. Today I'll be very brief. So that
No, I have heard it completely.
only few points I have to learn, not take more than 10, 15 minutes. Of course.
You have filed your list of dates, yes, I've also served on it.
The detailed notes that I'd even given the last time
Yes, sir.
with page references.
Named coding.
No, this,
CAG audit has not happened after 2019?
they given the draft, this one. We have given that our replace, it is pending.
So the audit did happen in 24 also?
They have given up 19 to 24, they have given the full 5 years.
19 to 24.
Yeah. Further, we have.
Well, I
replaced.
have
Yes,
made a note of everything.
Yes, I just point out.
Wait, let me
Yes.
finish. Yes. Yes, sir.
The, in this case, the notification imputed is not at page. 18. Page.
The notification is by the state reducing the amount.
I am just coming to one point.
Yes.
That is not because of, my lord, earlier there was a notification in 21 at page 81. Then, my lord, the quantum was reduced, amount was reduced with retrospective effect. And by which time, my lord, the petitioners had already submitted their application. So, my lord, I'm not going to argue, my lord, the legitimate expectation and that I'm not, because it is all facts on record. That is the number one. Therefore, my lord, subsequent notification that is on 30/10/23, where it has become retrospective effect from 2023, has affected these petitioners and of course whoever has applied. Whereas the persons whoever has applied subsequent to that, they are not affected, they are not before this court. So we are now confined, my lord, only to the period of retrospective effect of the academic year 22-23. Only that, my lord. That's my own submission. Next point, my lord, there are two aspects of this case. Lordship was asking for clarification regarding, my lord, unnecessary expenditures. Have you incurred unnecessary expenditures? Number one. Number two, my lord, our, my lord, responsibility to my lord, justify your lordship that why we have to reduce the amount. That's two main aspects. In regard to, my lord, the
amount is reduced by the state, by the notification.
Amount is reduced, sir. Retrospective effect, the amount is reduced. Amount is there. In fact, it is not totally taken away. It is there, but it is reduced.
30,000 ಕಳಿಸಿದೆ. Education.
Yes. Now, my lord, kindly see. Synopsis. My lord, in regard to CAG report, we have given a detailed reply. CAG report, my lord, after holding discussions with the Computer General of Karnataka State, Auditor General of Karnataka State, and also Principal Secretary, my lord, we have given a detailed reply to CAG. It is pending. My lord, when the matter is pending in CAG, my lord, they have to a lot of discussion, lordship, no, this is take place, and the Honorable Supreme Court. I said, my lord, what is the effect of CAG report? My lord,
it's a report.
They cannot be, my lord, made a basis for any.
No, we are not passing any order on that.
Okay, then
I will only observe the report.
I will not, but please
Could
observe.
give me judgment, whatever you want to give, please.
That is my one. Then my last occasion, my lord, Lordship was pleased to inquire about, my lord, the Emanriga, Indira Canteen and all those things. But today I'm not finding that explanation. At page, Lordship may get at page 9.
ಇವತ್ತು ಕೊಟ್ಟಿದ್ರಲ್ಲ? Funding Manrega.
The board has never funded Emanriga scheme. However, the Emanriga workers carrying on building other construction workers raised in the act. During the critical phase of the lockdown, in view of the first wave of COVID-19.
After 2019, you have not done.
Not done. And when will kindly come to Indira Canteen. Indira Canteen also will not kindly go to para 31. The government is not asking us to pay about 35 crores to Indira Canteen, 70 crores. And initial payment of 35. We said only construction workers, if they are claiming, give us the details. So far, para 31, we have said 8 crores, 85 lakhs only we have paid.
To Indira Canteen.
To Indira Canteen. Towards the construction workers taking food in because of the COVID situation, because only construction was allowed.
Yes.
And also we are, that is one. Next, government order R3, my lord, I also. Then, my lord, Dr. may kindly go to page, my lord, 23.
23.
Regarding income tax.
Exemption.
Exemptions. And we have got exemption and mandatory spending for CH-17.
11 and 12 ಇಂದ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
And this amount has not been paid. It is a claim. Amount is not.
It has not gone from your coffer?
No, no, it's a claim.
Okay.
Then kindly come to page 24, Kionics. There was a Kionics also. Kionics also, that also we have stopped. For only 2 weeks, that also was stopped. Then laptops, the lordship was, please ask me the laptops. About 7,000 laptops were issued to children of the construction workers. Laptops. And then page 26, cars. Last please ask the all 22. All section 22.
15 cars from 2006 till date.
Kindly told to page 41. Last page. Kindly see 2006 to 2021, these 15 cars bought. First 3 cars are now scrapped. It's not the working condition, scrapped.
All right.
Next one, 7th. Now, after 21, no cars have been purchased.
All right.
That is therefore, the finance, as long as the allegation regarding financial irregularities are using for unnecessary. And important point is this. Kindly go to page A5 of the same.
A5.
Page 5.
5.
Page 5.
Administrative expenditure.
Kindly see 19 onwards we have given. The percentage kindly be similar. Percentage.
Have you seen all this? No.
No. It's all there already, the original.
Already there.
Already there, not
All right.
nothing. I only culled out for lordship's immediate convenience.
All right. Yes.
Then we have never exceeded 5% as per the schedule, except in 1 year, marginally we have increased, that's all.
So
Trust.
your submission is you've never gone beyond 5%.
Not gone, except 1 year, that's also marginally we have gone above 5%, that's all. That we have given all. And whereas they are given page 72 of their estate last year, it's a lot of inadmissible expenses.
Lot of?
Lot of inadmissible expenses.
Inadmissible.
We have answered all those things, they all within the, and whatever we have spent under section 22, the schemes. That is one aspect of it. Now coming to the justification in the sense, I will only place the facts for lordship, then leave it to your lordship. Because lordship was keen that is in education, we should not be very strict on it. Well, kindly come to my lord, page number. 22, page number 19.
In this?
In this, today's, all in today's.
22.
Page 19.
Page 19. Yes, sir.
That is details of expenditure and.
ಇದು ಮುಂಚೆನೆ ಕೊಟ್ಟಿದ್ರಲ್ಲ, I have seen.
Only one point.
Compilation.
Compilation, kindly see page 20. Estimate comes to about 2 crores.
2,303 crores.
Crores expenditure. Now, please come to
23, 24.
No, 23 also I have said done. Before that, one more. Thing. Receipts and Malad, kindly come to Malad, page 15.
Page?
15.
Ah.
15.
Yes.
Malad, there I have given Malad receipts, that is cess collection, column number.
As on 2024.
Full it is there.
ಎಷ್ಟು ಬಂದಿದೆ?
Malad, kindly see cess collection is column 2.
Yes.
Interest also I have said. Both I have
Interest.
given. Now kindly see Malad the from cess, the cess collection is Malad, I will go from 1920 Malad.
Yes.
For
Correct.
911 crores cess collection. Then interest is 560.
Yes.
Like that, Malad, kindly come to 22 and 23.
Yes.
I have said. So Malad, kindly see.
Now till today, you have 15,599
No, no,
crores.
no.
Then
We have only about 6,900, 600 and 603.
600?
Yeah? Because we have spent, these are all collection, spent.
No, no, no. I thought spent where?
Huh? After spending for all the schemes, I have Malad at page, you also we get 6,600. No, wait. No. I'll give that cutout, what is pending and what is in, that is kept in FD. My humble submission in this. Kindly see the total matter every year. 1,559, then 815, including interest. Page 15, my lord, I'm saying. Then 1,725, 1,205, other. Whereas, my lord, I was referring to your lordship, page 19 and 20. 920, it is 2,303 at the rate of 400 crores for education. Without education itself, I have given my lord, page 4, my lord. Page 4. Para 12.
Yes.
Actual expenditure for scheme other than education, 1,067, 1,800, 1,903, 983. Whereas my Malad income cess plus interest comes to Malad only 1,000 and odd. Therefore, Malad, if I add education 400, is come to 2,300, 400 itself. Now, Malad, the issue is now, I was expecting Malad around 3 lakhs, 4 lakhs applications. Therefore, my budget was 400 crores. Whereas it crossed to 11 lakhs and eligible was going to be 9 lakhs. There also, Malad, I want to make one submission, important submission is there. During discussion, Malad, I holding, Malad, I could make out a very important issue. In one of the nursing college in Yadgir, all the students are complaining. I have availed this benefit. Applied for telling
No,
that
misuse, definitely it will be misused, no doubt about it. That's where you should plug in and give some real meaning to what is.
That's why not probably not now we want to scrutinize even whatever pending is there, we'll scrutinize and will not give it. That is one issue. Now when coming to the real fact of the issue, when 400 itself when 2003, when if I give the difference comes to about for 9 lakhs people, it is 1,400 crores.
What is the method of identification? What is the method for you to identify construction worker's child getting education?
But I have to find out that too.
ಏನ್ ಮಾಡ್ತೀರಾ? ಹೆಂಗ್ ಮಾಡ್ತೀರಾ? ಏನ್ ಐಡೆಂಟಿಟಿ ಕಾರ್ಡ್ ತಗೊಂತಾ ಇದ್ದೀರಾ? ಏನ್ ತಗೊಂತಾ ಇದ್ದೀರಾ? ಅಫಿಡವಿಟ್ ತಗೊಂತೀರಾ? How do you call for applications or randomly give? ಹೆಂಗೆ?
once interest beneficiary, beneficiaries children are coming under this.
True. How do you determine someone to be a construction child's worker? Illa everybody will misuse the benefit.
My lord, I believe more than 50%.
All right, misuse ಆಗಿರುತ್ತೆ, but misuse plug in ಮಾಡೋದು ಹೇಗೆ? The benefit should go to the
SATS ID in the no audience. SATS ID in
ID ಅಂತ ಬರುತ್ತಂತೆ ಅದು ಎಜುಕೇಶನ್ ಇವ್ರು ಕೊಡ್ತಾರೆ ಬೇಸ್ಡ್ ಆನ್ ದಟ್ ಆಧಾರ್ ಕಾರ್ಡ್ ಇವಾಗ ರೀಸೆಂಟ್ ಆಧಾರ್ ಕಾರ್ಡ್ ಮೇಲೆ ದೇ ಆರ್ ಫೈಂಡಿಂಗ್
there is a SATS ID in the database, not there it is linked to Aadhaar. And then we find out whether they are eligible or not.
No,
And
something that cannot be tampered with, you should come out. Illandre this is going to go get misused.
In fact, we wonder not from 4 lakhs to 9 lakhs. Lordship can make out.
No, true. I'm not saying, see, I'm only scrutinizing these things so that there is some streamline done and it goes to the appropriate persons. The court should do it or the state should do it. It should not go to people who are misusing these funds.
academically practice.
They have to register themselves. And while allotting to the students, my instructions are, my lords, they'll verify their ration cards and Aadhaar cards and see whether these are the children of these construction workers.
Who
are
verifies?
registered. The board. The board will have to verify. They are the ones who will scrutinize.
You
it.
should,
And they will also verify with the.
you should tighten the way of verification.
Education.
Or if there is any, dereliction of duty or misconduct, you should bring in
The
something.
Aadhaar has become an eye opener now.
Whatever, that's what.
100%.
No, that's what, see, it's a cause that is needed now.
Now,
That's precisely, I should thank him for denying 30,000. So that something can be streamlined. Yes,
I'm
now.
here fortunate that you hear your lordship so that we can get good like guidelines.
No, that is why, let me also do. This will tighten, streamline something in this. Yes, I'll just hear him. Yes, you have
Very
anything to
pointed,
say?
my lord.
One issue, only last. Therefore, my lord, the issue involved as it started earlier, my lord, that 1 year, 2023, now our budget is 400 crores. The actual, my lord, also for the 9,000 application comes to about 1,400 crores. So, my lord, at stake is, my lord, 1,000 crores. That is
No, no. That's why I asked you, the interest that you get is around 710 crores.
400. No, 400.
Interest just for
400. Not 1,000.
Alla, 8,700 crores is in FD.
6,700.
6,700 crores in
For
FD.
that, my lord,
And that interest you get is,
400 crores, but I have submitted that also, that figures also.
all right, interest 400 crores. And you service the other things by the funds that you get.
My lord, if I service the other, no, I say, my lord, the servicing itself, the 2,000 crores I need other than
No,
education.
true. No. The most important thing is these children getting education. Most important thing is that.
No, education, that's why, my lord, we have reduced the amount, not denied them. Only for 1 year,
Reduction of the, ಆಮೇಲೆ ಈಗ ವಾಪಸ್ ಮಾಡಿದ್ದೀರಾ? ಇಲ್ವಲ್ಲ?
only for one.
ಆಯ್ತು, ಈಗ ವಾಪಸ್ 30,000 ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲ.
ಇಬ್ರು ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು. ಅದು
ಅವ್ರಿಗೆ ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದೀರಾ?
all others we have
That's
given.
because of the order of the court.
And my lord,
We'll see.
my lord,
We'll try to.
and one more thing is, they can get assistance from these children also, not only from this board. There are other government schemes also there.
No, the other government schemes is a different thing. This fund is meant for those children. This fund shall be utilized only for that purpose. That is all I'm going to say.
But that's all. Ultimately, it boils down to, my lord, and narrows down to 1,000 crores for the particular year.
No. The figures, how you deal with it is your lookout. I will say what has happened in this case about the notification and what is to be done. That's all.
And restricted to that particular year.
No. Restricted to particular year. Allah.
Subsequently, we are revised and
Government's notification is under challenge. I will answer the challenge.
because retrospective effectively, they have challenged. Because retrospectively, they are losing their money.
No, losing or whatever. Reduction itself is under challenge.
Reduction is challenge.
Reduction itself is under challenge.
Well, if lordship made to hold.
ನೀವು ಬೇರೆ ಏನ್ ಮಾಡ್ತೀರಾ ಮಾಡಿ. Yes, somebody needy, medicine, all that is needed. Education is the most important thing. If a poor man's child is educated and the child comes to a particular level, it is a blessing to the nation.
And up to 10th standard, I am told, most of the schools are free education. You're only concerned about the
ಇದು
higher
10th
education.
ಅಲ್ಲ, after the 10th.
After
The
the-
amount is given after the 10th.
From first.
Under
time.
the RT, what is there? They are not asking that. The students here are law and MBA.
But
If a
my-
construction worker's child has gone to the extent of law or MBA, you
You're
not resisting the claim.
My humble, kindly restrict it to 1 year, otherwise, my lord, it will have a great
We'll see. Yes.
consequences.
Ah.
Be very brief, my lord. My lord, I would with great respect submit that the figures that they have given are in fact of two natures. One are answers that the CAG also received and the CAG didn't accept. And the second, my lord, is a non-compliance with the statute itself. The reason is this, my lord. It appears that the issue of lack of funds that is being cited is in the nature of saying that the state government has a budget, but the budget is not being allocated. We would reframe the issue as saying that there are statutory duties which the statute says must be done in a particular way, and that is not being done. I will only point out one thing, my lord. My lords, in fact, hit the nail on the head when my lords asked, how are these candidates being identified? This was an issue before the Honorable Apex Court also, and an order was passed saying that unique identification numbers must be granted.
Yes, that is what,
Not been
that
done.
was what was running in my mind.
Yes, it has not been, it's a specific direction. And now what the CAG has observed is, as a result, I'll just give examples without showing the number. There have been instances where money was without approval released for COVID. One instance the CAG has pointed out where one particular person has been administered treatment 27 times. To say that these are the reasons, there is no record as to how the money is leaking. But there is a more structural issue, my lord, because the statute contemplates a very strict filtration method. The statute contemplates the board, which is the ultimate authority. It is a body corporate, forever in existence. Along with the two boards, Section 4 contemplates an advisory committee. This advisory committee will inform the state government as to what steps are to be taken after ascertaining the factual scenario. But in addition to this, a very important committee that has been excluded is the expert committee. Expert committee has been provided under Section 5, and this has a direct relationship with the rule-making power. So all that my lords see now, including the rules under challenge, essentially is under Section 62 of the Act. And Section 62 of the Act, and the Supreme Court observes this, saying that without consultation with the expert committee, this is a non-starter. It's as a result of non-availability of an expert committee, non-availability of data.
The expert committee is not constituted.
Not there. And in fact, I will point it out.
When?
2024.
2014.
Huh?
2014 itself.
My lords, may please have, because I'll point out from this, their reply to the CAG. The CAG points this out, saying that where is your expert committee? This is on page number 95 of their memo. 85, my apologies. On page 85, the CAG notices two things.
Yes.
The
85.
first, please, my lord, memo, this is the memo filed by the respondent number 2, 19th August.
Page 85, right?
Please, my lords, may come straight to page 85. I'm just citing this as one example
Yes.
of statutory non-compliance. The column on the left is the CAG's observation.
Page 85 of what?
Please, my lord. Memo dated
85.
28th August 2024.
28th August?
2024, filed by respondent number 2.
Yeah. Mhm. 28th August, there is nothing.
May I pass on or
Give it.
is there?
Yes.
In the submissions I've given all the page references, my lord. I'm just citing this as an example. My lords may see the CAG's observation.
Yes.
The CAG notes, expert committee meeting not conducted regularly. Section 5 of the Act empowers the government to establish one or more expert committees comprising individuals specialized so-and-so as per the Supreme Court's order to make rules under Section 62.
All right.
Please see the next paragraph. The government of Karnataka constituted an expert committee in March 2024, comprising 12 members from various fields. However, the notification failed to specify the tenure and the minimum number of meetings to be held. And then the CAG notes, previously, it was observed that the committee convened only 3 times, twice in 2019 and once in 2022. My lord, this begs the question, who took these decisions? When there was no expert committee, the expert committee is not meeting, what data was considered, and how was section 62 set in motion if this expert committee was not consulted? And please see the government's reply, even to this draft reply. The respondent says, steps are being taken to nominate the member of the expert committee. Regular meeting will be conducted after constitution of the committee. So admittedly, my lord, the impugned notification is a product of non-application of mind. As my lords will recall, Annexure R1 to their objections was that today there is no board also. But we are anyway making this proposal. Please give it post facto approval after the board is constituted. So at the root of the
Here, section 62, my lord, it is for framing of rules.
and the rule is framed under Rule 45.
Whether such a statutory provision has to be followed while passing such an order.
Absolutely. The Supreme Court says, I'll show it, my lord. My learned friend raises a very important point. I will show section 62 to bring.
Government after consultation with the expert committee by notification make rules for carrying out this provision. If at all we are making any new rules as such, at that point of time, expert committees, expert advice would be required. But my lords would kindly see now, not a single argument has been placed before my lords, the very reason for which the notification is passed. We have explained in the order, it's a speaking order which says that from 4 lakhs of applications, the applications raised
11 lakhs.
That is,
and we have explained for every, if my lord sees our statement of objection, I'm sorry, no rejoinder is also filed for our statement. It's a very 5-page statement, my lord. We explain under section 22. Of course, education is important and we are giving it as a state. But my lords, there are various benefits under section 22. It is not just education. If my lord sees, it is assistance for accident, pensionary benefits, loan for construction.
No,
housing,
true.
group
You have
insurance.
all that, yes.
2 people coming before my lords cannot jeopardize the entire.
No. Don't think the court will pass some order which would take away the.
11 children are to be accommodated. If 30,000 was reduced, there is a reasoning given. That reason is not disputed.
I will with the greatest respect submit, my lord, with some references that we challenge that reasoning also for very specific reasons. First, my lords will note, as my learned friend rightly points out, I also appreciate the non-adversarial nature of these proceedings. Section 62 grants power to make rules where the benefit needs to be granted. Under Rule 45, which is the rule framed, figures have been mentioned as to for what educational level, how much money has to be given. What the board does is that over time, they revise that rule. So every time the figure is actually being amended, in essence, Rule 45 is being amended. That is why, unless an expert committee is constituted, the basis on which that amount is being revised is without application of mind. I have with me, for instance, I'm just stating this, my lord, Goa, Maharashtra, Punjab,
Have all expert committee.
and I've brought the rules with me, and they in their preamble say, we have consulted the expert committee and based on which we are making these rules. So I would most respectfully submit that as my learned senior submitted, every time a notification is brought, it is in essence an amendment to Rule 45. So without the expert committee, amendment to Rule 45 is a non-starter. It is irregular, will be hit by lot, which my lords have many times observed by the Nazir Ahmed principle. The statute mandates how it needs to be done. The second aspect.
Under which they are claiming 30,000. No expert committee was consulted for even raising that.
No expert.
Equally a problem. Yes.
The benefit given or benefit taken away is not on the basis of expert committee at all.
And that is in fact a very important point. Even every time a notification is made, let's take the instance, even the 2021
Madam,
notification.
who will question if you give them benefit? When you take it away, tane ella baradu.
Absolutely. Because now genuinely.
When benefit is given, how you give it, they are not bothered. So when you take it away, then comes everything. How did you take it away?
My lord, one very important point remains, which is a case that is being presented today is one of rival claims, which is that I have X number of benefits to give. On this, there's a specific notification, which my lords will see at Annexure AG, which is in volume 2, because this problem has come up in the past, where governments have been saying at page number 358,
Volume 2.
Annexure 2, volume 2, Annexure AG. This is a notification of the Ministry of Labor,
Page?
page 358. I'll just give the backdrop of this. Many state governments had raised this issue saying that, look, we have so many different schemes to handle. And the ministry, before I'll summarize it and then read it. Section 22 has a list of A to H schemes. A to G are specific. It says education, pensionary benefits, accidental care, maternity benefits. H is a residuary clause, which means it could be anything else for which money is left after providing for A to G. What some states did is that they brought a varied kind of schemes where in some cases third parties were getting benefits by way of contracts and passed it off as schemes under H. Just by way of a notation, of the 20 odd schemes that the respondent had here has cited, saying that, look, all of these schemes we have to be provided for, 14 of them are residuary schemes, which means half the schemes are not A to G, they are H, to which this notification would apply. My lords may please see para 2.
358.
Please, my lord. This is a notification of 25th of March 2021.
Yes.
I'll read para 2. Para 1 is a preamble. It has come to the notice of the Ministry of Labour Employment that some state welfare boards were issuing tenders and incurring expenditure on distribution of household items like lanterns, blankets, umbrellas, toolkits, utensils, cycles, similar other articles instead of tangible welfare measures such as life insurance, health insurance, disability, maternity benefits, old age pension for the workers. Since procurement's process adds layers to the entire process, with the apprehension of leakages both at the procurement stage and at the distribution end, hence this decision was prompted. I'll just pause here. Supreme Court also says, for example, laptops, saying that the board has no business giving laptops. I'll read on, my lord. My lords may please come to the para after the next, which starts with section 22. Section 22(1) of the Act comprehensively stipulates the functions of the state welfare boards. Subsections A to G mandate that the state welfare boards to spend the cess fund on payment of premium or pension, group insurance scheme, scholarships to workers, children, medical expenses, maternity benefits, loans for house construction, etc. An exception, subsection H, allows the boards to spend on such other welfare measures and facilities as may be prescribed. It was observed that some state welfare boards had taken recourse to this subsection of the Act and resorted to arbitrary use of cess funds for construction of building and distribution of articles and utensils instead of using it for welfare of construction workers. The order emphasizes that the social security coverage stipulated under 22(1) to G will hold precedence over any other benefit being provided to the registered construction workers under section 22(1)(h) of the Act. After meeting these priority expenses as mentioned in 22(1) to G of the Act, any balance cess fund can be utilized by the boards for giving additional benefits as per the mandate given under section 22(1)(h) of the Act. To keep a vigilant eye on the nature of expenditure, the ministry has asked the state boards to furnish annual return on the details of items on which expenditure has been incurred under section 22(1) to G and section 22(1)(h) separately. Therefore, my lord, it is no reason to say that I have so many other schemes and therefore I cannot give education. And this gets confirmed by the document they have filed today. I will only give one example. My lords may take the document that has been filed today, and very helpfully, the learned senior has rightly pointed to para 12. Para 12, my lord, is, and I read with permission, the below statement shows the actual expenditure for schemes other than educational assistance in the last 4 years. Now, please, my lord, may just do a cursory comparison. I will take the year 2022-23, for example, because that's the numbers they have been going by. 1,903 crores have been spent in schemes that have nothing to do with education.
Yes.
Now, my lords may compare this with the analysis made in the assessment report of the government of Karnataka granted, which my lords will find at Annexure AK.
Page?
I will, 445, volume 3, my lord. This is only to drive home the point, my lord, on the unsustainability of the argument that there are rival claims.
443.
434, my lord. My lords may straight go to 445 rather. 445, my lord, is a table. This shows in the order of things, which head has the most number of claimants. My lords will see education is in the fourth column, 90.67%. So 90.67% of all claims to the
Yes.
fund is for education. Now juxtapose those numbers, my lord, with what we see here. That a claim is being made that a mere 400 crore is being registered, budgeted for education. But for all other schemes, while there is a directive saying, please don't spend on anything else which is not A to G, 1,900 crores have already been spent. And this, my lord, contrasted with the fact that the second most claim is for marriage, for which in the last year they have spent more than education, which is a residuary clause. It is an H expense. So the question that arises then is that in the discharge of duties under section 22, 1 to G, is it a defense for the state to claim that we don't have money for this because we have put all our money into H? The next issue, my lord, is of accumulated funds under FDs. Shelter has been taken under an order of the Honorable Supreme Court. This is the same order that I showed the last time. I'll just read it because the Supreme Court didn't say this as a direction. Supreme Court said this as a matter of concern, saying that, look, there is so much money that is lying idle, accumulated over these years. I will just point out one thing, my lord. It's the sad fate of this statute, that this statute is today in its third decade. The first decade, quite literally, my lord, went in ignominy. No one knew the statute existed.
Yes, yes.
2007, thanks to the Supreme Court's order, first steps were taken, and 2007 to 17 went in the Supreme Court trying through continuing mandamus implement some schemes. And the last decade, my lord, states across the country have been trying to justify their inaction. Now, my lords will see in this context, the Supreme Court said, and this is what they're taking shelter under, the funds available.
The last paragraph.
Last paragraph, the point was this, that if any money, funds available with the welfare board shall not be utilized by the state for any other head of expense, but the operative portion is the funds available with the board which have not been disbursed or not likely to be disbursed. So
should be invested in nationalized bank.
yes, but the operative portion, my lord, that I would stress on is not likely to be disbursed. In other words, not likely to be used at all, excessive, should not lie idle in a savings bank account and therefore should go to an FD. Now, my lord, see their affidavit on the FDs. 25th of June, 2024. And the dates become relevant. I'll go straight to the table at page 5, para 11.
Affidavit, which affidavit?
This is their affidavit dated 25th June, my lord. This has been filed by respondent number 2. Lord, I have an unmarked copy. I can use the soft copy.
Yes.
Now, my lords may see how the FDs have then turned out. This is at page number 5, para 11.
Yes.
My lords may please just see the dates and the amounts. Date of deposit from serial number 1 till serial number 9 are all before the impugned notification. Which means before the impugned notification,
where was the money?
It was lying unutilized, moving from one FD to another on a rollover basis. But I'm coming back not to an issue of how they choose to spend the money, but to non-application of mind. 31st of October, the notification comes in. 13th of October, a proposal is made saying, please grant it post facto approval. But as on the 15th of September, 2023, 15 days before a decision is taken, they decide to park 5,900 crores in FDs. This, my lord, cannot be in line with the Supreme Court's direction, which says only if it is not likely to be used. The step that the board ought to have taken, if it was in existence, it is another issue that it was not even in existence when the matter was decided, that it should have said, we will summon these funds, apply mind, refer it to an expert committee, get a report on how funds can be allocated.
Let's see. Yes.
Therefore, my lord, the last issue, therefore, it all comes down to, as the learned senior rightly pointed out, retrospective application, legitimate expectation, And I would press into service the Honorable Supreme Court's judgment,
No,
which is
not
that
legitimate expectation, mandate of the statute.
mandate of the statute foremost.
Legitimate expectation is where statute does not impose any condition.
And that's probably my weakest argument, but the statute has not been followed. And this, my lord, is the case we bring to the court. And the only request would be, I think out of our, I would say it as an innocent lapse, we had said that the entire notification must be quashed and let there be a direction that the previous notification of 2021 be enforced. The previous notification had one clause that said that for students who get into IIM or AIMS, one of the elite institutions, their full fees will be given. As a result of the prayer reading that please set it aside and let there be equality, we missed that there was a separate treatment for
We'll
this.
see.
I will not
We'll
press
answer
that.
the many issues that are to be answered.
Please,
we'll do it.
We have most deeply obliged.
Yes. Ashte, sir.
My lord, I will
Clarification.
I will only place a memo. I have already served them advance copy.
All
This
right.
has the
What is
paras
that?
marked, memos of citations, my lord. Some judgments we've relied on.
Paragraph Saman.
All are marked out.
In today's memo,
Yes, sir.
I have also enclosed a model welfare scheme framed by central government in
Yeah.
furtherance to Honorable Supreme Court order.
That's
I'll reserve it. If there is any clarification, I'll post it before the hearing.
Please, my lord.
Post vacation.
My only, that's another issue since my learned senior didn't bring it up. The model welfare scheme also came up saying this should be the minimum. But some of the fees in this notification are lesser than even that minimum.
Yes, you have given all the
Yes,
list of
everything.
dates, synopsis, everything.
The submissions and the supplementary submissions have all the page references.
All right. Yes, heard reserved.
If there's anything else,
If there is any clarification, I'll post it before the hearing.
please,
Otherwise, we'll see. Statute is here.
please. And the rules also, I will supply a copy.
Rules copy no put.
My only last submission is this. We are only recorded the 1 year. Subsequent year notice is there. If that is made applicable to perpetually, then we'll go bankrupt.
We'll see.
My lord,
It is there, reporting.
my lord, on that, my lords will only consider one aspect, that some of these courses are 3 years, some of them are 5 years.
Kerala board appears, they're not paying pension also, my lord. No money with them. Kerala.
Yaar chairman.
Kerala.
Kerala.
Pension kodtala. No money for construction workers.
We'll see.
Lord, I'm also supplying a copy of the rules.
Give. Rules kodi.
Rule 45 would be relevant.
Rules. Rule 45, Allah.
Please, my lord. And in fact, the impugn notification also says in exercise of section 62 powers, read with rule 45, we are
Assistance for the education.
education.
Allah.
Please, my lord.
Rule 45.
Rule 40.
Yes.
So deeply obliged.
Yes. Heard so and so hackput. Heard Allah hackput. Reserved. Now those two girls are pursuing their education. Yes.
The legitimate expectation comes in here because they will go to the next year and then
No,
they are,
but their fees is paid now.
yes,
All right.
it's so deeply obliged.
Sure, madam. Great.
Matters 34.
Idara after vacation na? ಏನು offense?
504, 506 and 3.
504, 506. ಆಯ್ತು ಕೊಡಿ ಎಲ್ಲಿದೆ ಸೆಟಲ್ಮೆಂಟ್?
Filing the joint affidavit, my lord.
ಕೊಡಿ. ಆಲ್ ರೈಟ್, ಇಲ್ಲಿ ಹೇಳಿದಿರಲ್ಲ ಎಲ್ಲ. Whatever condition. Closed cost. ಅವರು ಹೆಸರು ತಗೊಂಡ್ಬಿಡಿ.
Please.
ಯಾವ್ದ್ರಲ್ಲಿ?
After
ಅದು ಯಾವ್ದು ಮೇಡಮ್ ನೋಡ್ಕೊಡಿ.
35, my lord. Serial number 35.
ಯಾವ್ದು ಮೇಡಮ್ ಅದು? ನೆಕ್ಸ್ಟ್. ಸರಿ. ಅಷ್ಟೇನಾ? ಬೇರೇನಿಲ್ವಾ? ನಮ್ದೆಲ್ಲ ಅಯ್ಯೋ ಎಲ್ಲ ಇಲ್ಲ, ಈಗ ಯಾರು ಸೆಟ್ಲ್ ಆಗಿದೆ ಕ್ವೇ ದೋಸ್ ಪಾರ್ಟೀಸ್ ಯಾರಿದ್ದಾರೆ ಅವ್ರು. ಈಗ ಸೆಟ್ಲ್ ಮಾಡಿರ್ತೀನಿ, ಅದೇನಾದ್ರು ತೊಂದರೆ ಆದ್ರೆ ಆಮೇಲೆ ಹೇಳಿ. ನಮ್ಮ ಕಲಿಯೋದಲ್ಲ.
ಇಂಟ್ರೀಮ್ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿರ್ಲಿಲ್ಲ. ಇಂಟ್ರೀಮ್ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿರ್ಲಿಲ್ಲ. 12460